Let's go.
I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I am Phil Mendelson. I am the chair of the Committee of the Whole as well as the chair of the council. Today is Thursday, February 23rd, 2023. The time is 9:59 in the morning. This hearing is a performance oversight hearing of three agencies in this order: the Office of Zoning, the Office of Planning, and then the Department of Buildings. This hearing is being conducted virtually. That is, all of the witnesses will be participating virtually. This hearing is available to the public live via the Zoom video conference broadcast platform. Live, I believe, on the chairman's website, www.chairmanmendelson.com/live. At www.chairmanmendelson.com/live. It's also being broadcast live on cable TV channel 13. And it is available on the council's website, which is www.dccouncil.gov. This is the second of 6 hearings that the Committee of the Whole is having on oversight. Monday will be we will have a hearing in the afternoon on the Office of Budget Planning of the other post-employment benefits program, University of the District of Columbia, and the Commission on Arts and Humanities. Possible. Oh, and the Retirement Board, a recessed hearing from yesterday, 1 o'clock on the 27th. And I believe it's still timely for folks to register to testify before the close of business today. Wednesday, the 1st, the Committee of the Whole will have a hearing on education agencies, and that's public witnesses only. Folks have until close of business on Monday to register for that. Education agencies include DCPS, Office of State Superintendent of Education, the Deputy Mayor for Education, the Public Charter School Board, and the State Board of Education. On Friday the 3rd, we will have our final performance oversight hearing, which would be the agency directors for those education agencies I just mentioned. Again, today is the Office of Zoning, followed by the Office of Planning, followed by the Department of Buildings. We have a lot of public witnesses. I should apologize that you've been waiting. And so I apologize. We will begin with the Office of Zoning, and what we will do is I'm about to call each of the 5 members of the public who asked to testify, and following their testimony and questions, if any, we will turn to the Director of the Office of Zoning. Anthony Dale, who's an ANC Commissioner, 5C01. Valerie Jablo. Noruzi, who's the Executive Director of Empower DC. Nancy McWood, who listed herself as a member of Ward 3 Housing Justice. And Deborah Akel, whom I met the other day on U Street, touring the area around 17th and U. They could all be let in. I am told that there are only 2 who were in the waiting room who've been let in, but if anybody else is here, please do your best to try to let us know that you are waiting to be let in as a witness. So I'm told that Commissioner Dale is not here. Valerie Jablo, are you here?
Yes, I am.
Why don't you proceed? Thank you for waiting. And please begin. And I expect I'm going to see you at least once next week. Education.
Thank you. This is education related. I am Valerie Jablo, and as a DC resident, I am here to outline how the Office of Zoning, Office of Planning, and Zoning Commission together act on flawed, self-interested, and publicly exclusionary data and decisions. Last year, Ward 8 residents harmed by a charter school development petitioned the Zoning Commission to have DC charter schools, all of which are private, nonprofit businesses, declared private for the purpose of land use and development, thus ensuring better public oversight and voice through the BZA process. The Office of Planning created a report on the petition for the Office of Zoning based on statements solicited from self-interested public and private actors, including the Federal City Council and Charter Board. The Office of Zoning Planning report is factually wrong in many areas. In my written testimony, I've outlined more than a dozen serious errors in those documents. Importantly, the Office of Planning report determined that democratically controlled processes ensure public voice in DC charter land use and development. I want to ensure the record is clear on this. DC charters exist whenever, however, and wherever, entirely as a private matter decided by their private boards and approved by unelected and publicly unaccountable DC charter board members. The only public process in DC charter school land use and development is public notification that the schools are hoping to start, expand, or locate somewhere. The public literally only has the ability to comment on that, not to direct, reject, petition, or choose it. Like other DC residents harmed by charter development, the petitioners in this case know that bait and switch well. Almost an entire charter school building was built in their midst without appropriate permits, causing damage to adjacent properties. They neither wanted it nor the problems it brought, but had no choice. Public oversight through BZA would have provided them some protection. Any change in zoning for charters would affect charters only as they wish to expand or locate, and neither is specified or required by DC government. There is literally no government agency or process directing DC charter school land use and development, unlike that for DCPS, though both are considered matter of right. In short, DC charter school land use and development is not a public process whatsoever. It is a private process with limited public notification, like development of private schools here, which are subject to BZA. But DC zoning commissioners never heard any of this, despite my writing to the zoning office about it. Instead, the zoning commission voted against the petitioners on the basis of flawed Office of Planning documents. That's because zoning commissioners have no obligation to hear anything from the public before deciding on a case, even when their decision relies on biased and inaccurate material, as it did here. The only time the commission hears public testimony is if they accept a case. There is no justice in the quasi-judicial zoning commission operating in such an ill-informed manner, especially as appropriate DC land use and development is the responsibility of the zoning commission, not that of private nonprofit businesses. I urge you now to change how the zoning commission works and ensure its responsiveness to the public it supposedly serves. Thank you.
Thank you, Ms. Chavlo. I believe that Ms. Naruzzi is not here. Ms. McWood is not here. Deborah Akel.
I am here.
Good morning.
Good morning. Would you like me to proceed?
Yes.
Okay. One moment while I want to speak today about letters from the public, how the Office of Zoning judges their authenticity and the weight it assigns to them. My remarks focus on Zoning Commission case number 2302, the upzoning of public land at 17th and U to 11 stories. On the OZ's exhibit page for this project, there are 12 letters of support so far. One is mismarked as being in support when it's actually in opposition. 3 have no physical addresses. 1 has no last name or physical address, and not one with an address is from someone who lives within a block of the project site. I would argue that these letters are not from residents who will be personally affected by the Zoning Commission's decision. They are from followers of Gigi Wash, who launched a mass letter writing campaign on the 17th. Every letter is dated after that. Followers of Gigi Wash are indiscriminately pro-development with no consideration for history or place and no respect for longtime residents or their concerns. Anyone who disagrees with them is called a crank or a NIMBY. The truth is, many older citizens protest projects because a project doesn't guarantee enough affordable housing or public uses, or because they've seen too many bad land deals, or because they want to keep public land publicly owned for future generations. So I'm asking that the Office of Zoning put these letters in their proper context and give extra weight to comments from neighbors who live in a close proximity to the site, some of whom, as myself, risk displacement. I'm also asking the views of immediate neighbors be given as great or greater weight than recommendations from ANCs for 2 reasons. First, many commissioners seem to have lost sight of their oath to represent their constituents and are instead voting based on their own personal opinions. And those should not merit greater weight than the views of residents who will be the most impacted by a zoning decision, especially one of this magnitude. And second, in the case of 17th and U, the ANC's deliberations are happening in a vacuum. There was a public meeting on this project, but neither DEMPED nor the Office of Planning released a report. If ANCs are the voice of the neighborhood, then shouldn't their recommendations take into account what their constituents said at that meeting? I ask you to consider these requests, not just for 17th and U, but for all projects, especially those involving public land. Thank you for your time.
Thank you. I don't have a copy of your statement. Can you provide that?
Yes.
And I'm hopeful that Ms. Barden has been listening, because I'd like her to respond to the issues that you raise. Ms. Chablo, can you say a little bit more about this case? As you were testifying, I could not recall. Why did it go to the Zoning Commission or the BZA?
So the residents in Ward 8 petitioned the Office of Zoning to have the designation of charter schools declared private for the purpose of zoning. And the Office of Zoning then sent the petition to the Office of Planning for a report.
There was not actually a development proposal before the Zoning Commission or the Board of Zoning Adjustment. It was a petition asking that a project like that be considered a public project.
It was seeking to change the designation in the DC code of what a charter school is for the purpose of development, so that it would be subject to the BZA process, the same as private schools are currently in the District of Columbia. The difference being that there is a public oversight process for DCPS for matter of right development, but there is no similar public process for DC charter schools for matter of right development.
And the public process, our DCPS schools get an easier treatment under the zoning regulations?
Right now, both DCPS schools as well as charter schools are treated identically under the zoning process. And that is a problem, because while there is a clearly articulated public process for DCPS development, there is none for DC charter schools. And that leaves a huge loophole that these petitioners adequately outlined for the zoning commissioners. The problem came when the Office of Planning was asked to comment on this, to create a report on it, and they sent the petition out to self-interested actors, including the Federal City Council, which is pretty incredible. I mean, they could have asked me to comment on it if you're just going to go to a private group, right? I don't understand what the purpose of that was. But the end result is that there is no clearly articulated public process to protect neighborhoods and neighbors from charter development in their midst, as there is for DCPS, despite them being both considered matter of right.
And I misspoke in how I phrased the question. Private schools have to go through a more rigorous process than public schools.
Right. Well, that it's not. It's more. I mean, we can argue whether it's more rigorous, but there is a backstop, and publicly funded schools don't have that same backstop. But the difference is within that category of publicly funded schools. DCPS does have a backstop. They have the SIT process. They have elected leaders with oversight, elected and appointed leaders with clear lines of oversight. DC charter schools have none of that. There is no SIT process. There is no public involvement in that development. And there's no way that people can know that ahead of time. The best that the public has is that they're notified that a charter school wants to locate somewhere at some time in some manner. That's the best we have. And that's, as the petitioners showed in their petition, that was not adequate even remotely. So why not have an additional step for public charter schools like private schools do?
I'm going to look at your written testimony more extensively. I'll ask the director about this. Thank you for your testimony. Let me check with staff. Anybody else? Teresa Neruzzi? Yeah.
Good morning, Chairman Mendelson.
Good morning. Why don't you begin?
Okay, great. I don't have a written statement today. I just wanted to provide a couple of thoughts about the zoning commission and the racial equity analysis that is now required by the comprehensive plan. My name is Paris Neruzzi. I'm the director of Empower DC, which for the past 20 years has worked with residents district-wide to advance racial, economic, and environmental justice. As you know, the council passed the amended comprehensive plan almost 2 years ago. I think it was May of 2021. It calls for a racial equity approach in planning and zoning. And in April of last year, the Zoning Commission released a very basic draft racial equity analysis tool, just a few really questions that it was proposing. To its credit, it held a roundtable last September, received a lot of public input. And a couple of weeks ago, it released a second draft, which is now required by applicants to engage, to utilize this racial equity tool. It's a vast improvement, but I think the process of doing this has really highlighted some of the challenges and questions that are not just problems of the Zoning Commission itself, but really of the district government at large. The tool does now require community engagement. It uplifts the fact that community engagement should be done at the very onset of a project, and certainly we agree with that. It doesn't define any minimum standards for engagement or require, certain types of proof that the input received from residents is reflected in the decision. So we would want to see that defined more. There's also no finding of whether the project exacerbates racial inequity or improves racial equity like you would find with a racial equity impact assessment like is done with CORE. I think that having that step of really having a determination of the impact of the project would be wise. If Office of Planning is doing the analysis, they really need to bring on racial equity experts. We certainly don't believe that the land use attorneys within the development review section are prepared to do this type of analysis. We also think that the neighborhood planners who have more familiarity with the community should be involved in helping to, vet a community engagement plan and help gather the data and define who the community is that should be involved. I actually want to also raise the issue of the vacancy on the Zoning Commission, which is longstanding at this point, and really encourage you as you consider candidates that are brought before you to find a woman, a Black woman in particular, or a woman of color who resides ideally east of the river. There's no women on the Zoning Commission, and as you know, only one person of color on the Zoning Commission. We'd love to see somebody with an equitable development or community development background. And then lastly, I just want to raise the issue of the need to deconcentrate industrial land, particularly in Ward 5. There's a number of facilities that have been grandfathered in. They would not be allowed given current rules, such as the National Engineering Products Facility in Ivy City, which is manufacturing chemical adhesives adjacent to people's homes, as well as the W Street Trash Facility in Brentwood. I know that Office of Planning is doing a study on industrial land, but it does not have an environmental justice lens or frame. And I really urge the council to direct the Office of Planning and Zoning to develop an approach that considers equity in the planning and placement of polluting facilities, as well as the priority of deconcentrating industrial sites, eliminating grandfathered uses, and protecting residents' health. Thank you so much.
Thank you, Ms. Narusi. And you'll be submitting your statement?
I will. Thank you.
Thank you. I do not have any further questions for you, so I'm going to call the director. Thank you, each of you, for your testimony. And we'll now hear from Sarah Barton, who's the director of the Office of Zoning.
Good morning.
Good morning.
Good morning. I'm waiting for Chairman Hood and Chairman Hill as well.
No, it's not the same.
There
as
you go. Okay.
Live and in person. I have is a monitor in front of me that has you on it. So
They're here now.
okay.
Okay, great. Good morning, Chairman Mendelson and members of the City Council. My name is Sarah Barden, and I am the Director of the Office of Zoning. With me today are Chairman Hood and Chairman Hill. I am very glad to be here with you today to testify about the accomplishments of the Office of Zoning over the last fiscal year. As usual, I would like to start my testimony by taking a moment to thank OZ staff for their hard work and dedication to public service. Our office grew by 33% in FY22 with the addition of the Office of Zoning Legal Division. The division is comprised of 8 very talented attorneys who over the past year have begun to make a big impact on our operations. I will expound on that further on in my testimony. We all work together as a strong, cohesive team day in and day out as we provide service to the public, the Board of Zoning Adjustment, and the Zoning Commission. As you know, OZ is an independent agency that provides professional, technical, and administrative assistance to the Commission and the BZA. We support them in their oversight and adjudication of zoning matters in the District of Columbia. In administering the zoning application processes, we review and accept applications, we schedule public hearings and meetings, and draft and issue legal orders that document the decisions of both the Zoning Commission and the BZA. In addition to OZ's primary mission to support the Commission and the BZA, we have 4 ongoing strategic activities in keeping with that mission. First, we are applying computer technologies to enhance the effectiveness of our zoning processes, which provides for greater transparency. Second, we are concentrating on outreach activities to educate the public on the zoning regulations and procedures, which empower city residents to more effectively participate. Third, we assist the public in navigating through the zoning process. And fourth, OZ has made it a priority this year to work to advance racial equity initiatives. We have provided a letter containing the answers to the questions included in the City Council's letter of February 1st. Since the beginning of FY22 through today, OZ continues to make significant gains in a number of important areas. I'd like to highlight a few of these areas and also a few performance measures. In FY 2020, OZ was provided with funding and FTEs to hire 3 attorneys that it detailed to the Office of the Attorney General. In FY 2022, the City Council and Mayor funded 3 additional FTEs so that the legal division could be housed at OZ. We assembled a team that has made it their goal not only to serve the Commission and the BZA to the best of their ability, but to clean up the 90+ BZA and Zoning Commission order backlog that we inherited. Even though there was a learning curve, they all hit the ground running and have been providing excellent service to the Commission and Board, as well as producing orders. In FY 2019, 50 BZA full orders were issued, but it then declined to the point there were only 21 BZA orders that were issued in FY21. In FY22, we issued 37 BZA full orders and 62 Zoning Commission orders. The orders that were issued were on average 80 days old for the Commission and 1 year old for the BZA. The oldest order were just over a year for the commission and 3.5 years old for the BZA. The commission backlog was cleared by the end of 2022, and currently the commission orders are on average being issued within 49 days of decision. On the BZA side, 71% more orders were issued than in the previous fiscal year. We are currently addressing the backlog while also working towards a goal of more timely orders and predictability in the process. Ultimately, we need the orders to represent the decision of the board, be legally sufficient, be able to stand up to appeal, and to be issued in a timely manner. Secondly, OZ has made it a priority this year to advance racial equity initiatives, particularly with respect to commission decisions. The recent updates to the comprehensive plan required the commission to evaluate all zoning actions through a racial equity lens. In order to comply with the comp plan requirements more formally, the commission released its initial racial equity analysis tool on April 28th, 2022. While the commission found the initial tool's guidance regarding requirements of racial equity submissions and racial equity themes and outcomes to consider in evaluating zoning actions helpful, it acknowledged the limitations of the information being considered and the need for more data to be considered in the evaluation process. For this reason, the commission held a public roundtable on September 22nd, 2022. It was to seek community input and ideas about the ways the commission could refine the initial tool. The commission then instructed OZ staff to subsequently meet with DC government agencies and external stakeholders with knowledge and expertise on racial equity issues to revise and refine the tool. After a few months of collaboration and several iterations, the revised tool was released on February 3rd, 2023. The main revisions include a new community outreach and engagement component, a new disaggregated race and ethnicity data component requiring centralized data sources, and additional evaluation themes and outcomes to consider. The commission expects the revised tool to improve upon its efforts in advancing racial equity initiatives and expects the tool to continue to be refined over time. Next, I would like to address one of OZ's 2022 performance measures. In FY 2022, OZ continued to feel the effects of the pandemic and therefore failed to meet its goal of hearing cases within 3 months of filing. While we failed to meet our goal of 98% of all cases heard within 3 months, 50% of the cases were heard within this time frame, and the rest were heard within 6 months. In FY 2023, OZ will have another setback with this goal because cases had to be rescheduled so the newly redistricted ANCs could receive notice about pending cases. Cases are currently being scheduled within 4 months. In conclusion, we are extremely proud of our accomplishments and are optimistic that we will continue to advance to new heights in the remainder of FY 2023 and beyond. I would like to express my sincere thanks to you, Chairman Mendelson, the City Council, and Mayor Bowser for your ongoing support. This little office could not function as it does without the unfaltering support it receives from all of you. I would also like to express my gratitude to Chairman Hood and Chairman Hill for their steadfast support of the office over the years, which has allowed us to accomplish so much and lay the groundwork to better serve the citizens of the district. This concludes my testimony, and I look forward to your questions.
Thank you, Ms. Barden. You mentioned in your testimony that one of your goals for the Office of Zoning is to concentrate on outreach activities to educate the public on zoning regulations. The council recently appointed a new executive director of the Office of ANCs, and one of his initiatives is to connect ANCs with training and resources to help them navigate the zoning process. Can you describe conversations you've had to date with Mr. Bass, and what steps are being taken to collaborate?
I haven't personally had any conversations with him. However, we are in the process right now of putting our training together for the ANCs, and I'll have to speak with my ANC liaison to see if she has yet, but we will definitely be in contact with him.
Okay, so when you're back with your budget hearing, if I ask the same question, I'll get an answer that yes, you've had conversations and working together.
Yes, and we will have scheduled them by then as well.
You mentioned in your testimony that several cases were re-noticed. to notify the new ANCs as a result of ANC redistricting.
Right.
Does the law require that you hold off or renotice these cases, or are you doing this out of a caution or some other reason?
We are doing it because as the ANCs were districted, the affected ANC is the one in which the project resides. So we felt that we had to renotice them so that the proper ANC could represent the public for those cases.
I hope I'm not hearing you say that there's only one ANC that can be affected.
No, not at all. I'm not saying that. No, I should say the affected ANCs in some cases. More often than not on the BZA side, it's one, but there can definitely be more than one.
I had an email exchange with you a month ago with regard to a case that was remanded from the Court of Appeals, involved Call Your Mother in Georgetown. Has that case been scheduled?
It has not been scheduled. It won't be scheduled until the board makes a decision, has been advised and makes a decision on whether there needs to be a hearing, whether there needs to be a limited scope of hearing or a full hearing.
Now, I went there from talking about renoticing because of ANCs, and then I also wanted to bring up your statement that currently you're scheduling cases about 4 months out. We have to move more quickly. So how can I feel better about the office moving more quickly?
Because we are headed that way. We were right there before the redistricting happened. And again, that set us back. So there were, I said 50% of the cases were being heard within 3 months. If the redistricting hadn't happened, we would have been at 70, 80, maybe more. But like I said, we are at 4 months now. So that means as we keep going, that will get better. It will get back to within 3 months. I project within the next fiscal year.
So remind me the process. An applicant, we're talking here about BZA cases, right? Or
Right,
zoning
right.
commission as well?
No, it's just BZA. Zoning commission
Okay.
is a different process.
So an applicant wants, a homeowner wants to put an addition on the back of their house, requires a special exception. I said that because I know a special exception is not as high a standard as a variance. And so they file the application. And then right now it's 4 months before it's scheduled?
Pretty much. So because there were cases that did not need to be renoticed. So all of those cases were able to be heard when they were previously scheduled in January, February, March. But for those cases that had to be renoticed, they were moved from January further on, as long as it complied with the notice requirements for the ANC. So that, of course, is pushing everything further. So newly filed cases are being filed at the same time. And it's about finding space on the calendar so that we don't have 15 cases in one day that would probably take us to past midnight. There has to be an amount of cases that can actually be heard on that day. So if the day fills up with 8 to 10 cases, whatever it is, then you have to move to the next hearing date, and so on and so on and so on until all the cases are placed on the schedule.
And how often is the board meeting?
Once a week.
This is a horrible thing to say, but can the board meet just to catch up here? Can the board meet a little bit more frequently?
It's actually catching up already. So we're on that path to catching up.
Okay, but the homeowner, the poor little homeowner who just wants to put a little deck on the back of their house and it's a special exception, probably have that a little messed up, but they're waiting. They filed today because they actually went to Department of Buildings. You don't go to the BZA without going to the Department of Buildings first and being told that the zoning administrator says you need a BZA a special exception. So there's already been some time there, a month, 2 months. So let's just hypothetically, the homeowner goes to Department Buildings January 1st. It's January, February, we're gonna say March 1st because Department Buildings isn't super fast. They're coming up later today. I'll ask them. So March 1st, the homeowner gets the letter from the zoning administrator, goes to the BZA. And that'll be March, April, May, June before the order, before the hearing. Right? That's 4 months, June. Getting a little nervous here. BZA goes into recess, so I guess that would be in August. So the hearing is scheduled for, let's say, the third week in June. I just thought I'd pick that. And there's a cranky neighbor next door, so this is not going to be a bench decision. Office of Planning said case is fine. It was just the one cranky neighbor who's pretty cranky. An order has to be written. How long does it take to get an order written?
It depends. It can take 2 days up to months.
Well, this was a contested case.
Mhm.
This is a contested case, so it'll be a couple months. Summer's in there, so the order comes out when? September, October, November? It's a pretty unhappy homeowner.
Possibly, but I will still say that as far as getting the hearing within 3 months, those issues were beyond our control, and we have been diligently trying to get caught up and get back to where we were pre-COVID, and we're getting there. We're just about there.
Well, remind me of the Call Your Mother appeal. My recollection is that there's an attorney for the board who will be reviewing this, and that attorney cannot review this until he or she's done with another case. I got that wrong?
No, what I was just trying to explain is that we're diligently trying to work through the backlog, as well as you brought this to my attention, this remand is on the list. It's in the queue to get done as soon as possible.
Yes, I appreciate that.
Yeah.
When did it get remanded?
Ooh, off the top of my head, it was, I want to say 6 months ago. I'm not positive.
Yeah, Court of Appeals order August 11th. I believe the case was a variance. The court held that the board had erred in granting the variance. The court didn't go so far as to deny the variance. It remanded it for the board. That was August, so help me here. It's now February. Are we talking about 7 months, 8 months? And the case hasn't been scheduled, and that'll be 4 months?
No, that would, first, we don't know whether there will be a hearing or not. The board has to decide that. But I'm not sure how that scheduling would go. That's not a newly filed case. I need to, it would be determined based on how the board decides.
Well, why can't the board decide last month whether to have a hearing? In other words, instead of doing this stuff sequentially, because there are other cases that, right, some of this, the delay has to do with staff. Correct?
Some of the delay has to do with staff.
Staff, yeah, BZA staff.
I'm sorry, I don't understand in what way.
Well, I'm trying to remember. You were kind enough to write back to me when I emailed you on this.
Mhm.
And my recollection.
What I was trying to say is that we were short-staffed for a short period of time, and so we're doing our best to try to keep up with everything, to try to get ahead on everything. But sometimes you're short-staffed and everybody is working as hard as they can, and you have to wait until you're fully staffed again. And so I was referring to that.
Okay, so you're fully staffed at this point.
We're pretty much back to being fully staffed, yes.
But why can't this case be presented to the board next week for a decision on whether to schedule a hearing?
Because they are working on it. They are working on it right now.
Can you say a little more?
No, other than they're working on it. They are, I'm telling you, they're diligently working on all of the matters that they have to work on, and they will get it out as soon as they can.
Yeah, but this
It
is
is-
just a decision whether to have a hearing or not.
No,
Because
there's legal analysis that goes into it. So it's a little bit more than that.
from the staff, a legal analysis that would then say to the board, we think you need to have a hearing or you can get by without having a hearing.
Chairman Hill wanted to jump in.
Excellent. And I don't mean to be
I
giving.
didn't know that I was on a screen there for a second as I raised my hand. Hi, Chairman Mendelson. This is Fred Hill.
Good morning.
Good morning. I was just going to jump in with Ms. Barden and help her. Like, I mean, the way the queue is, as I understand it, there are other cases that are before that remand to get the analysis done from the Office of Legal Department. So as soon as if we jump that, if that remand were to jump the line, then all the other cases would suffer. In other words, I know that they're getting as quickly as they can to that remand so that we would be able to know whether or not, the board decides, I suppose, as to whether or not we're going to have a hearing, whether we would review it in some capacity. But I'm sure it sounds like a long time, and it does sound frustrating to me, even as a member of the public. And I really don't know how else to speed this up. I do know that the Office of Zoning's legal department was, as Ms. Barden mentioned, short-staffed for a while. They're back up and running. And unless there's some way to jump that queue, which doesn't seem fair to the other people, I know it's in process. It's not a great answer, but I know it's in the process.
Oh, it was a great answer, but I didn't like it. So, yeah.
I don't like it either.
Well, jump the queue, except that this is a remand from a court of appeals on a case. I don't know the details of the case. It's a variance. I believe it involves Call Your Mother. I think Call Your Mother is operating. So arguably, let's just say one perspective on it is that Call Your Mother is operating illegally. I don't mean illegally like the cops can come, but they don't have a variance because the variance that they were granted was, how do I want to say, not reversed. What's the word? Maybe not reversed, but what the Court of Appeals did was to say, no, it was granted improperly. It needs to be remanded and reconsidered. So actually the case predates probably all the other cases you've got. That's just a point about the queue. This is not a new case. This is a case, it's an old case. It's an old case because it's a case that got decided, then got litigated. Lord knows how long that took. And then the Court of Appeals sent it back to the BZA last year. And so it's not jumping the queue, I would argue. But on top of that, the things can be done linearly, which is another way of saying sequentially, or things can sometimes be done in parallel. I don't know how long it takes somebody to look at the case and decide to recommend a hearing or not. It's not the end of the world to recommend a hearing, and it's also possible to recommend a hearing and then change your mind. But all that's waiting, none of that's happened because all this other stuff has to get decided before there will be a decision to grant a hearing, which will then take place in 4 months. Why not decide now whether to have the hearing? That doesn't take as long, and then, because that's not a hearing, that's just deciding whether to grant a hearing. And then go on about all the other cases, and then 4 months from now, you have the hearing. As opposed to waiting 4 months and then deciding to have a hearing that'll be 4 months after that. I think I'm clear here. And I think that I'm conveying some frustration, not because I'm feeling frustrated, but because I'm pretty sure that the constituents who care about this are very frustrated.
Sure. I mean, I haven't looked into the specifics about remands as to how they are processed, meaning if there is a way to, I will say jump the queue, and that this is the flow in which we're getting our information from the Office of Zoning's legal department. However, if a remand can be looked upon differently, I can talk with Director Barden, or I don't know, see what different options there are available to us. As far as the illegality of it, I mean, the fact that the case is remanded back to us doesn't mean that it was wrong necessarily. It means that we have to determine whether we did make an error. So it's not necessarily operating illegally now. They're just operating under the context of what the original order was.
Which the court has, if I say vacated, I might be technically legally incorrect. My defense is that I'm not an attorney, but the variance that was granted by the Board of Zoning Adjustment is not valid today because of the Court of Appeals decision.
That I don't know. I
Well,
thought that
why would the
remand-
court have remanded it? They wouldn't have said it's valid and you need to reconsider it.
Again, I'm not a lawyer either. As far as I know, the Court of Appeals has said that we need to, again, remand. I thought meant we have to take a look at it. We're waiting for the Office of Legal to look at it and let us know what their thoughts are on it so that the board can determine its next path. But I understand the delay. I mean, it all sounds, as you were going through the special exceptions, that also sounds like a lengthy time.
The note I have here, the DC Court, I don't know if this is correct because this was not written by an attorney. The DC Court of Appeals agreed with us, the neighbors, and the variance was vacated and the case remanded to the BZA. Now, I'm not suggesting that Call Your Mother is operating illegally, as in the police should go or Department of Building should go and shut them down. But they don't have a variance. And they're operating contrary to they're operating in variance of the zoning regulations, but they don't have a variance. So that's what I meant by that point. How long does it take for an attorney to look at this, to read the court case, which I'm assuming is not a couple hundred pages, the court decision, I mean, and decide whether to recommend a hearing? How long does that take?
I would also say, though, that you mentioned working in parallel. The attorneys are working in parallel on many, many levels. So they're giving legal advice on all the cases that are coming before the board every week. They're giving legal advice to the board during the week. They're writing orders. So they are working in parallel. Again, I don't think it's a matter of how long it takes. It's a matter about the queue, what's being worked on at any given moment in time. Again, when we come back before you in a month, I hope to be able to tell you that it's done, that it's scheduled. But I can also keep you posted within the weeks preceding that as well to tell you where we are.
Okay, I won't belabor it. Ms. Barton, do you have a response to what Carissa Naruzzi testified about regarding the racial equity tool? I know you spoke to racial equity analysis in your testimony. Ms. Naruzzi had made some statements. I don't have her, she didn't give me a written statement, so I can't read anything to you. You were listening. Do you have a response to what she said?
Yes, I believe she mentioned all of the milestones that we made this year, and she said that there might be some room for improvement, and I would agree with her. We've always said, as we've worked on this racial equity tool, that it's always in flux. If things come up that we did not think about or address, there will be room to revise the tool yet again and refine the tool yet again in the future. So, they just released it February 3rd. We will see how it's working out, and we're always open to public comment about how people think things are working. And if needed be, it will be refined further in the future.
Now, your testimony gives the sense that there is a lot of data-driven work. Will this affect your budget? In other words, will we be seeing something reflected in the budget we get next month?
No, the data sources are over at the Office of Planning.
All right, so I should ask OP. In prior years, we've asked the Office of Zoning, I think that means we've asked you about the number of PUDs and other discretionary reviews that have been submitted backlogs and orders and appealed orders. Previously, our concern was that appeals were having a chilling effect on discretionary review applications. So where are we at with PUDs? And that's a very generally worded question. Where are we with PUDs? For instance, have the numbers changed in the applications? Are we still seeing any remands from the Court of Appeals? What does the PUD picture look like today?
No, there are no remands that I can remember. I think the only cases that have been appealed recently have been BZA cases. I do believe we are receiving more PUD applications. Other than that, I can find the information and send it to you on how many PUDs have been filed, but I do believe that has gone back up.
Would you follow up and
Absolutely.
go back several years so that there's more of a context? You may have to go back before the pandemic, since
Okay.
pandemic may have affected things.
Okay, will do.
I think there's still some in the development community are talking about how difficult it is to get a PUD, and I'm guessing that the statistics have changed dramatically from, say, 6 or 7 years ago.
Mhm.
So it'd be helpful to see that. Thank you. Are you still conducting zoning and BZA meetings online, or are parties coming back into the Berry building?
No, we are still online.
Do you think that has enhanced or hindered participation?
I believe it's enhanced participation. We have a survey on our website when people sign up to testify on whether they would like to continue virtually, try to figure out some kind of hybrid, or come back in person. And by and large, 75% plus want to continue virtually.
No, there's nothing like a controversial case with a packed hearing room.
Right.
That kind of gets lost with the virtual. You have a vacancy on the zoning commission?
Yes, we do.
How long has it been vacant?
I think for about a year.
Do you know what the status is of filling the vacancy?
I do know they're working on it, actively working on it. Yes.
And what does that mean? That they've said to you, Moda has said to you we're working on it, or you've actually seen some like names going back and forth?
No, I haven't seen any names, but I know that Moda is working on it.
Can you respond to Ms. Akel's testimony? She didn't have a written statement. Oh,
Yes.
it's in the written statement.
I think she mentioned there being an issue with the testimony that's in the record. And I just wanted to say a couple things. First, the record is open for anyone to provide testimony. I know she said that there was some testimony that doesn't have addresses on it. We do request that people put their address on their testimony, but there are people who do not want that kind of information out in the public. And so it's really up to the commission to decide how they're weighing the testimony that they read. And so we don't want to not allow people to submit testimony within the record. She also mentioned that there was one exhibit that was misnamed in support instead of opposition. And that does happen. There are humans back here exhibiting those documents. And so we always ask that if somebody catches that, just to tell us and we can change it within a minute. But also understand that the commission is reading every letter. So even if it says that it's in support, they're going to read it and say, oh, this is in opposition. So we do want the record to be correct, but know that it won't get by the commission.
So part of your answer is that the commissioners are the ones who ultimately decide what weight to give to the letters, to understand whether the letter is actually in opposition or in support, and to balance the letters against each other.
Right.
What about Ms. Jablow's testimony, which apparently was a petition to the zoning commission to treat charter schools like private schools? Are you familiar with that case?
I'm gonna let Chairman Hood respond to that.
Good morning, Chairman Mendelson,
Morning.
Chairman Mendelson, Councilmember and staff. I appreciate it. I wanted to make sure I say good morning. I heard the young lady, I don't remember her name. I have some notes here, but I heard her mention about the charter school issue. The zoning commission, you know, we do land use and we're not the experts, so we have to elicit a lot of information from the subject matter experts. And then our findings, our conclusions of law, and we looked it up. I looked it up as she was speaking. It says, the commission notes that the deputy mayor for education, the public charter school board, and OSSI were consulted by OP staff and all agreed with OP's position that the petition's proposed text amendment should not be set down for a public hearing. So we operate on the advice of all the subject matter experts, because through their findings and their analysis, it would put an undue burden on public charter schools. So that's why we ended up where we were. I know everybody's not always happy with the decisions, but the subject matter experts weighed in. So that would be my response, Mr. Chairman.
Was this a case before the zoning commission, or it was correspondence?
It was a text amendment that was proposed to be set down. It was zoning commission, hold on a second, I'll get my computer act right. It was zoning commission case number 22-26. And I think I would also implore the young lady to read the order, which I believe she has, but I would ask her to read it again and look at the conclusions of law where the subject matter experts in this city have weighed in.
So it was a text case.
It was a text case, right? And what was told to the commission at the time, the way I'm reviewing it and recalling it, was that it would put an undue burden.
Yeah.
And you know, we want to keep undue burdens. The goal is to streamline, as I'm hearing in this conversation, is to try to get things done, and that would actually add to what charter schools would have to do in their relief requests, and when they would have to do more relief requests according to the order.
So the zoning commission had gotten a request to amend the zoning regulations to treat the charter schools differently than they're currently treated. And the zoning commission received comments from the deputy mayor for education and others. And then the zoning commission issued an order.
Well, we didn't set it down without prejudice, because the subject matter experts, Mr. Chairman, who are the ones who govern this, were not in support of it as well.
Okay, and and when did the order come out?
The order came out, so I can find a date, on January 20th, 2023. So it's relatively about a month or so ago, about a month.
Yeah, so if the petitioners wanted, they could go to the Court of Appeals, although it might be too late now because it's more than 30 days.
Well, actually, the 23rd today is what, the 20, so it's a month. Yeah, you're right. 30 calendar days.
Mr. Hood, did you want
Yes.
to say anything when I asked a question about the racial equity tool? I think last time you testified.
We are on, Mr. Chairman, and I appreciate the time to be able to respond to it. I appreciate DC Empower's comments. We take the racial equity tool very seriously, to the point we had a roundtable, as it's already mentioned. What we want to do now is do the track record and put it in place to move it forward. So that way we can see how it works, and we can, we've always said it's going to be fluid. We may have another reiteration of it, but we already said that it's very fluid. But I also want to take the time to thank the Office of Zoning under the leadership of Ms. Barton, but especially Ms. Lovick. Ms. Lovick has been on top of this from day one. We have not always agreed on how we're going to move this forward, but the biggest part of this racial equity lens for me is community engagement. That's the biggest piece that I see through all this, Mr. Chairman. And then there's some other findings and other things that we have to look at. And Mr. DC Empower is exactly correct, is that we are still looking at ways and how it's going to actually work. So we want to still solicit everyone's comments. We're going to probably do another roundtable at some point, but we have to put it in action first to see how it's going to come out and make sure that actually where the rubber meets the road, this is actually, even though it's fluid, but it's actually working for the residents of the city and it gets to the folks that it needs to get to. That's where we are, Mr. Chairman.
Thank you. I think that's going to conclude my questions. Let me just check with staff. I don't have any other questions for you. Thank you. Ms. Barden, you'll get back to us with regard to PUD information.
Absolutely.
And we'll see you, I think it's on March 28th.
Right.
And I think Chairman Hill wants to say something, but in a second. When you come back, I'm hopeful we'll have more information on the timeliness of getting hearings scheduled, including that remand case.
Correct.
Chairman Hill.
Chairman Mendelson, thank you for allowing me the time. I just wanted to also thank the Office of Zoning and Cliff Moy and also the Office of Legal Department with Mary Nagelhout and their staff, as well as Sarah Barden, as well as all of the people that have helped us. I'm up for my term is coming up in September. And so whether or not I am here again, I want to thank Mayor Bowser and the opportunity to have served here and really personally have appreciated it over time. I've really learned a lot and I've enjoyed speaking with everybody in the community. And I just want to say thank you. So thank you, Chairman Mendelson, to you and the council.
Thank you.
Mr. Chairman.
Yes.
I know you're rolling, but give me a moment. I also too want to thank the mayor, the council, the residents, applicants, the ANC, especially the Office of Zoning under the leadership of Ms. Sarah Barden, and as well as I've already mentioned, our Office of Zoning Legal Division, which has been working very diligently since we made this move. I cannot say enough about them. They are excellent. And also the whole Office of Zoning and my right hand who really keeps me straight. And when I'm running things, and that's Ms. Sharon Shelling, Ms. Ackerman, and all those in the Office of Zoning, the ones I work with consistently and ones that I don't work with see as much, but they all make it up under the leadership of Ms. Barden, and also my zoning commission colleagues and BZA colleagues. So thank you, Mr. Chairman, for allowing me that moment. Thank you.
Yes, and I'll see all of you in a month. It's exciting. Thank you all.
Thank you.
All right, you're excused. We're going to turn to the Office of Planning. I'm going to call the public witnesses, meaning the non-government witnesses, and then after we hear from them, we'll hear from the director. ANC Commissioner Anthony Dale, ANC Commissioner Jamila White, Alex Baca, who's with the Greater Washington as the DC Policy Director, Parisa Naruzi, Executive Director of Empower DC, Kristen Barden, who's with the Adams Morgan Partnership Bid, Nancy McWood, listed as a member of Ward 3 Housing Justice, Helen McCarthy with Ward 3 Vision, Scott Roberts, who's with the DC Historic Districts Coalition, Rebecca Miller, who's with the DC Preservation League, Chad Donahoe, who's with the Friendship Heights Alliance, Michael Fisher with the DC Legacy Project, Deborah Akel, Caitlin Maury, who's listed as Community Economic and Equity Development Law Clinic at American University, Washington College of Law. Debbie Hanrahan. Bill McLeod, who is Executive Director of the DuPont Circle BID. BID is Business Improvement District. Give it a moment for folks to be let in. I believe that Commissioners Anthony Dale and Jamila White are not here yet. So Alex Baca, I think you're first.
Good morning. Thank you, Chairman. My name is Alex Baca, and I am testifying on behalf of Greater Washington, where I serve as DC Policy Director. I've submitted more detailed written testimony just for verbal comments today. I want to focus on the comp plan and land acquisition. It's our understanding that a rewrite of the 2006 comprehensive plan, which was amended in 2021, will begin in 2025. We look forward to the Office of Planning's proposal for how the rewrite will work. GG-WASH would like the rewritten comp plan to reflect the recommendations by OP in its 2021 staff report about its composition to be shorter, more legible. And we would like to see it legalize apartments district-wide. We are prepared to work closely with the executive and the council to bring this to bear in a way that is racially and economically equitable. On land acquisition, we've advocated for several years now for the district to retain ownership of its land by ground leasing it, to start an acquisition fund to facilitate the purchase of more land, and to zone for the maximum possible density allowed by the future land use map on that land. In the future, we'd like proposed map amendments for those zoning changes to come from OP, not from developers, once their bid for any given specific project has been awarded. A precedent for this process is currently being set by OP's proposed map amendment to rezone 1617 U Street Northwest from MU4 to MU10, which we support and which we've urged our readers, who are members of the public and who can submit any comments anytime, to support, as we've assumed that what is interest to us is of interest to them. Happy to answer any questions. Thank you so much for your time. That's all from me right now.
Thank you. Ms. Norouzi, Parisa Norouzi.
Good morning, Chairman Mendelson. I'm Parisa Norouzi, Director of Empower DC. I just have a few comments on the performance of the Office of Planning, particularly as it relates to the racial equity analysis, as well as some of the ongoing planning efforts that are underway right now. Overall, we are concerned that the Office of Planning has been slow and very limited in its definition of its racial equity approach. Office of Planning had an open house just a couple weeks ago. The 4 bullets that they have in their racial equity action plan for the agency are extremely lacking. They're very basic and non-detailed. So for instance, it says OP staff understands and is committed to racial equity. OP is committed to eliminating racial and ethnic inequities. OP is committed to meaningfully engaging community, and OP is an equitable employer. But there's no goals yet defined. How are we measuring this? How are we identifying this? And so we fear that this is really being slow walked and kind of done in a manner that lacks any measure of accountability. Are we advancing racial equity? In the actual planning initiatives that are taking place right now, we're very involved in the Ivy City Small Area Plan. And I would say that it has been a fairly good experience working with the neighborhood planners on that initiative thus far. However, it's, a bit frustrating to be a partner of the Office of Planning in the sense that we are speaking with them and we are, doing labor to engage our membership in Ivy City in this effort, but still having like a limited level of transparency. The things that I want to put on the record though, which I hope the council will monitor and look for when you get the small area plan before you, is that the agency has committed to do street level engagement and really emphasize door-to-door outreach over any type of, not holding online meetings, and certainly limiting even the meetings and doing more of the gathering of input, really person to person on the street level, which we think is really good. So I hope that we will actually see that. And that as part of this small area plan, we will have as a centerpiece an affordable housing strategy. So a strategy that really looks out how to preserve existing affordable housing, as well as how to create additional deeply affordable housing in the Ivy City community, as well as an environmental justice strategy. So how to really address the air quality, heat island, and some of the other issues, lack of green space affecting the community. So I hope, again, that the council will really look for those things as the plan comes before you. I know my time is limited, so I just say briefly again on the New York Avenue framework and the industrial land use study that are also taking place. There is not an environmental justice lens to these projects, and we really need there to be. So I would encourage you to emphasize to the Office of Planning that incorporation of racial equity, environmental justice, and equitable placement of industrial lands, it really has to be foremost in these studies. Thank you.
Thank you. Kristen Barden. And I should note before you speak, Ms. Naruzzi, I assume you will submit your statement.
I will, thank you.
Ms. Barden.
Hi, good morning. I'm Kristen Barden. I'm the Executive Director of the Adams Morgan Partnership Business Improvement District, and I have been in this position since November 2008. I'm very pleased to be here today to say how thankful we are for the Office of Planning Streets for the People grant program. With the grant funding we received last year, we held 3 pedestrian zones. We call them the AMPZ, the Adams Morgan Pedestrian Zone, on 18th Street between Calorama and Columbia Roads. These pedestrian zones were follow-on activities to the mayor's weekend-long street closure in June 2020 that was not continued due to fear of the COVID-19 spread at the time. But we have no data to support that the June 2020 pedestrian zone resulted in any COVID cases. We also installed 3 benches in the public plaza at Adams Mill and Columbia Roads to sit in between the newly planted trees by DOT Urban Forestry. And we are continuing to pursue a permanently installed infrastructure designed to close the street to vehicle traffic without the recurring expense of dump trucks, MPD cruisers, and traffic control officers, or TCOs. We have been invited by DDOT to review a variety of street closure proposals for F Street Northwest around the Capital One Arena, and are hopeful that one of those could be approved for use in Adams Morgan as well. Those proposals are being brought to DDOT by MPD and Capital One Arena. The Adams Morgan pedestrian zones were a terrific economic development tool to bring pedestrians, cyclists, families pushing strollers, etc., to have an open walking promenade and space to watch and participate in pop-up entertainment that occurred at scheduled times during each design day. The unobstructed 20-foot emergency access lane was maintained in the center as HCMA had requested. The pop-up entertainment was done in such a way as to not obstruct emergency access. I've included the schedule of entertainment for each day with this testimony, along with the 3 flyers we produced for business owners throughout Adams Morgan that describe what they should expect for each event. I've also included a summary of the media coverage we received, the pedestrian numbers obtained from pedestrian counters installed, website traffic, etc., that we use to measure the impact of these 3 events. We would like to continue these Adams Morgan pedestrian zones on a more regular basis during warm weather months. One criticism we heard was that the schedule of random Sundays was difficult for businesses to plan. We would need a commitment from the city for a regular schedule, the first Sunday of each month or something similar. The permanent infrastructure should also make the costs much less, since we would not need to use dump trucks, TCOs, or MPD cruisers to block the road. One of the other criticisms we heard was about the large number of MPD officers and cruisers on the street for each event. And of course, there is that expense. We have not yet received confirmation from MPD that they would reduce their footprint or manpower should the permanent infrastructure be permitted and installed. We need the commitment from MPD to reduce the requirements, or it would be wasteful to install the infrastructure. Thank you for your support of the Streets for the People grant program. I know my colleague Bill McLeod will speak later, but I would just like to echo that my colleagues in the other bids that received this money, Kenyatta Robinson at Mount Vernon Triangle, Leona Agarides at Golden Triangle bid, and Jaron Price in the downtown bid are also very appreciative of the opportunities that this grant provided for their respective communities. And we hope to submit additional proposals this year and hopefully next year to continue this pilot project. And I'm happy to take any questions. Thank you.
Thank you, Ms. Barton. I don't have a copy of your statement. You'll submit it?
I sent it last night.
I do have a copy of your statement. Thank you. The police presence or footprint, some of that would be because of the road closures. You mentioned vehicles blocking the roads, the police vehicles blocking the roads, but some of that might be security concerns, given what we've seen in other towns. Don't you agree?
Yes, well, our understanding is that they staffed it as if it was an Adams Morgan Day festival from years past. And this was not an Adams Morgan Day festival. There's no vendors allowed in the street. And it didn't attract, the tens of thousands of people that the festival would. So this was a much smaller scale event. And we did not think it required the level of MPD resources that they brought. I think, yes, of course, there's going to be some MPD required, but not at the level that they brought.
Thank you. Thank you. And I do have your statement. Nancy McWood. I believe she's not here. Ellen McCarthy.
I'm sorry, Mr. Chair.
There you are.
Yes, I was having a hard time getting unmuted there. Good morning, Chairman Mendelson and members of the council and staff and the general public who might be listening. My name is Ellen McCarthy, former director of the DC Office of Planning and DC resident for almost 40 years. My testimony is very short and it addresses a very small but important point. The DC government in general, and the Office of Planning in particular, needs to have and deploy additional resources to bring communications with the public up to the state of the art of the 21st century. Jurisdictions across the country have implemented numerous innovations in public outreach, and we lag behind. In addition, I think it's important to recognize people have different learning styles. Our recent experience with the Office of Planning with regard to the Chevy Chase Small Area Plan highlights the importance of OP having more resources to provide graphics and renderings and perhaps charrette style opportunities for public engagement and planning. When we're planning for neighborhood growth and development, we can't assume that the average citizen can envision what the recommendations of a plan rendered in text will actually look like if implemented. In our case, the ANC 34G had unanimously supported increasing the intensiveness of land use designations in the future land use map as part of the comp plan amendment process, with the condition that no zoning change be proposed till a small area plan was done. As you know, the plan was done and adopted unanimously by the council. I'll submit the testimony later, and I'll skip some of the intervening points. But it was evident that residents could not conceive what impact the proposed new heights and densities would have on the character of the community. Due to resource limitations, the final report only had 2 or 3 sketches to help people see what the changes would look like. And it included detailed recommendations to step down in the rear of Connecticut Avenue buildings, to have a smooth transition to the single family residential units behind, but no graphics to see how that would look. Now, DMPED is proceeding to implement the recommendations of the small area plan, redevelopment of the Chevy Chase Library and Community Center with affordable housing on the unused development rights. There's been an outcry from some citizens against allowing for this desperately needed public housing or affordable housing, who cannot envision how the site would accommodate this new development without undermining the character of the community. In addition, OP is in the process of preparing new zoning text for a new neighborhood zone as called for in the plan, It will involve setbacks and various other design requirements for new construction recommended in the plan. As you can imagine, it'll be difficult for people to envision how that will look, and the Office of Planning does not have the resources to provide renderings to allow that to happen. Bottom line, we have an affordable housing crisis in the district, and we are probably facing some severe fiscal shortages in the near future, which will dramatically reduce the funds available for public subsidies for housing. The comp plan recommended that additional density that there be additional density along major arterials, especially in the vicinity of metro stations, as necessary for one tool to deal with affordability, especially since the upzoning will carry with it IZ plus requirements, dramatically increasing the affordable housing requirements for new development. We also know that in order to deal with our housing crisis, we need to utilize all of the tools available, and that includes using city-owned land as effectively as possible, utilizing opportunities to include affordable housing in addition to redeveloped city facilities. But we also know that density can be very threatening to citizens who are not planners or visually oriented. Better resources to render how new development might look could avoid or at least reduce the kind of acrimonious comments and opposition that only delays moving forward. We expect to return for the OP budget hearing to support these additional resources. And I would also add, just as an aside, based on my other role, which is teaching land use controls and placemaking at the urban planning program at Georgetown, in response to the witness earlier who was talking about how only those who are immediately proximate to the site at 17th and U should have a role in, or should have a major role in advising on that new development. The point that people, we clearly need better education of the public in general about the planning process, development, zoning, et cetera, in the district. The point that is important for people to understand is city-owned land is precious. If we want to achieve lower levels of affordability, that is very difficult to do on privately owned sites, even with the numerous city subsidies that exist. So the only way that we can move forward is to utilize all of those tools, and that includes publicly owned land. So yes, it's important that the residents in the immediate vicinity of public projects have a say to make sure that they are designed and implemented in a way that minimizes adverse impact on those who must live with them day to day. But there are really important citywide needs that we as citizens also need to accommodate, and we cannot insist that things must remain the same because that's the character of what we are used to. But if we can bring new tools to the process so that people can meaningfully input into what new development will look like and hopefully have their fears allayed, we can meet both the citywide needs and the concerns of the nearby residents. Thank you, Mr. Chair.
Thank you, Ms. McCarthy. And I don't believe I have a copy of your statement.
No, I am polishing it up. I will send it in shortly.
Thank you. Scott Roberts.
Good morning.
Good morning.
Chair Mendelson and council members. My name is Scott Roberts, and I'm a resident of the Bloomingdale Historic District who is speaking on behalf of the DC Historic Districts Coalition. The DC HDC is an informal alliance of individuals and organizations representing Washington, DC's 37 neighborhood historic districts, as well as other individuals and organizations interested in the city's historic preservation, including residents of potential future historic districts. The DC HDC has identified 5 issue topics for the coming year. First and foremost, the DC Historic District Coalition would like to highlight the need for increased and consistent enforcement of design guidelines in the city's neighborhood historic districts. As you are aware, there are 2 types of design guidelines. First, citywide design guidelines, which provide guidance on building components, as well as other important topics like new construction and sustainability. And secondly, historic district specific design guidelines. HPO and the HPRB support and adhere to these guidelines. Violations of these design guidelines occur regularly, and oftentimes it is the historic district's residents who are responsible for reporting these infractions to the HPO and Department of Buildings. I would now like to provide a brief overview of just a few of the violations that have occurred in recent years. My submitted written testimony provides a lot more detail. The first two examples are in the Capitol Hill Historic District, and the second two are from the Bloomingdale Historic District. Over in Capitol Hill, illegal windows were installed, and the HPRB decided that the unpermitted windows needed to be corrected. HTC supports the strict enforcement of design guidelines. The HPRB approved a design concept for oversized two-story rear addition Capitol Hill Historic District. HTC has concerns with decisions like this that dilute the integrity of a historic district. Over in the Bloomingdale Historic District, one homeowner was required to reshingle a turret with slate shingles, while another homeowner was allowed to use asphalt shingles, clearly not in compliance with the Bloomingdale Historic District design guidelines. Also on the topic of design guidelines, HTC believes that there is a need for a user-friendly update to the whole set of design guidelines. There need to be clear and easily understood for both historic district residents and the general public. While some of the existing general design guidelines are well done, most of them are outdated and do not include color photographs and do not provide representative contemporary examples. They kind of look like documents that were written during the Kennedy and Johnson administrations. Generally, they do not provide, or they are not useful in practice. Additionally, in regards to the recent mayor's agent decision regarding for the use of hardy planks in the Capitol Hill Historic District, HTC is very supportive of design guideline updates that provide cost-effective solutions for homeowners, yet continue to preserve a historic district's character and identity. Like other historic preservation advocates in the district, DCHTC is requesting increased funding for the DC Historic District's Homeowner Grant Program. As the city addresses the affordable housing challenge, which is currently confronting every major American city, it is time to fully invest in homeowner assistance. We also request that the grant program be expanded to encompass all 37 residential historic districts. Finally, HTC would like to recognize the city's, specifically the HPO staff, for its rigorous work in the 2022 providing access to economic assistance for the residents of the Kennesaw/Renaissance, a historic multi-unit building in the historic Mount Pleasant Historic District. Thank you for allowing me to testify.
Thank you, Mr. Roberts. Rebecca Miller.
Good afternoon, Chairman Mendelson and members of the committee. My name is Rebecca Miller. I'm the Executive Director of the DC Preservation League. We are the citywide advocate for historic resources. I'm here to testify today, particularly on a relationship with the Historic Preservation Office, which we work very closely with to carry out our mission, and in doing so support DC-led initiatives that successfully utilize historic preservation as a tool for economic growth and vitality. You have my written testimony, I believe, so I'll just summarize given the short time period that we have. DCPL has had a long-standing relationship with the Historic Preservation Office to tell the histories of our unique and diverse neighborhoods. Recently, we have been working collaboratively to develop a more complete story of Washington's residents through context studies on Chinese and Korean American communities, women's suffrage, and African American civil rights. DCPL will also be collaborating with HPO on studies associated with DC's Latino history, as well as a survey of African American affordable housing in the district. These studies, funded by the National Park Service, help identify priorities for historic protection in traditionally underserved communities and provide a foundation for broader public education. We do really value our relationship with HPO, and as in past years, are submitting the testimony to assist this excellent staff with their vital work. As we've testified, I think for the last almost 20 years, HPO does not receive the financial support it requires to be successful through OP's budget. Much of HPO's funding comes through the Federal Historic Preservation Fund and from other agencies such as DDOT. Since 2010, several thousand buildings have been added to the DC inventory of historic sites. And this expansion of coverage has increased the design review load for what DCPL and affected community members, as you've just heard, perceive to be an already overworked HPO staff. HPO is an essential ally in enhancing the economic and cultural vitality of our city, and continuing to underfund the office and to rely on federal funds for HPO staff salaries is detrimental to the city's historic preservation program as a whole. We obviously have testified for years about enforcement. I may save that portion of my testimony for the Department of Buildings. Enforcement is clearly a problem, as you heard from Mr. Roberts. Historic preservation programs are important to residents of the District of Columbia, no less so than humanities and the arts. Historic districts and landmarks are indeed significant aspects of the city's identity and character. Despite this, there's very little investment in public education, outreach, or the Historic Homeowner Grant Program for low and moderate income homeowners. DCPL urges the city to expand all of these programs. The grant program should have a dedicated funding source that we hope the chairman may help us identify, and be extended to all historic districts and landmarks across the city, with the only restriction being income. Extension of the program this past year to a single co-op condominium building with a well-publicized external maintenance issue that has prompted the owners of other multifamily historic properties to ask for equal treatment. There needs to be a wider conversation about the use of public funds for the restoration of privately owned historic resources. The Historic Preservation Review Board, and I'll just summarize this as I see that my time has expired, that the HPRB is the official body. It's a 9-member board that helps implement the DC preservation law. Currently, the 9-member board has 4 vacancies, a historian, an archaeologist, and 2 citizen members functioning with a statutory required minimum risks a lack of quorum at a future meeting. This does not seem to be a priority of the mayor's office. These vacancies began this last July. And so they have been functioning with just the 5 members since their January hearings started up. There also needs to be representation across the city. The board currently has no members from wards 1, 4, 7, or 8, which have thousands of protected buildings respectively. Other than that, my final comment would be that I do believe that this new tweak to the Height of Buildings Act
Lady from AIEA is going to
Please
give
continue.
each of your
not
tables
sure
a
what the
large
feedback
sticky post-it.
I'm sorry,
It's
there's
going
a
to work through
feedback.
these questions once you get the scenario. So
5 seconds.
we're going to take probably about 30, 35.
Hold on for just a second. We're checking. There is
Oh.
some feedback. I'm barely hearing
Okay, there was just there was some,
Right.
sorry, I apologize. I'll just continue if you can hear me okay.
Bio
it.
break.
Yes, I can
We
hear.
are going to also take a photo, group photo at 12:15 on the stairs. So in the event you're out at
I'm just hearing about a group photo, so.
a group photo.
Give us
Okay.
a second.
Anyway, so just to talk about the Height of Buildings Act, the District of Columbia's character is one of its greatest
Great.
assets. And one thing we'd like to point out is that while the mayor states that the goal is to put 30 extra feet in the downtown zone of 160 feet, Pennsylvania Avenue is 160 feet wide. Downtown streets are not that wide, and the buildings will feel as though they're creating a tunnel space. And also topographically, the core of downtown is approximately 30 feet higher in elevation than low-lying Pennsylvania Avenue. Therefore, at 160-foot tall building downtown, in line with the mayor's proposal, would appear taller than those along the avenue, disrupting views and creating cavernous streets. The Height Act is not standing in the way of affordable housing, economic development, or any other important goal. We need to look at the low-hanging fruit in downtown in order to reach the goals that the mayor has set out for housing and conversions. With that, I'll just leave it there. And if you have any questions for me, I'll be happy to answer them in the future. Thank you.
Thank you, Ms. Miller. I'm going to pause for just a second. Sorry about that. We were checking on the that feedback that occurred during Ms. Miller's testimony. Chad Donahoe, is he here?
I am indeed. Can you hear me now?
I can hear you. I can't see you. I can see you. I don't know if I can hear you because you haven't said anything.
Thank you,
proceed.
Chairman.
Please proceed.
Thank you, sir. Appreciate the opportunity to come before you all. My name is Chad Donahoe, as you said. I'm Senior Vice President at Donahoe Companies, local landowner and builder in the DC area. I come before you today as Chair of the Friendship Heights Alliance, which is a cross-jurisdictional nonprofit that's formed to shepherd Friendship Heights from where it is now as two things separated by Western Avenue into one coherent, cohesive place through research, placemaking, and community building. Pleased to be able to offer our support and to voice our appreciation for the work of Office of Planning, in particular what Office of Planning has been doing in Friendship Heights. Back in 2021, Office of Planning led the effort to bring Urban Land Institute's Technical Assistance Program to Friendship Heights. And that was really critical in identifying some of the challenges that face our neighborhood and the potential solutions. It was instrumental in then identifying the need for and spurring the creation of the Friendship Heights Alliance, and has done a lot to bolster cross-sector, cross-jurisdictional collaboration among stakeholders in Friendship Heights. Would also like to thank Office of Planning for the Wisconsin Avenue Development Framework, which is ongoing, and the similar work on Connecticut Avenue. A lot of goals as part of that, but housing, and especially affordable housing, is perhaps paramount among those. We would also like to acknowledge that Office of Planning's good work has spurred Montgomery County's Department of Parks and Planning to begin their own planning effort, complementary on the Friendship Heights, Maryland side of the border. And we support the efforts to bring more housing opportunities at various income levels to Friendship Heights. We know that all this managing change entails a lot of deep and frequent community engagement, and would note that Office of Planning has been doing exactly that through surveys, through tabling at Friendship Heights Alliance events, through leading their own charrettes and the like as well. And they've gone through extra efforts to make that a possibility, and have been regular fixtures at our events, and have gone out and spoken with small businesses with us as well. Long and short, our area, Friendship Heights, is at the cusp of a lot of change. And we think we've hit a certain bottom that we're moving up from. And the Office of Planning's work in identifying the problems that our area faces and the solutions that may be available to us has been really crucial to us to date, and will be critical to the success of the area going forward. Thank you.
Thank you, Mr. Donahoe. Michael Fisher.
Good morning.
Good morning.
My name is Michael R. Fisher Jr., and I'm an affiliate scholar at the Metropolitan Policy Center at American University. Today, I'm speaking on behalf of the DC Legacy Project as a member of the steering committee. The DC Legacy Project is a coalition of activists, architects, community organizers, scholars, preservationists, and former tenants of Berry Farm dwellings that united shortly after the DC Historic Preservation Board ruled that the 5 remaining buildings of Berry Farm dwellings must be designated as a historical landmark. By conducting research, producing documentary films, creating art, hosting public programs, and engaging former Berry Farm Hillsdale residents and their descendants in planning and advocacy, our goal is to secure the historic landmark as a commemorative community space honoring the history and legacy of Berry Farm Hillsdale. Berry Farm Dwellings was demolished a few years ago in a push to redevelop the neighborhood, largely through the transformation of the public housing property there into mixed income housing under the city's nearly 2 decades old New Communities Initiative. Unfortunately, the New Communities Initiative has failed to produce new communities in Berry Farm. What it has done, however, is displaced Berry Farm tenants, many of whom called Berry Farm home for decades, and whose family lived in the neighborhood across multiple generations. The buildings that remain as a designated historical landmark is an achievement of those who fought the erasure of the community's history and legacy. As a reminder, the Historic Preservation Board stipulated that a small group of landmark buildings must be designated in the place of the remaining buildings alongside Stevens Road Southeast that, quote, should emphasize associations with significant persons, an authentic setting of buildings and landscapes, an ability to create a meaningful commemorative site well integrated into the rebuilt community. A portion of the landmark should house a museum and a cultural center to commemorate and extend the memory and legacy of Berry Farm for the benefit of future residents as well as the city and nation, end quote. The DC Legacy Project was formed to champion the preservation of the 5 remaining buildings that are the last of their kind in a way that truly honors the memory and spirit of the Berry Farm Hillsdale community. We envision the site as a space for community organizing, education, small business incubation, and other activities that support Black DC residents impacted by gentrification and dispossession. But for that to happen, the remaining buildings require regular maintenance to prevent further deterioration. Our primary concern is that these buildings are in danger of what is known as demolition by neglect, which is the practice of allowing buildings to deteriorate to the point that demolition becomes necessary or renovation untenable. This is a historic practice traceable to the 1950s and 1960s, at least, that has largely been used to circumvent historic preservation statutes. With this concern in mind, the DC Legacy Project partnered with the Quinn Evans firm to conduct a site visit and condition assessment of the standing structures and meet with relevant stakeholders, including the Legacy Project and the nonprofit developer POA, to discuss its findings. The report is forthcoming. Once released, we urge the Office of Planning in partnership with DCHA and POA to prioritize the maintenance of the historic landmark. So when the phased redevelopment plan moves to the historic landmark site, the city is in the best position possible to create a space that epitomizes the spirit of the Berry Farm Hillsdale community. The history and legacy of Berry Farm is an integral part of our city's culture and must be commemorated as such. As the city continues to change at a rapid pace and welcomes new residents, we must attend to the needs of the communities on whose shoulder the city stands. Thank you, and I yield back.
Thank you. Mr. Fisher, I don't have a copy of your statement if you would provide it.
Yes, I'll submit it now.
Thank you. Is Deborah Ako here?
Yes, I am here.
I have a copy of your earlier statement. Do you have a separate statement for this?
I don't have it finished, but I will submit it ASAP.
All right, why don't you proceed?
Okay. I just have sort of a wish list here of things for OP to consider. In their memo to the ANCs asking for support for their map amendment at 17th and U, there's a little section about affordable housing that says that increased density would give them the opportunity for additional affordable housing to be built. And it doesn't seem to consider the likelihood of this project triggering the sale of existing affordable housing. And that leads me to ask if they would consider creating a displacement tool. We have a racial equity tool, which is fantastic. I think we need a displacement tool where they would, when they propose a project like this, they analyze, they can put historical data in there, they can put property values in the area and compare it to other similar projects and see what is the risk of this project triggering the sale of surrounding affordable housing. So I would lobby for that, that they think about creating some kind of displacement tool, because what's the point of pitching new affordable housing if that project is going to put at risk existing affordable housing, like my building, which is right next to the development site and is a legacy building that could very well be put up for sale. This happened to me before, as some people know, in the West End, where a similar project triggered the sale of my building. So I think there should be some consideration about displacement risk, and I don't think that's happening. I would also like to ask OP to put social housing options in their toolbox. I don't know what needs to be done to move that down the field, but I'd really like to see that. I'd also like to see more consideration for multi-level designs. I think that would work really well at 17th and U, and I hope they're considering that as a possibility. I'd like to see something where displaced residents get priority for new units to buffer the challenges of being displaced. At least they could stay in the neighborhood and at a similar rent level. And lastly, I would like to know if OP considers the current vacancy rates in their push for increased height. I read in Biz Now a couple weeks ago that DC the vacancy rate is rising and the population has flatlined since the beginning of the pandemic. So I'd like to see or know whether they take current vacancy rates into account when asking for increased height and density. Thank you for this opportunity to testify again, and I will submit my written statement.
Great, thank you.
Thank you.
Caitlin Maury.
Good morning.
Morning.
My name is Caitlin Maury. I am a student attorney practicing under DC Court of Appeals Rule 48. I represent the Community Economic and Equity Development Law Clinic at American University, Washington College of Law. In that capacity, I represent Empower DC. I assist Empower to ensure that DC's economic and housing efforts do not leave behind its most vulnerable and longest term citizens. Today, I am requesting that the Office of Planning do two things. One, use disaggregated data to develop anti-displacement risk maps, make these maps available to all relevant agencies in a zoning decision, require that zoning applicants consider the maps in their applications, and publish the anti-displacement maps on the Office of Planning website. And two, that the Office of Planning prepares a text amendment formalizing the racial equity impact assessment requirement to perform the assessment before making a zoning recommendation to the Zoning Commission. The Office of Planning is responsible for the development of the comprehensive plan. I am here to address the comprehensive plan's impact on people of color in DC who are disproportionately burdened by displacement. The comp plan provides 4 guiding principles regarding racial equity, but I'm going to talk about the disaggregation of data by race and the analyzing of that data considering different impacts and outcomes by race. Since the Office of Planning is responsible for keeping and distributing the disaggregated data to the Office of Zoning and the Zoning Commission, so that they can use that data in decision-making, it is not enough that the Office of Planning merely steward the raw data and maintain it. It is important to use that data to improve racial equity in zoning and in planning. This has been done all over the country. Seattle, Boston, and New York have used similar disaggregated data to improve racial equity in zoning and planning by creating anti-displacement maps. These maps use disaggregation data such as percentage of people of color in a neighborhood, housing cost burden, proximity to transit, proximity to high income neighborhoods, potential development sites. In New York City, the Office of Planning works with the Department of Housing and creates these maps. In Seattle, the Office of Planning and Community Development creates and incorporates displacement risk and access to opportunity index maps, and they're available to the public. I will submit additional written testimony where you can see a map of Seattle, which shows concentrated areas of high displacement risk with low access to opportunity. There are areas on the map that are darker to indicate a higher risk index. In advance of DC's 2025 comprehensive plan rewrite, it is critical that the Office of Planning incorporates anti-displacement maps into the plan. DC Office of Planning has access to these resources, and we do not need to recreate the wheel regarding racial equity initiatives and planning. And I know that I'm short on time, but I would just like to finish by saying that as the Office of Planning works to increase racial equity in its decisions and recommendations, I ask that the Office of Planning create a racial equity impact analysis, AREA, for zoning applicants whose developments present a high risk for displacement. Since zoning applicants are required to comply with the latest iteration of the Zoning Commission's racial equity analysis tool, in its current form, it is self-reported qualitative responses to the tool are presented to the Office of Planning as part of a petitioner's application. And I ask that you use this information and the disaggregated data to complete AREA before submitting your own recommendation to the Zoning Commission. This is a useful independent evaluation method that can help increase racial equity in zoning and planning. That concludes my testimony, and I thank you for your time.
Thank you, Ms. Maury. Debbie Hanrahan?
Yes.
Are you on?
Yes. Yeah. Hi.
Good morning.
Good morning.
I can hear you. Okay.
Can you hear me?
I can hear you.
Oh, okay. First of all, Chairman Mendelson, I am so impressed with the quality of the testimony today. I mean, it begs the question of why is our city in such a mess in terms of planning and development? Because the citizens have really stepped up and presented an enormous amount of valuable information, which we obviously are not incorporating. I wanted to make a couple of points. Ellen McCarthy talked about projects having a huge impact on a neighborhood should not be totally controlled by the neighborhood's feelings. Well, I don't know about that, but I know it is land owned by the whole city. The whole city may have paid for it. The whole city is going to pay for the building on it. And I wish there were more transparency in exactly the kind of money we're spending. I'm really concerned. We talk about our purse strings tightening in the future. I'm not sure we're watching the store. We're spending way too much money for what we get at the other end. Also, Mr. Mendelson, I would like to thank you for coming to our community the other day. In 4 days, we had 4 days notice that you were coming, and we were able to get 90 people to come because they do not feel, despite the offerings today, that the citizens are included, are listened to, and have any weight in the decisions that are made. We have a meeting that we had, the Department of Transportation in the summer, the one meeting we were going to have on the 17th and U development. The report was never issued, and yet the ANC was asked to vote on it prior to being informed of what the report is. So we hear you, we heard you very eloquently say the process protects citizens' interests, but citizens don't feel that. Citizens don't experience that. And I would like you to, being a little cynical here, I would like to say that today's presentations by government witnesses emphasizing how much the public is included is really in response to maybe you and members of the council getting complaints that they are not including the public, because that really is the experience of the average citizen in the city. When building, development, whatever is going on in their neighborhood, only special favored insiders seem to have any effect. That's all I have to say. But again, thank you very much for coming. We really appreciated your visit. It did give us some confidence that somebody in a high place is paying attention to something which I think will just give gentrification on steroids to a huge between 17th and U and the Reeves Center. We will then be lighting a match, putting gasoline on 2 or 3 blocks, and that will end all that moderate and low income housing, because that's what happens. And so I'm not an expert like so many people that talk today, but I have lived through it. We have all lived through this displacement of people. And the reason we moved here was we wanted diversity. We wanted all kinds of people here. And all we're getting is upper middle class people in finance. So please save the city, save the character of the city, and approach things a little bit more broadly. And also, please pay attention to the bottom line. I think we're giving away the store in these private public partnerships, especially when it involves public land. Thank you very much.
Thank you, Ms. Hanrahan. It's good to see you. Of course, the first public step will be with the Zoning Commission. The case has been filed, and assuming they set it down, there'll be a hearing. And I don't have a copy of your statement. If you want to submit it, please do.
Well, can I say, Mr. Mendelson, that there was such terrific testimony that I scrapped my stupid statement. And I just wanted to make, I wanted to thank you for coming, and I wanted to note that the citizens in this town have so much to offer. Why aren't we doing better?
Thank you. Bill McLeod.
Good morning.
Good morning.
Good morning, Chairman Mendelson, Councilmember Fruman, and members of the Committee on the Whole. My name is Bill McLeod. I'm the new director of the DuPont Circle Business Improvement District. Last year, the DuPont Circle bid received a Streets for People grant totaling $339,000 from the Office of Planning, which enabled the organization to activate DuPont Circle through the summer, fall, and winter. 5 performances were organized, including a DJ, salsa lessons, concerts, and some were interpreted by sign language. The third Thursday Art Walk was expanded to include live performances, plus local visual artists created artwork on the sidewalk during the event. A fall festival was held in DuPont Circle Park, where children could paint pumpkins and listen to live bluegrass music while drinking hot cider from Dawson's Market. In addition to activations, the Streets for People grant provided funds that have enabled the DuPont Circle bid to build on our placemaking efforts by installing new banners, planters, and flowers, and holiday lighting. We've also been able to invest in new technology that will help the bid and its members identify better economic opportunities, as well as measure attendance in public space. Coming in March, we hope to convene an art charrette in the Hotel DuPont to let the community provide input into new public art on the DuPont Circle Plaza, which will be built over the next 2 years. Details about the date and time are still being organized. I want to thank you and the Office of Planning for your support for the Streets for People grant. This grant brought thousands of people to DuPont Circle over the last 8 months, helping businesses improve sales after the pandemic. Without this grant, the circle would remain a 2-acre grassy field. Activation of public space through this grant enables people to rediscover a community asset long taken for granted. Thank you for your time, and I'm happy to answer any questions.
Thank you, Mr. McLeod. And I do have your statement. Thank you for that. I just have a couple questions, not for you. Let me see, where are my notes here? A couple of people touched on this, and I wanted to just explore this for a moment. There was some testimony at the beginning. I'm going to read from it. Historic preservation regulations impede the production of more housing and more affordable housing. I wish that weren't the case, but it is. Ms. Miller, Rebecca Miller, how do you respond to that? I think you touched on that in your testimony, maybe not, but I'd like you to.
Sure. So while I don't have the numbers at the moment from the Washington, D.C. Economic Partnership, between, I believe it was 2016 and 2019, DC's historic districts and landmarks had produced 18% of the affordable units in the district. And since historic protection is about 20% of the city, it's almost in line with that. Also, because of the rent control regulations, it's buildings that are 40 or almost 50 years old at this point. Many of the properties that are rent controlled are row houses, they are apartment buildings and whatnot. So there's a tremendous amount of affordable housing that is already in historic buildings. There is concern from our understanding about development in historic districts and compatibility, that sometimes maybe a floor is lost or something like that when it comes to development, because the regulations are looking for compatibility of new construction within these historic districts. Conversions, a lot of row houses, of course, are converted from single family to multifamily. That has been a problem. But one of the issues that you'll find in these kind of conversions is that the properties are going from, maybe they're going from single family, they're going to 2, 3, or 4 units, while the developer may have purchased the property for $700,000 to $1 million. They're then selling the new units for $700,000 to $1 million individually. So you're talking about a tremendous profit in that capacity. So there are a multitude of reasons why affordability is hard in the city. Historic preservation is not the one source of that. There are other issues such as policies that have been set forth, and the allotment of all of these luxury apartment buildings that are across the city.
Are you saying that that if historic preservation were removed as a alleged obstacle, there would still be other obstacles?
I think there would be many obstacles, yes, because it's tremendously costly to actually develop affordable units. That's what I've been told from many developers.
But is historic preservation actually costly? We just went through this. This wasn't historic preservation, but the committee of the whole put through a bill last fall that requires buildings to be bird safe, and all these folks came in and said this is going to cost a huge amount of money, and we actually looked and it was in the tens of thousands of dollars. Is historic preservation really costly? Does it really deter a developer from building an additional floor?
Not generally speaking. I mean, I would think Richard Lake from Roadside Development was testifying at the deputy mayor's office. Roadside Development is responsible for the Wegman site up in Wisconsin, and that's a $718 million project. That particular developer submitted their own landmark nomination, decided to keep the building on their own volition, and developed around it and included housing and a grocery store and many other amenities for that neighborhood. So I would say no, that it is not. I think it's a tool in economic development, and which I think it's been proven to be for the last 50 years in this city.
There's also, isn't there through the historic preservation process if there is an issue with the development, that one can go to the mayor's agent?
Yes, there
argue that I forget the project is a project of merit, and merit could include affordable housing.
Yes, under special merit, yes. There have been cases that have gone through where developers have appealed the decision of the review board to the mayor's agent for historic preservation. The mayor's agent is actually the planning director, but they do have an an attorney who actually acts as that mayor's agent, and they can argue that there is this community benefit of affordable housing in order to overturn that of the decision of the Historic Preservation Review Board.
So in your experience, has historic preservation proven to be costly to developers?
I think it depends on the situation. I mean, the second largest landowner in the District of Columbia is Douglas Development, and they do almost primarily historic preservation. And so if it wasn't lucrative, I don't think anybody would do it. And so it may cost a bit more in some cases, but some of that comes from deferred maintenance on properties as well. There is not tremendous activity when it comes to holding up the property standards law. I mean, we've contended a number of times. We testified at DIMPED hearing last week about a number of DC owned buildings that are just rotting, and because there is no general maintenance done on them, that it will cost much more money to redevelop those properties. And that is the fault of the district government. That's not the fault of the historic building. It's the structure is there. Historic buildings are meant to last and be redeveloped. It's actually, from a climate perspective, the better thing to do for our environment because of the amount of carbon emissions that new construction put off. But it is the responsibility of an owner to maintain their building, so it isn't as costly to rehab a building in the future.
Mr. Roberts, you also testified in support of historic preservation. Do you have any comments on this? Scott Roberts, are you
Yes,
here?
yes. Just generally, I hear people speak about affordability in historic preservation and specifically historic districts, as that's what I'm representing. And broadly, if I can say that the enemy people think that they have isn't really historic districts, but it's zoning. The enemy in the room is zoning and not historic historic preservation regulations in the city. Does that help?
Okay. Let me see. I had another question. I had a question for Mr. Donahoe. Can you speak to the status of where we are with Friendship Heights and the development of housing and affordable housing there?
Yeah, there's already four different projects with varying degrees of affordability that have been announced or in some stage of moving towards construction. Those vary from 8% IZ in some of those buildings up to a project that Councilman Fruman stewarded, which is a largely affordable project paired with a senior's home. There is the possibility for at least 1,000 or more additional units as WMATA and the Western Bus Garage and the Lord and Taylor site get thought through. That is certainly an opportunity where an outsize portion of those units could be affordable units above and beyond the typical IZ levels.
Thank you. I had one other question. It was for Ms. Miller again. In your statement, you said we should have a conversation with regard to using government money for private. Needs to be a wider conversation about the use of public funds for the restoration of privately owned historic resources. Well, we could sort of have that conversation right now.
Okay. Happy to have it.
So begin.
Okay, so we have this homeowner grant program, which was originally supposed to be, it was actually a tax credit previously, but it transferred into this grant program, and it has historically only been available to targeted historic districts, which has left out other residents across the city, which is why we've had this discussion at DCPL and with the Historic Districts Coalition and others about this being a citywide grant program that the eligibility is just your income, regardless of your historic landmark or whatnot. We have had the council passed emergency legislation due to the issue at the Kennesaw, which has it's a very complicated ownership structure. It is a condo op. It's a co-op / condominium that was formed and signed off on by whatever DHCD's predecessor was. And so the way that the program is set up, it doesn't necessarily allow for the easy use on such a property of the homeowner grant program because of the essentially the lien that gets put on the covenant, I should say, not a lien, that gets put on the property so that you can't make additional changes or undo the changes that you received funds for from the DC government within a 10-year period, because co-ops you own a share of the cooperative. You're not necessarily owning. It's just not your building, so to speak. So there needs to be just this larger conversation to work through these issues, because now we do have, because the Kennesaw is receiving funds through the homeowner grant program and also through DMPED released a fund of $1.5 million back in November. It was advertised and it's been awarded to the Kennesaw because they were the only ones that were actually eligible for the funding. That other co-ops and condominiums that do have low and moderate income residents are interested in had their buildings being eligible for this grant program, and they're not at this point. And also $250,000 a year, which is the standard allotment of cash that goes into that fund, is just simply not enough. Because I mean, that ability gives out, you know, maybe 10 grants a year. There should be a dedicated funding source. There should be a dedicated staff member that works on this particular grant fund. And it could be as simple as a, you know, portion of the transfer tax, the real estate transfer tax, or something like that. But it just needs to be kind of rethought through, and that's something that DCPL is working on to present to the council as an option. And also, we have talked to the Historic Preservation Office about this, and not to speak for David Maloney, the State Historic Preservation Officer, but they're in agreement that there needs to be this program needs to be looked at.
If DCPL is working on a proposal, when would we see that?
Potentially in the next few months.
Or within the next month?
We can certainly try to get that to you within the next month, yes.
Well, I'm just thinking that it might be something that is germane to the budget and the Budget Support Act.
Agreed, yes.
All right, thank you.
Yes, we will make every effort to get you something within the next month.
Thank you. We've been joined by Councilmember Crewman. I've been just going on and on because I was here all by my lonesome, but now I have company. Mr. Fruman, do you have any questions?
Just a couple of questions. Thank you, Chairman Mendelson. For Ellen McCarthy, if Ellen is still here, I'm watching to see if you come back, Ellen.
I believe
I'm here. Wonderful. So
I'm here. Can you hear me?
Yeah, I can hear you. So thank you for your testimony, Ellen. I've seen proposals about charrettes, and maybe I'm thinking about this differently in the Chevy Chase small Civic Corps context. When you're talking about charrettes, are you talking about just demonstrations of massing, or are you talking about people from the community coming together and trying to design the building? Because I will be candid with you. I've been wary about the idea of a committee trying to design a building, some of whom are not architects or landscape architects, or and in the Civic Corps context, this is going to be an incredibly complicated building with a library with very technical needs, with a rec center with very technical needs. And so I have been skeptical of the idea of a convening that was intended to be designed by non-professionals, as opposed to spelling out of criteria, which then would be responded to by professionals who were responding to an RFP. But maybe I've been misconstruing what you're talking about when you talk about charrettes. So can you explain to me what you envision that charrette process in that context to be?
Thanks for the opportunity to explain. I definitely would not say that it is to do detailed design. A typical charrette operates with tools like Lego blocks, in effect, and allows people to sort of move the massing or think through the relationship of buildings to the site. In the case of the Civic Corps, I think it might be useful in that
as you move towards the stairs, if I could ask the tallest among us, about 10 steps up, that's where we're going to start.
I think you guys should go to the stairs.
We're hearing a voiceover.
Yeah. Somebody's unmuted.
Give me a second here. We're hearing a voiceover, and we're thinking it might be from cable television. If you could check your microphones to see if you're open.
Okay.
You continue, Councilmember.
Okay.
Ms. McCarthy.
So in the case of that sort of charrette, the benefit would be if you had blocks of some sort that represented the approximate square footage of the library, the community center, and then potentially
housing, they could be moved around to see, all right, what would be the effect if we put most of the height and density on Connecticut Avenue? How would that affect the housing behind? Where could the open space be? It would definitely not be detailed design. And the idea in this case, it's hard to do charrettes when there's a COVID emergency. And that was what OP was faced with. I did find some resources online, which I had forwarded, that had done virtual charrettes, and they, it was a pretty good adjustment to the circumstances. But in the case, so mostly I think we're looking at charrettes because there seem to be so many people who don't feel that they were sufficiently informed or involved in the small area plan process. I don't think that's necessarily OP's fault. Everybody, the loss of the Northwest Current left us without good ways for people who are not always plugged into their computers to know what's going on in the community. So I think the charrette process would be more making people feel comfortable with the fact that some of these outlandish charges that have been made on the listserv about the Manhattanization of the Civic Corps are just not true. And that in fact, there is room for all of what we want to see. That was what your point about spelling out general desires. Those goals and objectives are already stated in the small area plan. We could get them reinforced in some kind of a public charrette or an online charrette, but it's more to satisfy people that, and my goal is to reduce the acrimony and to reduce the delays and allow us to proceed with this project, which we've all been talking about for so long, and not have sort of groundless fears delay DMPED's ability to go forward. And then we'll get the really detailed plans from the prospective bidders, and we can see whether the pros and cons of those and comment on them. I would also note that in DMPED's RFP for the 17th and UV site, they have included relevant sections of the comp plan and other planning documents as guidance to the bidders. And I think we can insist on the same thing, that when DMPED issues the RFP, bidders be aware of what the community's concerns and issues and desires are for the site.
Okay, so that's very helpful. So, and I have been misinterpreting to some extent the calls for a charrette, which are more about education and less about design, is how I am thinking about it now after this conversation. All right, well, that's very helpful. I want to stay within my time, so I'm going to turn just very briefly to Jad Donahoe. I want to thank all of the witnesses who have testified. Jad, the Friendship Heights Alliance project is, as you know, I believe is a very important one. I was going to tell you, but I then got a press release from your organization that we have submitted legislation in support of the bid formation on the DC side today, and very much look forward to supporting your work. The chairman asked about affordable housing, and it's less a question and more maybe for the benefit of the chairman here, that there is a lot that's happening in Friendship Heights now. Most of it, other than the Lisner project, is using inclusionary zoning. The two big sites, as you referred, are the WMATA and the Lord and Taylor sites. That's a lot of the land on the DC side of Friendship, in Friendship Heights. And WMATA, in a sense, hopes to control both of those sites. They have the bus garage block right now. They want to purchase the Lord and Taylor site, and then they're going to do what they'll be making proposals on that. WMATA is not in the business of being an affordable housing provider. And they're pretty constrained about what they can spend their money on. So it's different than an ordinary setting where you're doing community benefits from a private developer. WMATA is going to need to do some community benefits, but to really create a lot of affordable housing on those two sites, just as a heads up to all of my colleagues, is going to require a significant amount of city support. And I think we should be getting ready to do that, because this is a very important site to have affordable housing at every level, but we can't expect WMATA to fund that. So we're going to have to figure out a way to do it. Are you seeing that? Now I'll just turn it into a question and give you a chance to go off on it. But do you see that in the same way, Mr. Donahoe?
Well, first, thank you, council member, and we appreciate the work you're doing in Friendship Heights, and the coordination we've had with your chief of staff, Lee Catherine, in moving forward with creating a business improvement district on the DC side of the line. And then, of course, as soon as next week, creating a complementary urban district on the Montgomery County side with your colleague across the line, Councilmember Friedson. Yeah, to take a crack at your question, we have about 800 units spread across 3 projects, not including the Lisner project that you helped shepherd into being. And of those, those range from about 8% to about 15.2% inclusionary zoning. That does not, frankly, that does not heal the wounds, and it does not repair the damage of decisions made and decisions not made in the past with regard to the provision of affordable housing. Those 2 large sites that you referenced, the Lord and Taylor site, the current Western Bus Garage site, are, if you will, spoken for. Those are the 2 real opportunities to sort of tip the balance. But to do so, in conjunction with WMATA on either of those properties is gonna, require an innovative approach that isn't necessarily just a market-driven approach, which best case is getting you that 8 to 15% kind of number, which in itself doesn't solve the problem. And finally, there's essentially almost 0 units of rental affordable in structured buildings right now along the Wisconsin Avenue corridor on the DC side, but there's more than a dozen buildings on the Maryland side, which are really work together. There's a little bit of naturally affordable housing within those buildings, but there's a bare minimum a couple dozen units out of thousands of units which have some sort of long-term affordability restrictions on them. So the need is very clear, and as you know, it's a high opportunity area that needs that rebalancing.
Thank you very much. Really appreciate it. And I'll turn it back to you, Chairman Mendelson. Thank you for the opportunity.
Thank you, Councilmember. I'm going to thank all the witnesses, and we're going to turn now to the Director of the Office of Planning. Thank you, each of you, for your testimony. And Anita Cozart, if you could come forward. I see you.
Good afternoon.
I hear you. Why don't you begin when you're ready?
All right, I am ready. Good afternoon, Chairman Mendelson, Councilmember Fruman, and staff of the Committee of the Whole. My name is Anita Cozart. I'm the Director of the DC Office of Planning. I'm pleased to be here on behalf of Mayor Muriel Bowser to share with the committee the activities and accomplishments of the Office of Planning during fiscal year 22 and the first quarter of fiscal year 23. Mayor Bowser's fiscal year 22 budget made investments that supported our efforts to deliver on the district priorities, to provide district residents a fair shot opportunity. To this end, our FY22 strategic goals have focused on implementing the policies and land use changes in the 2021 comprehensive plan through our place-based planning efforts. Second, accelerating land use and zoning activities that advance Mayor Bowser's goal of 36,000 new housing units and 12,000 affordable new units by 2025. Third, supporting efforts to reimagine and reinvigorate downtown. I look forward to sharing today about the significant progress OP has made towards these goals in fiscal year 22 and our plans for fiscal year 23. In FY22, OP launched, conducted, or completed 8 place-based planning efforts to implement the updated policies in the 2021 comp plan. But between July 2022 and February 2023, Council approved 3 small area plans that OP developed with community partners from Chevy Chase, Congress Heights, and Pennsylvania Avenue East. Each of these small area plans advances housing goals and supports equity and resilience through recommendations that are tailored to neighborhood needs. In summer 2022, OP launched 2 additional planning efforts in Rock Creek West to apply the land use designations established in the 2021 comp plan. The Connecticut Avenue Development Guidelines examine how building and public space design can support additional market rate and affordable housing in the Woodley Park and Cleveland Park historic districts. The Wisconsin Avenue Development Framework will recommend zoning that can yield additional housing in the high opportunity mixed-use corridor at key sites around the Friendship Heights and Tenleytown metro stations. Throughout 2022, both planning efforts have engaged community stakeholders through walking tours, surveys, and design workshops. Public review drafts of both of these plans will be released this spring. In fall 22, OP began working with community stakeholders to develop the New York Avenue Northeast Vision Framework, which guides the transition of this corridor from almost exclusively production, distribution, and repair use to a mixed-use area with housing, civic space, and other community amenities. Through a series of walking tours and a community planning day, OP launched the Ivy City Small Area Plan, which will consider how future growth and development of New York Avenue will impact this existing neighborhood with an emphasis on housing, health, resilience, urban design, mobility, and connectivity. In parallel with these 2 planning efforts, OP has begun work on a citywide PDR land use report that will evaluate market forces, explore trade-offs, and assess new approaches for addressing existing and future needs for PDR land in the district, much of which is concentrated along New York Avenue. Lastly, in January 2023, OP began work on the Nanny Helen Burroughs Corridor Small Area Plan in Deanwood. The Small Area Plan will focus on urban design strategies for opportunity sites that have new land use designations in the updated future land use map in the 2021 comp plan, and public realm improvements to enhance the pedestrian experience. We also expect it to include an updated retail strategy for commercial nodes along the corridor. Since the release of Mayor Bowser's housing goals in 2019, moving the district closer to 36,000 new housing units and 12,000 affordable units by 2025 has been a central focus of OP's work. A key component of this work is evaluation of applications to the Zoning Commission, which has been steadily increasing. In the 18 months since the enactment of the 2021 comp plan, the number of plan unit development and map amendment applications to the Zoning Commission have tripled compared to the previous 18 months. OP has also been developing racial equity assessments as part of case report development and reviewing all applications to the Zoning Commission with a racial equity lens. OP continues to advance updates to the zoning regulations to support market rate and affordable housing production. In addition to advancing place-based efforts and supporting zoning applications that increase the number of market rate and affordable units, OP's FY22 work focused on ensuring that all district residents have a fair shot at affordable housing, access to opportunities, and building generational wealth. In 2022, I served as the co-chair of the Black Homeownership Strike Force, which set a bold goal of 20,000 net new Black homeowners in the district by 2030, and issued recommendations to achieve that goal. OP also launched a project to develop an anti-displacement strategy, a 2021 comp plan action item, which we expect to share in 2024. OP continues to manage the district's historic homeowner grant program, which assists low and moderate income homeowners with the cost of repairing their historic homes. In FY22 and 23 to date, OP approved 31 applications for grants, totaling up to $577,000, including 26 grants to unit owners in the Kennesaw apartments, using the council's temporary multifamily building authorization. In December 2022, OP received an application from the Kennesaw Condominium Association for funding from the $1.5 million multifamily historic preservation grant fund, established in partnership with the Office of the Deputy Mayor for Planning and Economic Development. And we are currently working with the applicant to finalize an award. This will unlock significant additional resources for this historically significant building in the Mount Pleasant and Meridian Hill historic districts, and one of the first successful examples of Tenant Opportunity to Purchase Act in the district. In January 2022, OP awarded the first round of grants for the Streets for People initiative. This program provided $2.8 million of funding to business improvement districts and community improvement districts in the downtown to support recurring public space activation and reusable infrastructure. Between April and December of 22, the grant supported all grantees to sponsor over 100 activations. A pedestrian zone on 18th Street, coordinated by the Adams Morgan Partnership bid, welcomed over 60,000 guests in 3 days that enjoyed free programming that supported local businesses. The Golden Triangle bid conducted 37 events during the work week, which drew more than 3,000 guests to Farragut Square Park. The DuPont Circle bid included monthly recurring events such as the Fall Festival, which brought in over 5,000 visitors on weekend mornings when the neighborhood drew fewer visitors compared to weekdays. Streets for People grantees focused on spending dollars locally, prioritizing Black, Indigenous, and people of color-owned businesses, accessibility services, and cultural resources. This program will continue into 2023 and build upon the successes and to continue advancing downtown's economic recovery. As I had shared in my confirmation hearing, one of my key priorities as director is to enhance the accessibility, equity, and impact of OP's work across the agency's divisions. I'll now share a few concrete examples from FY22 about how we've applied those approaches to our work. Enhancing accessibility involves expanding and enhancing the ways that residents can engage with and inform OP's work. A key example of this was OP's technical support of the district's redistricting process. OP worked with the council's redistricting subcommittee and 8 ward task forces to conduct the realignment of ward, advisory neighborhood commission, and single member district boundaries after the release of the 2020 census data. This involved procuring and conducting trainings on the ESRI redistricting tool, which for the first time allowed any district resident to submit proposed maps to be considered during the redistricting process. Embedding and approaching racial equity as both a process and an outcome has been a key to OP's work. This also requires considering how the agency can improve our internal and external process to enhance the outcomes achieved as a result of our community engagement efforts and various planning activities. To that end, throughout 2022, OP participated in the Mayor's Office of Racial Equity's inaugural pilot cohort to develop a racial equity action plan for the agency. This plan charts a 3-year path with specific action steps to ensure that OP staff Understand and are committed to achieving racial equity, that OP's work contributes to eliminating racial and ethnic inequities, that OP meaningfully engages the community in planning processes, and that OP is an equitable employer. On February 11th of this year, OP held an open house to gain input and feedback on enhancing our draft racial equity action plan, which will remain open for public comment this spring to incorporate feedback with the goal of finalizing our racial equity action plan in late 2023. OP's focus on impact is guided by the understanding that disaggregated data, meaningful community engagement, and collaborative strategies to address displacement pressures facing many communities. Preserving housing affordability and avoiding displacement of longtime residents at the Kennesaw, a building that has stood since the 1970s as a symbol of tenant organizing, housing equity, and heritage of the Latino community, is a project that OP is committed to helping through substantial grants that will offset that extraordinary cost of repairs to make the building watertight, remove lead paint, and restore its historic facades. In FY23, OP will continue its work to implement the 2021 comp plan, advance the mayor's housing goals, reimagine downtown, and prepare for the 2025 comprehensive plan rewrite. At the same time, we will take every opportunity to improve the accessibility, equity, and impact of our work. Now I will briefly highlight several additional projects that were initiated this fiscal year. In the coming months, OP will launch 2 additional place-based planning efforts that are part of the 21 comp plan future planning analysis areas. First, a public life study for Foggy Bottom and West End will identify needed transportation improvements and explore access to public space in the neighborhood. Second, a forward-looking and aspirational vision for the North Capitol Crossroads will chart a path to eliminate obsolete highway infrastructure at the intersection of Irving Street Northwest and replace it with a vibrant civic center that advances district priorities for housing affordability, environmental sustainability, economic development, and job creation, as well as racial equity. A key component in rethinking the district's public space is ensuring that the culture and history of these spaces represents the district's population. To that end, in FY23, OP launched the first year of the Commemorative Works Technical Assistance Program. Through this, we've partnered with the Commission on Arts and Humanities and Main Street organizations located in wards 5, 4, 7, and 8 to identify commemorative subjects, locations for commemorative works, and to develop a concept design for a commemorative work in their ward. Concept design will be submitted and reviewed by the Commemorative Works Committee in the fall of 2023. This program helps to advance the goals established in the Diverse Washingtonians Act, specifically to highlight the lives and contributions of Black Washingtonians and other people of color. In addition to advancing commemorative works, OP will launch a new series of community heritage guides as part of an updated version of the Historic Preservation Office's Ward Heritage Guides that will focus on the district's historical development, historic properties, and other sites in Black and people of color communities. Additionally, OP will launch a downtown public realm plan that will create a vision and strategy to transform downtown streets, alleyways, and sidewalks into vibrant and active public realm that will attract workers, residents, visitors, and catalyze economic recovery, as well as support local business development. OP has been working with agency partners, including the District Department of Transportation, the Office of the Deputy Mayor for Planning and Economic Development, as well as the Downtown and Golden Triangle Business Improvement Districts and other stakeholders to build on the momentum of ongoing efforts to enhance downtown public spaces. Finally, OP will be focused on and supporting the mayor, advancing the mayor's comeback plan with a particular emphasis of the goal on the goals of adding 15,000 residents to the downtown population, eliminating key amenity gaps across all neighborhoods, and increasing access to opportunity for all residents. In conclusion, FY22 was a productive year for OP. I want to take a moment to thank our staff who've been critical to this agency's success. I also want to thank the residents who have engaged with with OP on our various planning efforts. And for residents who are interested in learning more about our work, please visit us at planning.dc.gov or give us a call at 202-442-7600. Lastly, I'd like to thank this committee for the opportunity to discuss our work. We look forward to working with you, Chairman Mendelson, Chairman Fruman, or Councilmember Fruman, and other members on the committee for the continued progress for the District of Columbia. I'm happy to answer any questions you have at this time.
Thank you, Director Cozart. Put me on a 10-minute clock because we will have at least one round with council members. Director, the comprehensive plan adopted 2 years ago requires a study on industrial land to be completed by January 2024. Is the Office of Planning on track to complete this study on time?
Yes.
In response to the pre-hearing questions that we sent you, question 39, you provided all planning currently underway in connection with the comprehensive plan. In last year's answer to this question, sometimes we repeat the questions and then we can compare 1 year to the next. You listed under each or for each a completion date and then a quarter that you expected to submit the plan to the council. This year, you only listed the completion date. Are we to assume that the expected completion date is the same as the quarter in which you expect to submit it to the council? I believe that something like the Wisconsin Avenue Development Framework is not something that gets submitted to the council, but something like the Ivy City Small Area Plan would be submitted to the council. So is the expected completion date the same quarter that it will be submitted to the council?
Yes, that's correct.
All right, that means you'll be completing it early in the quarter and submitting it to us later in the quarter. We asked you a question 15 about MOUs, and in the answer, again, question 15, it was listed an MOU with DEMPED to, quote, support a grant to a multifamily building, unquote. I believe from your testimony and our knowledge that this is related to the Kennesaw project. What is the status of this? And in your testimony, I think the total amount that we have available is over $1 million, but I think you listed a smaller number of units that had received the grants. So could you explain the status of this?
Sure. So we are leveraging for the Kennesaw, we're leveraging both the multifamily grant program as well as historic homeowner grant programs, because there are residents, homeowners inside of the Kennesaw that would qualify for that, the historic homeowner grant program, given the council's legislation to allow that to include multifamily homeowners. Does that help to clarify?
What were the two programs again? Historic homeowner grant program, and what was the second one?
The second one is essentially a multifamily grant program. This is the one that we have in partnership with the Office of the Deputy Mayor for Planning and Economic Development. It's
the one that
recurring.
Yeah, that the council.
That's right.
Okay, I can't see where it was in your statement, but it's
Let's see if I can find it.
Wasn't all of the units. I think it's on page 4. OP approved 31 grants. No, that's for the total, including 26 grants to unit owners in the Kennesaw apartments. 26 is not the total number of units. So
that's correct. That's the total number of units in the apartments, and there were applications that we received outside for the historic homeowner grant program that were not for the Kennesaw. And so we made awards and approvals for that.
But the 26 are for the Kennesaw, and there are more units than 26 at the Kennesaw.
That's correct. That's based on eligibility and people submitting applications and documentation related to that.
So are we going to see balconies falling off, or do we think gotten ahead of the problem there at the Kennesaw?
So what we're trying to do right now is make sure that we have all of the documentation that's needed to approve the $1.5 million grant application so that work can begin as soon as possible. Our anticipation is that we'll be able to get that documentation and make those final approvals in the next 1 to 2 months.
I'm not being clear what I'm asking. So 26 units is not all of the building, but all of the building has an issue with, I believe it's the balconies. There might be some other exterior treatments that are at risk. So do we have the entire building taken care of, or are we still like struggling with this piecemeal?
So through our resources, we're supporting the low and moderate income tenants, and we're partnering, and that helps to support the work that the entire condominium would need to do. And so that's the contribution that we're making to that. To our knowledge, based on the conversations that we've had with the representatives there, this is going to be go a very long way towards helping to make the restorations that are necessary.
Okay, I think that's what I was looking for. That it will go the distance.
Yes,
coupled with private resources at the building.
That's correct.
Rebecca Miller in her testimony commented, and I think you might have heard me ask her about this. I'm looking at her statement. Extension of the program this past year to a single co-op condominium building with well-publicized external maintenance issues, the Kennesaw has prompted the owners of other multifamily historic properties to ask for equal treatment. There needs to be a wider conversation about the use of public funds for the restoration of privately owned historic resources. I said to her, well, let's have the conversation. So what's your contribution to the conversation?
So our contribution is that we would be delighted to see Ms. Miller's proposal around that, and that we're also doing as quickly as we can, while we're also trying to administer the program, also have some carve out some time to think about what's next, because certainly we do have experience and lessons learned that we would like to apply to a new iteration of the program.
The one of our pre-hearing questions asked about lawsuits, and you are listed as a party to 2 lawsuits, the Masonic Temple development and the comprehensive plan. These lawsuits were both ongoing last year when we held this hearing. I understand there was some movement on the Masonic Temple case and that the district has appealed the ruling. Has there been any movement on the comprehensive plan lawsuit?
No, there has not been.
And I'm guessing that OP is not closely involved with the litigation, if that's the Attorney General?
Yes.
Anything else that you could say with regard to the lawsuits and their implications on your work?
So I think for the comprehensive plan one, we are proceeding to implement the comprehensive plan. We're confident that the engagement and the work that we did on the comprehensive plan, and certainly having had it blessed by council, gives us a mandate to move forward. So we're watching any progress, but think it wise to continue to move forward with the actions that are there in the comp plan. Similarly, we're watching the outcome of the Masonic Temple and whatever comes from what the courts have to say about that, we'll continue to take the steps that are recommended by the court.
Changing subjects, it appears from your Schedule A that you have about a dozen current vacancies. Is that correct?
That is correct. That is correct.
Which is about 15%, which seems on the high end. Is there something going on here?
So it seems I would say it's probably a little closer to 10%. What it is not reflected there, and isn't reflected until someone shows up on their first day, is that we have made a selection on 2 of those vacancies. We've and issued offers to candidates. We have interviews as active as this week for 4 of those positions, and 5 of those positions will be posted in the next 3 weeks.
How long have those 5 been vacant?
We can provide you with that information. It ranges. It ranges because some, just in the last 2 months, or one of them in the last 2 months. One of them has been vacant since we received it in the beginning of the fiscal year. So it's, we can give you some a breakdown of that.
If you would, I'd appreciate that. But
Sure.
why would, if a position's been vacant since the beginning of the fiscal year, why are you only now about to post it?
So what I would say about that is essentially we've been trying to move things through the queue as quickly as we can. Some positions have required more postings because it is a very difficult job market. We've conducted interviews, and after interviews had candidates immediately after say to us, I'm withdrawing my application because I got an offer from someone else. And so we've missed out on that. That's happened on a couple of occasions. So it's taken us multiple rounds of interviews for some of these positions. And so it's just a matter of trying to move each of the positions through the process with the staff that we have.
So you said there are offers to 2, interviews with 4, 5 to be posted. That adds up to 11. That's the number of vacancies?
Yes.
Okay, and you'll provide some more information about that.
We will.
I have a few more questions, but I'm going to turn to Councilmember Fruman.
Thank you very much, Chairman Mendelson. And thank you, Director Cozart, for the promotion. So I'm going to ask about a couple of different things that you already talked about in your testimony, but just to try to get a little bit more detail. I think you referred to the Wisconsin Avenue framework and the Connecticut Avenue framework, that you will be out with public drafts for those in the spring. Is that right?
Yes.
Which could be a month from now or could be 4 months from now. Are you optimistic that it'll be soon, or are you want the protection of the end of that 4-month period?
I am optimistic that it'll be soon.
Okay, that's terrific. In your description of those, you referred to Cleveland Park and Woodley Park, and maybe I'm missing it, but is Van Ness covered by the Connecticut Avenue framework?
It does not go that far north.
It does not. So we have Chevy Chase, that we have the small area plan, then we have Van Ness that is not covered by a planning process at this point.
We're not undertaking one at this point now.
Okay, but in the comp plan, the area covered covers Van Ness, but there isn't a current plan. There isn't a current process going forward around Van Ness.
That's correct.
That's interesting. Why was that choice made, not not to include Van Ness because it becomes a kind of island there between the other planning processes.
So part of coupling Woodley Park and Cleveland Park is because of their historic district status.
Interesting.
And so we wanted to kind of couple with like.
I see. And one of the things that is striking, I don't know if you will have heard me talk about Friendship Heights on the with the public witnesses, that the big opportunities for affordable housing in Friendship Heights are the Western Bus Garage site and the Lord and Taylor site. And so we're going to need to have a strategy for how we're going to achieve that, because WMATA, which is, likely someday to own both sites, is not in the business of affordable housing. So they can't, in a sense, spend their resources to support affordable housing over what would be required. So we're going to have to figure out a way to make sure that we do better than IZ. Do you share the view that we need to do better than IZ on those sites?
Yes, and there are sets of additional tools that I think that we can certainly tap into and should look to tap into.
And what are some of those tools that I should be thinking about and working with you on?
So certainly thinking about the high needs area tax abatement, that's one that's an important one to try to take advantage of. And there may be others that we can think about that may apply to the development, but we can also think about it holistically about what's possible in terms of affordable units in the broader area. And so that's one of the things for the development framework that's important, is to think about other tools that would.
Well, let's stay together on that, because I want to make sure that we get to a result where there's significant affordable housing at all levels on those, what are maybe the highest opportunity sites in Ward 3 at this point. So it's going to be important to me to work with you and others in the administration to get to a good result in those places. One of the things that's striking, and I've walked every street and spent lots of time in each of the different communities, is that they're all different. So you have Woodley Park and Cleveland Park, and they're one, they're not identical to each other, but they actually have some similarities in the sense that historic districts, not a lot of land to work with, so it gets tricky about how much you can put there without imposing on the residential neighborhoods next to them. Friendship Heights seems like a place where, except very close to the residential neighborhoods, you could put a lot. Chevy Chase is one that you're in the middle of now. And I don't think I like change, and I think that it's important that we add density. But Chevy Chase is one of those ones where it's not on a metro stop. And so it's different than a Friendship Heights or a Henley Town or a Van Ness in terms of how much density is appropriate to add there. And I don't know whether as you're thinking about that, you're sensitive to those differences. I hope that as we go through this process, that we do a lot in all places, but that we be very sensitive to the differences of the different commercial districts. Do you see it that way? I'm curious how you react to that view on my part, that there's no one size fits all for these different communities, and that we need to be particularly careful about relationships to the residential neighborhoods.
I agree. And I would just point to and encourage you and your staff and those who are listening to really look at the Chevy Chase Small Area Plan and what its recommendations are, and look at it alongside it. We have for both the Connecticut Avenue Development Guidelines and the Wisconsin Avenue Development Guidelines shared some renderings and some scenarios that show those differences between the key opportunity sites. What are we thinking about in terms of relationships to the surrounding areas? There's different approaches to treatments there. So just encourage folks to look at them alongside, because we did try to highlight those.
Yeah, and it's a super tricky thing, but in the Chevy Chase Small Area Plan, people put in a ton of work. I mean, and really, they were in front of everything else. I think hats need to be taken off to the leadership in Chevy Chase that started the Small Area Plan process before the comp plan called for it. And then they came out with their recommendations about what should be in the Small Area Plan, and then you guys tweaked it in different ways. And so there can be differences in the Small Area Plan as passed by the council. And what was pretty clear from the community coming through, it's not huge differences, but I'm going to have my eye on those differences as we move forward. As passed by the council, it does. That's the law. And as an example, one of the things that I wonder about is the call to maximize, and I think that's a thing that the Office of Planning might have added in. And when I think about the Chevy Chase Civic Court as an example, there's a ton of things that we need to do that are all in that Small Area Plan related to transitions to the neighborhood, buffers, preserving enough green space, and then having the library and the rec center and adding housing. And what does maximize mean in that context with all of those different factors? I want to be careful. I want to build something that is very significant at that Chevy Chase, but overshoot. And I want to be careful that we not overshoot. So that's not so much of a question, but I'm watching this process and really want to make it succeed, but also want to be very careful not to overshoot. I guess I'd invite you to react to that.
My reaction is that we'd be delighted to continue to work with you and your staff today.
All right. All right. Last thing in a different subject. The Black Home Ownership Initiative, I just think is a really, really important one. It's a tricky one legally given, but I'm curious what you see as the key recommendations and what you see as the key recommendations that we can put to work in Ward 3, because it's very important. I have made it a priority to try to encourage African Americans to live in Ward 3. We have a history of expulsion and then segregation, and I think we have an obligation, and everyone benefits when we're living in diverse communities. So we want to change that. But how can this program help us?
So there's a few things that have been recently announced, particularly for existing Black homeowners who need help as it relates to kind of estate planning and thinking about how to pass on their home and their wealth to the next generation. We have existing programs and newly launched programs at the district that could be helpful. So making sure to get the word out about those so that folks can take advantage of that. That's important. I think the other key piece around that is making sure that we have more housing supply that is built at a level that's affordable, given that Black households in the district just have less income overall than their white counterparts. The other piece that's really important is making sure that folks are able to take advantage of things like the home ownership or the home purchase assistance program, which is now up to $202,000 of assistance, which opens up certainly opens up more opportunities than previously in area that you represent. I'm happy to kind of organize a more formal conversation to talk about the nuts and bolts, certainly with our other housing partners that are key to the Black homeownership strike force recommendations.
Well, I appreciate that. I have one more question, Mr. Chairman Mendelson, if you want me to go, I can go, or I can wait. Okay, thanks, Hon. One of the things that you talked about was promoting quality amenities in all of our different communities, which I think is a really important thing. And for me, the thing that jumps off the page around that is schools. And there's two sides to that, to the schools issue in your world. One is in Ward 3, where we have, overcrowded schools. What does that mean for planning? And what role does your office play in that? And then elsewhere, where people do not have as much confidence in their neighborhood school, which is very important to the success of a community. What role do you play in the advocacy for not just that we need a supermarket here, but we also need to be investing in our neighborhood matter of right schools that are linked to the community as part of ensuring quality amenities in every part of the city?
So in terms of the latter, I would say there's not really a formal role for the Office of Planning in the duties that we carry out related to what happens with those neighborhood schools that where folks don't feel quite as confident. Certainly, what we can do in terms of making sure that there are other aspects of making every community a community of opportunity around retail, around other civic spaces and public space, and the quality of that, we will make contributions to that, certainly. As it relates to understanding what's happening with a given school, really, especially around capacity and facility planning. Our role there is to really provide through our the functions that we have as a state data center, really collecting and understanding population trends, shifts in population trends that may impact near time and long time next steps as it relates to facility planning. So it's really that kind of technical role that we have there, which is relevant to the decision making of the Deputy Mayor for Education. And we're actively sharing that information with them to make sure that their plans are well informed and most robust. Well informed, certainly, as it comes to population forecasts.
Yeah, so I hear you on that, and I sort of expected that it's sort of not your lane in many ways, but I would submit that maybe the most important thing for families when they're thinking about living in the district or living in a neighborhood in the district is their confidence in the schools, and so that it really does affect your work, and your voice at the table around schools issues could make a lot of sense. It's not part of your mandate today, but I think that it's worth thinking about the interplay of the things that you're doing and where the schools are at and how they can reinforce each other. I'd just add to your plate with that as a thing to think about and for a follow-up conversation. So thank you very much.
Sure.
Thank you, Councilmember. I have several more questions. Director Kozar, there are currently 4 vacancies on the Historic Preservation Review Board. I said 4 vacancies. There are 4 seats, 3 of which I believe are vacant, and 1 of which is occupied by Mr. Horsey. Mr. Horsey is serving, but he is nearing the end of his holdover period. My understanding is that he was in the process of reappointment, but that MOTA, Mayor's Office of Talent and Acquisitions or Appointments, has gone silent. Do you know what may be going on with filling out the board's membership, given that it is barely at a quorum?
I don't have information on what you said that MOTA has gone silent, but I'm happy to follow up with MOTA about that.
Would you follow up with me after you follow up with
Yes, sir.
my understanding is that Mr. Horsey is well regarded and he is an architect, and losing him because of the end of the holdover period would put the board at exactly a quorum. Nobody could be absent. And as I said, our understanding is that MODA had reached out to him months ago and he submitted required paperwork and nothing further has happened. And so, all right, you'll get back to us on that.
Yes.
I had earlier asked a question of Ms. Barden at the Office of Zoning. This is what I asked her. Your testimony touched on additional changes made to your racial equity tool that is required by the comprehensive plan. This sounds like a lot of data-driven work. Will your budget reflect that in the form of additional staff, or will you be doing this work within your current resources? And her answer was, well, most of that work, at least with the data, will be done by OP. So will this require some changes in your budget?
We do not anticipate it requiring changes in our budget. And I'll just say that we have some information available at opdatahub.dc.gov, and we have a racial equity section that has a lot of the data that was referenced by folks who gave testimony around housing cost burden. This data is disaggregated by race. You didn't ask me that question, but I thought it appropriate at this moment.
And what's that website address again? OP Data Hub?
OP Data Hub, all one word, .dc.gov. And there is a racial equity at the very top. There's a racial equity section. And we're also happy to send that link and that specific, the link to that section as a follow-up as well.
Okay. You touched on this in your statement, talking about the mayor's recovery plan for downtown. In your testimony, you spoke very generally about supporting 15,000 more residents and fill out one other, I don't have it right in front of me. And I feel like finding what you said. It's focused on supporting and advancing the mayor's comeback plan with a particular emphasis on the goals of adding 15,000 residents, eliminating key amenity gaps across all neighborhoods. Well, that's not downtown. Increasing access to opportunity for residents. That's also citywide. My question focuses on downtown. In your responses to our pre-hearing questions, I'm not sure you spoke to this, but one of the mayor's expressed priorities is to tweak the Hyde Act. Is he also planning actively doing any planning work relating to the Hyde Act?
We are working to understand what are some of the kind of economic conditions, market economic conditions of downtown, understanding what are the urban design character of downtown, and in particular, and also trying to understand kind of the desires related to kind of public space. Is it relates to sidewalks, streets, and alleys, and how that functions? And so it's really kind of some urban design analysis. There's also, and that incorporates historic preservation and view sheds, et cetera. And then also looking at the pieces around kind of market economics, just to understand what's happening with our downtown and what that might mean in terms of what we can expect as it relates to opportunities to expand and get to that goal of additional development downtown and additional 15,000 residents.
Well, when you say additional development downtown, are you speaking of development other than residential?
There could be development other than residential, because certainly the land use allows for it, but in many ways, what we're looking at is ability to bring additional residents downtown.
Additional residents. Well, I ask because non-residential development, why do we need more non-residential development right now downtown? There's a high vacancy rate in office. There's a vacancy rate in retail. So I would think that the comeback plan ought not to be looking at non-residential development. Do you agree?
I agree. The focus is not, I guess I just wanted to clarify that it's not putting some kind of moratorium on non-residential development. Obviously, the focus of that work is around bringing additional residential development.
And so the work you're doing is looking at economic conditions, marketing conditions, urban design analysis, historic preservation, view sheds, stuff like that.
Yes.
But isn't there a time period for the comeback plan? And by that, I mean something like next 2 to 3 years?
The comeback plan duration is 5 years. So 2028 is our year goal.
Okay. And as a practical matter, is development possible downtown in 5 years?
There is some development that's certainly possible, and some, office to residential conversion that's already underway, broken ground, that kind of thing that can be realized. Certainly the 5-year kind of one reference point for the 5-year time horizon is that is the time horizon that the Federal Economic Development Agency kind of puts on a comprehensive economic development strategy, of which the comeback plan is. So it's not intended to say, if we don't get it by 2028, we're not going for it. It's to set goals for 2028 and to work towards achieving those, and understanding that that's kind of the cycle that we're working with.
I'm just trying to understand, because the goal is 15,000 more residents downtown by 2028. And I'm just thinking in terms of residential. When I said development, I wasn't thinking of office to residential conversion. I was thinking of tearing down a building and building a new one. There's not a whole lot of undeveloped space downtown, if we're talking about downtown, and I think we're talking about downtown, right? There's not a whole lot of undeveloped space. So the only way that you would get residential would be either conversion, which I guess is a form of development, but I don't really think of that as development, or you'd have to tear down a building and build a new one.
That's
do
correct.
I have the whole
Agreed.
universe there?
Agreed.
Okay, and I'm not quite getting how you could, as part of the comeback plan, to get 15,000 units, and this isn't something you said, I'm sort of arguing with something that hasn't been said here. I'm not getting how within 5 years we could tear down, find a developer, find an investor, a developer, a development plan, tear down a building, get the zoning approvals and build a new building all within 5 years. It just doesn't seem practical to me. Agree?
I would say that the district, we're committed to putting as many incentives, and both trying to figure out, are there ways that we can streamline some of the processes? You raised this in the discussion with the Office of Zoning, exploring some ways to kind of shorten some of the timelines that property owners are experiencing as it relates to the review process. And so certainly that's a part of it. A 5-year time horizon is aggressive. And something
aggressive.
that yes, yes, I would say it's aggressive, but that's, I think, what is expected given the challenge that we face around the vacancies, the key points that you raised around the vacancies, and what we've been hearing from stakeholders downtown is that they want something to be bold and trying to really bring us to the comeback that we're looking for.
Well, I would probably use the word impossible rather than aggressive if we're talking about new development. Even the conversions are going to be difficult because a lot of buildings, the floor plate doesn't lend itself to residential, but that's a different issue. But to attract investors, to get the zoning approvals, to have a development plan. A development plan comes before the zoning approvals, to actually build it. And because I just have some impatience with this, to talk about doing this in the context of amending the Hyde Act, which is going to require Congress. And I think stop one is going to be NCPC, and I don't see them favoring it. I don't, it's just impossible to do that within 5 years. And I think this is counterproductive talk to suggest that the Hyde Act is the culprit here, or that the Hyde Act needs to be changed. My plan was, my intent wasn't to give a little speech, but I'm just not seeing in 5 years, in a 5-year plan, that development is a viable strategy. I think there are other ways, encouraging the conversions and looking for other ways to attract people downtown, like activating, which you talked about in your testimony, more activation, events, whether we're talking about cultural events at museums and theaters, or cultural events and other activities which could be on the streets, like the barbecue festival in the summer. Events like that to bring people downtown, to make downtown more attractive, to make people think, hey, this is a cool place, I want to live here. And then that creates market pressure for residential development. Let me check with staff, see if I have any other questions. I don't have any other questions for you. You're going to get back on filling the vacancies, and you can get back on the filling the vacancies in your staff, and separately what you can find out about filling the vacancies on the Historic Preservation Review Board.
Yes, and I'll also send a link to the Open Data Hub.
Yes, and we will see you, I believe, on March 28th.
Yes.
When we all find out what your, do you know what your budget is for next year?
I'm excited about the conversations we'll have about the budget.
Okay, that's what I figured. Thank you very much.
Thank you.
We're going to turn now to the Department of Buildings. I'm going to call, we have a lot of witnesses here. We have 46 witnesses, so I think I will call the first 20 and then the remainder, and then we will go to the director. I hope witnesses will be mindful of the clock, and so that everybody has a chance to testify. We do have interpreters available, and in order to access interpretation, if you want that, there is a icon at the bottom of your screen. Everybody who's here has a screen because this is a virtual hearing, and that icon says interpretation. You click on that, and if you want Spanish interpretation, you would click on Spanish. That's the way the interpretation works. We have interpretation, as I said, for this segment of the hearing, because that was requested timely. So I'm going to call the first 20 witnesses. Kathy Zeisel, who's Director of Special Legal Projects at the Children's Law Center. Alicia Dantzler, who's with AFSCME Local 2743. Abel Ameni, I apologize if I mispronounced your name. Commissioner Trupti Patel, who's an ANC commissioner with ANC 2A03. Eleni Christidis, who's with the Legal Aid Society of the District of Columbia. Darlene Jackson, Janet Phoenix, who is an assistant research professor at George Washington University. Matthias Palstian, who is with the Sierra Club. Max Broad, who is listed as leader, Citizens Climate Lobby, DC chapter. Cynthia Davis, who's executive director of the DC Family Child Care Association. Teresa Aspinwall, who's executive director of the Multicultural Spanish Speaking Providers Association. Irma Sewell Morales, who's owner of Little Blessings Child Development Home. Maria Paola Miranda, who is former owner of the Washington Family Child Development Home. Julia Ruiz, who is former owner of Child Development Home. Vanessa Bertelli, who is listed as a public witness. Margaret Stevens, ANC Commissioner, ANC 1C05. Doug Siglin, who is the DC coordinator with Chesapeake Climate Action Network. Rebecca Miller, who's with the DC Preservation League, and David Maloff. Check to see if everybody's been admitted. So folks log on, get into the waiting room, and then they get a message to click to enter the hearing room. There are several people who have not clicked, so you have to click to enter. Otherwise, we'll miss your opportunity. Ms. Zeisel, you are first, and good afternoon.
Good afternoon. My name is Kathy Zaiza. I am the Director of Special Legal Projects at Children's Law Center and a resident of the district, testifying today on behalf of Children's Law Center. Our more than 100 staff work with DC children and families, community partners, and pro bono attorneys towards a future where every child can grow up with a strong foundation of family, health, and education, and live in a world free from poverty, trauma, racism, and other forms of oppression. I'm not going to share a bunch of stories like we often do. Instead, I'm going to focus on the concerns we have about the lack of culture change and plan change at the agency. So far, DOB is largely the same personnel and policies moved from DCRA under the same logo, and we ask the council to help with oversight and work on that change that's needed. If KPIs are what the agency uses to hold themselves accountable, then DOB's failure to expand their KPIs to acknowledge their new, more focused roles is extremely discouraging. The single new KPI used for abatement is written in a way that is hard to interpret and hold the agency accountable. And in my written testimony, I provide some suggestions for areas where DCRA struggled and DOB really should have KPIs to hold themselves accountable and see if they're improving healthy housing. In establishing the agency, the council provided funding for 29 new inspectors. The agency's already reprogrammed one of those positions to an HR role. We're also concerned about the perspective on enforcement shared by the director in his written testimony, and that we've heard from the agency saying that other agencies seem to be responsible for the lack of enforcement by DOB. We need to see new strategies and new approaches by the agencies towards enforcement. DOB is statutorily responsible for housing code enforcement and should be a leader in this area. Instead, what we see from the agency's new dashboard is that DOB and DCRA before it has only collected $317,000 of the $66 million in fines assessed in FY 2021 and 22. And there's no information on whether any liens have been placed available on the dashboard. Proactive inspections should be a core part of the strategy as well. We don't see any changes that have been proposed or made there. We urge the council to pass the Proactive Inspection Program Act of 2022, and we look forward to working with you to improve that bill even further. I also want to draw your attention to concerning data around the lack of abatements obtained by DOB in their current housing code process and the lack of any changes to that process. In FY 23 so far, there's been 2,900 inspections with 620 abatements. Considering that most repairs are supposed to be within 30 days and the abatement data is largely self-reported abatement verified through photographs, that's a concerning rate of abatement and should have led the agency to revisit their procedures, but it didn't. We asked the council to call for more and better enforcement to ensure that DOB is the leader in healthy housing, healthy and safe housing in this city, and that it coordinates with the other agencies doing healthy housing work. Thank you.
Thank you, Ms. Seidel. Felicia Dantzler.
Yes. Good afternoon, Chairman Mendelson and committee members. My name is Felicia Dantzler, President of ASME Local 2743, and I represent over 90 members at DLCP. Currently, Labor has only one member detail at the Department of Buildings. As this committee is aware, as of October 1, 2022, DCRA split into two agencies, and last year, most of my members worked under the direction of Director Chopra. Last year was no different from previous years of how my members have been treated under the leadership of Director Chopra, who has led the way to cause hostility, retaliation, and rebuke for union members who exercise their union rights. Since Director Chopra's charge, there has been a mass exodus of employees. Labor noticed that it was losing members in the Consumer Protection Unit and Licensing Division, and the agency was not replacing employees, but adding work to those who remain. Keeping in mind, Director Chopra was appointed in 2019, Labor reviewed DCHR's employee records and learned the following. In year 2019, the agency had 6 separations. 2020, the agency had 31 separations. 2021, the agency had 68 separations. And in 2022, the agency had 70 separations. To date, a total of 173 separated employees. Certainly some separations came by way of retirement, death, or termination. However, Labor believes these individuals represent a small portion, and Labor believes many left the agency due to poor management, compensation issues, lack of appreciation, or poor agency culture. More so a mixed match with their values and what the agency values. The biggest concern is how these separations impact the agency. The positions vary, however, it appears the agency gutted its IT division and legal division. The tenures at the agencies range from 3 months to over 10 years. We must question why so many separations and what can be done to reverse course. The agency falls flat with providing processes in place for applications and on how to apply SPO and non-SPO licenses. The current system is not end-user friendly. For instance, documents larger than 1 megabyte cannot be uploaded, and those documents that are spec qualified can only upload 1 document at a time. The renewal period is fastly approaching March 1st through May 31st of each year, and there are over 6,000 officers who would need to be renewed in a 90-day period. The current system will surely impact processing times and possibly jobs. Last year, the agency had an email address that applicants used to send their application and documents, and during that time, there were approximately 5,000 emails waiting for action. Upon information and belief, currently there are 3,000 emails that remain. Labor has also learned the agency has stopped processing these applications, although applicants paid for a service. These applications date back from year 21 and 22. The applicants have requested refunds, and it is not clear if refunds were ever given. However, management has told my members to not let the applicant know that a refund can be had. In closing, with the implementation of 2 separate agencies, Labor is now rid of Director Chopra's gaslighting, double talk, failure to accept responsibility, and failure to foster a working environment where employees and supervisors are encouraged to prosper and grow. Labor is pleased that Director Chopra no longer has authority over his member, and he is now AFSCME's concern. Thank you.
Thank you. So Ms. Dantzler, you represent, or your local represents the employees at the Department of Licensing and Consumer Protection, but not at the Department of Buildings? You're on mute.
Yes, sir. We have only one member detailed to the Department of Buildings.
All right, thank you. Abel Ameni, and I'm sure I mispronounced your name, and I apologize.
No, actually, that was quite good. Thank you so much. Hi, like you said, my name is Abel Ameni, and I live at the 500 block of Longfellow Street in Brightwood Park, a neighborhood that has historically been underserved by the district. I'm coming here to testify before you for the Department of Buildings, not so much specifically about the department, but the underlying codes that they are supposed to enforce. The issue particularly that I'm here to speak about is the fact that my apartment, and I'm sure many in my building, have no kitchen exhaust. So that means that when there is any cooking going on, that there is no ventilation to the outside. Now, when you hear that, I think everybody would understand immediately that that is a problem. And the first thing that comes to mind is, wait, that has to be a code violation. And Department of Buildings should be involved. And I just want to raise that I've done that. I have, called for an inspection, and 2 inspectors have come to this building, to my apartment to check and see this. And both have informed me that it is perfectly within our code for such kitchens in a very small spaces where the kitchen is theoretically within small spaces, that the code doesn't call for this to have kitchen exhaust. And I mean, I am not an expert on this, but I think most people will understand that this is unsafe. On top of that, my building uses gas stoves, which further exacerbates the issue. Buildings around the region have been blowing up, and lack of ventilation is part of that, and the toxicity from all of this is also involved. So the building code specifically that I'm speaking about is the DC version of the mechanical code, which is adopted from the International Mechanical Code for Buildings. Specifically, section 505.1 has a subsection, a paragraph 1, which is an exception to that, which allows for an exception for a ductless, meaning no exhaust to the outside. So a hood system that basically takes the air in and then pushes it back out into the interior of the building, into the interior of the apartment. It makes an exception for that for range hoods that have been labeled as functioning as ductless. So I'm here to advocate for striking that entire paragraph, that entire exception, and to require, I know that there might have to be some time to allow for this, but to require that all range hoods have exhaust to the outside and have fresh ventilation. That's basically my testimony. Thank you so much, and I'll be submitting this as written testimony as well.
Thank you, Mr. Ameni. And yes, I was going to ask for you to submit your statement. Commissioner Trupti Patel. Is she here?
Chairman, I'm always here. I got to make sure I keep you on your toes. You know this.
Well, I'm sitting, so.
All right. Well, pleasure to see you, Chairman, as always.
Likewise.
Happy New Year. I haven't seen you this year yet, so I hope to see you in person one of these days so I can actually properly wish you. But good afternoon, Chairperson Mendelson. I appreciate you holding this oversight hearing so that I may enter these comments into the permanent record. A third-term ANC commissioner that represents 2A03. For the duration of my entire tenure, there have been numerous issues plaguing ANC 2A03, such as vacant and blighted properties, illegal construction, and illegal weed dispensary. Residents of 2A03, along with myself, are incredibly frustrated by the lack of urgency by the former Department of Consumer Regulatory Affairs, DCRA, which has now been broken up. I'm hoping that the Department of Buildings can address these issues. I can hope. Nearly 3 years later, we're still dealing with it. The same multi-unit building that is Circle Arms has also had multiple 311 requests entered in by numerous residents about illegal construction. Somehow that fell through the cracks and the building once again was able to get away with bad behavior. However, just a few months ago in 2022, the DC Office of the Attorney General won the largest settlement against Darrow Management in US history. With all of these numerous violations, how come DC agencies are failing to act? I have residents who feel more and more angry with DC government due to the lack of response and urgency to the legitimate concerns of safety that have been flagged in the last few years. I'm really hoping that it won't take an act of violence that results in the loss of life for a DC agency and the DC Council to act. There is a bit of bright news, as I used to have 2 vacant and blighted properties on the same block. It's now down to 1. Hooray for small victories. The one remaining property, 2505 I Street, is still the one that manages to really get under the skin of my neighbors. At this point, the owner is gaming the system and absolutely counts on the fact that the fines are dissolved/waived due to age and economic status. A dangerous gas leak reported by neighbors to the fire department prevented a great tragedy. Yet to the frustration of surrounding neighbors, there is still no traction on this issue. Neighbors have consistently pleaded with the homeowners to maintain the property for health and safety reasons, and it continues to fall on deaf ears. Another property that is not being kept up to maintenance wise is 920 Snows Court and is better known as Nash Staple. At one point, the fire department put out a notice and surrounding residents are expressing concern over the rate of deterioration of the structure. The issues I'm amplifying have impacted my neighbors' quality of life for many years. They're understandably frustrated by the process, the rules and regulations that DOB must follow. I'm hoping that my testimony will be able to get some traction and progress for neighbors having to deal with this for so many years. Thank you for the opportunity to testify. I'm glad to answer any questions that you have. And just Chairman, I just really want to say thank you for your advocacy and leadership on vacant and blighted properties and for just listening to the residents of 2A03. They do believe you have your back. They are asking that you please continue to have their back. There is very serious anger and frustration. Snows Court is, facing a possibility of their property, undergoing severe damage just due to the lack of oversight from various agencies. They're begging. I have a neighbor who's watching his foundation sink into the ground. And I am just really worried that this entire area, that is the historic district, it's a segment of the historic district, is going to literally cave into the ground. So that is the reason why I'm here before you today. So anything you can do to help us, we would really appreciate it. Please let me know what I can do. I'm more than happy to continue to testify, send whatever resolutions you need me to send. It is all there. I will be following up and sending all of these comments in writing. So thank you again, Chairman.
Thank you, Commissioner. Snows Court, is that a vacant building?
No, sir. It's it's an alley where there's about 20 dwellings that reside there. So there are homeowners there, and all of these homeowners have experienced sewage backing up into their homes. Many of their homes are starting to have their foundations sink into the ground because the ground, apparently when DC Water had come in a few years ago, when they had changed the pipes, they didn't do something right. So now there is literally water under the cement, and it's causing all of the foundations of their homes to start sinking. And these issues have become deeply pervasive. We've put in a major budget request. Councilwoman Pinto is taking this directly to the mayor. It is going to be a multi-agency project. DOB is going to be one of those agencies that is going to be tasked.
Okay. And you will submit your statement in writing.
Absolutely. And there is actually an ANC resolution to follow up with this testimony as well. It was approved by NC2A at its last meeting earlier this month.
Okay, thank you.
You're welcome, sir.
The next witness is Eleni Christidis.
Thank you. Good afternoon, Chairman Mendelson, council members and staff. My name is Eleni Christidis. I'm a Ward 1 resident and a senior staff attorney in the Housing Law Unit at Legal Aid DC. 2 years ago, the council overrode a mayoral veto to break up a dysfunctional agency, DCRA, and create the new Department of Buildings. The council recognized that when something is so broken that it can't be fixed, you need to start fresh. Yet DOB's actions suggest that it is merely DCRA by another name. So far, DOB has failed to timely deliver its strategic enforcement plan, failed to hire all 29 new housing inspectors funded in fiscal year 2023, and done nothing to improve its processes around housing code enforcement. Tenants living in unsafe and unhealthy housing cannot wait for DOB to change on its own. The council must finish the work it started when it created DOB and ensure that it succeeds where DCRA failed. The council must appoint new agency leadership and increase its oversight in the areas of violation abatement, strategic enforcement, and tenant accessibility. First, DOB needs clear and consistent measures to show that it's actually improving living conditions for residents through the abatement of violations. DOB is not using its new dashboard to publicize abatement data, and its oversight responses indicate a violation abatement rate of just 20% of violations cited in fiscal year 2022. It's also possible this measure is not a true reflection of conditions on the ground, as DOB accepts landlord-submitted photos and invoices as proof of abatement without requiring reinspection or auditing of those cases. In our experience, these types of proof are not reliable. DOB needs to be much more transparent about what counts as an abated violation and how it determines a violation is abated. Second, DOB must deliver its strategic enforcement plan, regularly report enforcement data, and tell us how it plans to collect millions of dollars in unpaid NOI fines. DOB must explain how it will work with DLCP to suspend or revoke business licenses of serious or repeat violators. DOB could also add a new tool to its enforcement arsenal by working with the Rental Accommodations Division within DHCD to stop landlords from increasing rents on rent-controlled properties where there are no known unresolved NOIs. Third, DOB must include tenants in its enforcement strategy and make itself more accessible to tenants in general. DOB's business process and technology needs assessment should create ways to notify tenants of enforcement steps after an inspection finds violations, including the opportunity for tenants to give evidence at an OAH hearing. DOB needs to make its technology systems, like its phone and online forms, accessible to limited English proficient tenants. DOB needs to be present in the places where tenants could most benefit from its services. The council should revisit legislation that would put DOB inspectors in landlord-tenant court, where tenants who have housing code violations could get an inspection and raise violations as a defense in certain eviction cases. DOB should also deploy ward and neighborhood-specific enforcement teams to rebuild trust and credibility with the public and more proactively prevent the loss of affordable housing due to landlord neglect. I hope the council will not waste this hard-fought opportunity to create an agency that all tenants need and deserve. Thank you, and I'm happy to take questions.
Thank you. This is the challenge between the legislature, which can enact policy like breaking up the agencies, and the executive, which is responsible for implementing what we pass. Challenge is how to get them to implement more faithfully to what we intended with the legislation. Thank you for your testimony. The next witness, I managed to cover up my witness list here, is Darlene Jackson. Is she here?
Yes, I am here.
Please proceed, and good afternoon.
Good afternoon, Chairman Mendelson and members of the DC Council. I first want to tell you, Chairman Mendelson, that my testimony will be slightly different because I accidentally sent the wrong copy into your office. My name is Darlene Jackson, and I reside at 213 Oglethorpe Street Northeast in Ward 4, the District of Columbia. I find myself testifying once again at the DOB, formerly DCRA, oversight hearing regarding how their performance has continued to affect me with regards to the home renovation and addition project that I had performed on my home back in 2019 and 2020. As a brief recap, I signed a contract for a home renovation addition project with a DC contractor who made my home unsafe, uninhabitable, and ripped me off for $128,000. At near completion of the project, it was discovered by a third party and 3 other DCRA inspectors that the work done by this contractor had multiple safety code violations. Although the initial DCRA building inspector who visited my home during the project failed to identify any violations, but instead signed the faulty work off as approved during his inspection. As a result, all of the faulty construction had to be demolished and redone for my home to be made safe, brought up to code, and made habitable for myself and my elderly mother. In addition to being out of the initial $128,000, plus the costly funds required to redo my home, my mother and I were forced to live elsewhere at great expense in rent and storage costs for our belongings for an additional 9 months because of the actions of this contractor and the DCRA inspector. I am here again because after 3 long years, DOB has continued to fail me by not demanding that this contractor be held accountable for his actions. After 2.5 years, a disciplinary hearing was finally held for the contractor's infractions, only to have the OAH judge issue a stay, placing the decision on hold until my civil case eventually reaches a trial decision. That case has been going on for years, despite my best efforts, and may still take many months to be finally resolved. Why is DOB okay with this result? As of this date, to my knowledge, DOB has not petitioned the court for reconsideration and thereby issue a decision that will hold this contractor accountable for his negligence without delay. The evidence against this contractor was documented by 3 of DCRA's own inspectors, 2 of whom visited my home and documented the violations in person. Was this not enough to justify the violations? Since it obviously was, why is DOB not insisting that the record before OAH is sufficient to justify a ruling? And if not, what more is needed to ensure the residents of this city and contractors will be held accountable when documented negligence has occurred? The question of whether he committed the violations DOB itself alleged he committed and presented extensive testimony and evidence about to OAH does not need to wait for the resolution of a separate private court case. So what is this agency doing now to hold this contractor accountable? Again, who is responsible for holding these licensed contractors and inspectors accountable? Who is responsible for ensuring the safety of the public? DOB continues to do very minimal to assist me in making this matter whole. Thank you.
Thank you, Ms. Jackson. Janet Phoenix.
Good afternoon, Chairperson Mendelson and council members. I'm presenting this testimony regarding the Department of Buildings. My name is Janet Phoenix. I'm an assistant research professor at the Milken Institute School of Public Health at George Washington University and a physician by training. I'm also a member of the executive committee of the DC Healthy Housing Collaborative. My concerns are about the impact of housing on health. Childhood lead poisoning and asthma are 2 serious health conditions that can result from unhealthy housing. Because so many children in DC have been made ill by their housing, the collaborative has been engaged in a campaign to reduce lead exposure and asthma in the district. And we've met with you, Chairman Mendelson and others on the council to raise these concerns. As DC attempts to improve its inspection and code enforcement activities, we need to acknowledge that there is still a legacy of housing that has resulted from the poor functioning of the past Consumer and Regulatory Affairs Agency, with many properties having code violations such as roof and plumbing leaks, pest infestations that trigger asthma attacks and expose kids to lead. And so these conditions really need to be more promptly addressed by the new agency and the effort to put together a new approach to prioritizing housing for code enforcement. The district has legislation that gives some authority over lead paint in housing to both DOEE and to DOB. DOB's role is inspection and enforcement. In order to do this work effectively, however, to protect DC residents, it will require coordination between those 2 agencies with formal memorandums of understanding so that data on properties where children have been exposed to lead can be shared and used to inform prioritization of units for inspection. The new public health manager within the DOB should lead this effort for the agency by creating protocols and mechanisms for obtaining that information and using it as part of a proactive rental inspection framework. Similarly, Children's National has data available on properties with code violations where children with asthma reside. The code violation data was obtained from DCRA's own databases. The data on children with asthma was pulled from hospitalization and ER records that Children's has because they care for 95% of the children with asthma in the district. This dashboard is publicly available and would also be useful for the new public health manager at DOB to use to prioritize housing for inspection and enforcement. Lastly, there is an inspection mechanism housed within DOEE's Lead Safe and Healthy Homes division that refers rental families to the Department of Buildings when landlords fail to address adverse housing conditions. This program works cooperatively with DOB, but it is an informal mechanism, and it depends upon relationships that staff have formed across agencies over time. I recommend a more formal process that allows both agencies to track and to report referrals, and to share information on any enforcement actions that might result from those referrals. Thank you very much for the opportunity to testify, and I'm happy to respond to questions.
Thank you, Ms. Phoenix. And I have your written statement. Thank you for that. The next witness is Matthias Postian.
Thank you, Chairman Mendelson. I'm testifying today on behalf of the Sierra Club DC chapter. I begin my testimony with a recent personal experience on obtaining permits from the Department of Buildings for a renovation project at my house. That turned out to be straightforward and easy. The permit for an alteration and repair could be obtained by submitting all required documents online, and each step was moved forward by reviewers in less than 24 hours. So in my experience, that worked well. Thank you for the Department of Building for creating this quick and effective permitting process. Turning to climate change, about 75% of the district's greenhouse gas emissions come from buildings. Therefore, the Department of Buildings plays an important role in implementing the district's climate commitments. As you know, last year, the DC Council passed the Clean Energy DC Building Code Act, which requires the executive to establish a net zero building code for all newly constructed commercial buildings no later than 2026. Net zero energy buildings are highly energy efficient and are powered exclusively by electricity. Importantly, they don't burn fossil fuels. The Construction Codes Coordinating Board is tasked with implementing that, and the Department of Buildings has 3 members on that board. The CCCB currently has before it a proposal from its technical advisory group, which requires that all equipment in newly constructed commercial buildings be powered exclusively by electricity with no on-site combustion of fossil fuels. This proposal is a natural interim step towards a net zero energy code that is required by law. The Sierra Club calls on the DOB representatives on the CCCB, and in fact, on all CCCB members, to uphold the district's climate commitments by voting in favor of this all-electric commercial code. All-electric buildings are less expensive to build than mixed fuel buildings because they rely only on one piece of equipment, a heat pump, to both heat and cool, rather than requiring 2 separate pieces of equipment. Heat pumps are less expensive to operate. They achieve 300 to 400% efficiency compared to only 85% efficiency for burning fossil fuel. Heat pumps are also better for the health of building occupants because electric equipment does not emit toxic pollutions such as nitrogen oxide that are released when burning fossil fuels indoors and that contribute to asthma and other adverse health outcomes. Heat pumps are also better for our climate because DC's electricity will come from 100% renewable sources by 2032. Methane gas, on the other hand, is 100% fossil fuels. All electric codes are fiscally responsible because the alternative, methane gas, is extremely expensive. Over the next 5 years alone, Washington Gas wants to spend $672 million to replace just a small fraction of its pipes. And that's part of the gas utility's larger plan to have DC residents pay approximately $5 billion to replace its fossil fuel piping system. The earlier we move away from such an expensive fossil fuel distribution system, the better. Given these benefits, it's perhaps surprising that I'm testifying here today, but perceptions in the building trades change slowly, and the fossil fuel industry is lobbying to stop electrification efforts in the district. The Sierra Club asked the Committee of the Whole to remind the CCCB members that the district's laws require a net zero energy code, and we call on all CCCB members, including the DOB, to vote yes for the upcoming all-electric code. Thank you very much for your time. I'm happy to answer any questions.
Thank you. And I don't have a copy of your statement. If you would provide that, please.
Yes, I'll send it. Thank you.
That would be very helpful. Thank you. Max Broad. I believe he's not here. Cynthia Davis.
Yes, I'm here.
Excellent. Please proceed.
Hello, Chairman and the members of the committee. My name is Cynthia Davis from Kings and Queens Child Care Center, a home-based facility in Ward 4, and the Executive Director of the DC Family Child Care Association. I was born and raised in the District of Columbia, where parent choice was a high priority for families with an abundance of opportunities to choose resources within their neighborhoods. In the late 1990s, around 160 or more family child care programs were operating in the DC area. Now faced with extinction, many have closed due to COVID, aging, death, regulations, and laws prohibiting growth. I love my city's priority of early education of our children in safe and healthy environments. However, I must express my concern and frustration about homeowner association bylaws designed to minimize home-based childcare and early learning opportunities, coupled with the Department of Buildings regulations minimizing our growth potential. For example, Maria Miranda's Washington Family Child Development Home was forced to surrender its license after the court ruled in favor of a condominium HOA. This action placed DC residents out of work, at the back of a waiting list, searching for childcare slots, either non-existent or backlogged, and families in a bind for care for their children. These families were enrolled in programs for years, creating bonds with Maria that will last a lifetime. It is a tiresome and challenging process for parents to vet and trust non-family members to care for their children. Forcing families to leave a facility due to loopholes in a system is a tragedy when the city's main priority is children first. Prior to the advent of COVID-19, the mayor made a call for an additional 1,000 childcare slots throughout the city, which has become a greater necessity because of closings, staffing shortfalls, and limited childcare options. In addition, there is another instance where Ms. Morales and several other family childcare homes were told that Appendix M of the DC Building Code prohibits the establishment and the expansion of child development homes in the multifamily residential buildings in 3 or more units. This prohibition of CDHs from operating a family childcare facility and multifamily residential dwellings is discriminatory and creates more disparities for Black and brown children, and makes a goal of sufficient childcare slots impossible, or at best a pipe dream. Low-income families are the chief residents living in public housing and make up a sizable part of families living in private housing structures. Consisting of multifamily dwellings, DC families must have the right to choose where their children receive care and their early education. There is a stigma around family childcare within the city that we are low quality and are glorified babysitters. Most family childcare programs are not low quality and have the proper credentials, including degrees. According to the Office of State Superintendent, family child care is chosen because families like home-style settings, flexible hours, and personal care and understanding we provide for their families. Department of Buildings can remedy this situation by mirroring other states like California and Colorado by ending HOA bylaw discrimination gaps against home-based childcare businesses and prohibiting HOAs to rejecting DC residents operating in family childcare homes. By doing this, we can grow the city's entrepreneurship, home ownership, rental, and employee base. Thank you for your time and for allowing me the opportunity to speak.
Thank you, Ms. Davis. The next witness is Teresa Aspinwall.
Yes, hello and good afternoon, Chairman Mendelson, council members and staff. My name is Teresa Aspinwall. I'm a resident of the District of Columbia, director of the Multicultural Spanish-Speaking Providers Association, and an active member of the Under 3 DC Coalition. On behalf of the MSSPA members, I want to thank the council for investing in early childhood educators, the workforce. Sorry, I lost my place. Thank you. Today, I'm here to ask the council for help to ensure that more licensed childcare programs can be established. Specifically, I have 2 asks. First, to reduce the barriers. This isn't working here, sorry. To reduce the barriers to opening up new programs. I'm sorry. apologies. Let's start it again. Number one, I'm asking for assistance from the council into looking into reducing the barriers for the establishment or expansion of family child care programs, like Cynthia just mentioned. I'm also going to ask the support for the passage of the newly introduced amendment act called the Banning Associations from Banning Youth Amendment Act of 2023. As you may know, DOB oversees the home occupancy permit process for child development homes. Currently, permits are issued for single-family dwellings or multi-family units for up to 2 units. DC affordable real estate residential spaces are usually within apartment and condo buildings. Condo buildings, and in order to establish a family child care program, many of these residents should actually be a matter of right. Other challenges that members are experiencing as they work towards getting to applying for an HOB permit is they're not finding interpretation. They're unable to communicate with agency staff without that. Sometimes the absence of translated applications and important documents are not available. And also we're hearing that there's delayed responses and calls to emails. As a public agency, DOB must ensure compliance with the DC Language Access Code of 2004. My second request is for the passage of the newly introduced bill banning associations from banning Youth Amendment Act of 2023. It's also known as the Baby Act. This bill was introduced by council members Nadeau, Bonds, Parker, Gray, Pinto, and Robert White. The bill would amend the Condominium Act of 1976, and it would prohibit association bylaws from interfering with the operation of child development programs. Protecting these essential community services is an important step to ensuring that working families have increased access to childcare options. As you will hear today from providers, there is a need to protect these family childcare programs and the need to establish a permit process that is more reflective of the broader DC housing options. The newly formed DOB agency has the opportunity to craft a more inclusive permit process and to develop a plan for better language access for DC residents. Thank you very much for the opportunity to testify. Appreciate it.
Thank you. Thank you, Ms. Aspinwall. Irma Morales.
Sí. ¿Me escucha? ¿Me escucha?
I can hear you.
Buenos días, presidente Medenson y miembros del consejo. Soy Irma Yolanda Azul de Morales, residente desde hace mucho tiempo en el Distrito 5. Abrí Little Blessing Child Development Home, un programa de inmersión en español en el 2009. Justo antes de la pandemia, mi especialista en licencias me animó para solicitar un programa ampliado de cuidado infantil en el hogar, aumentando la capacidad a mi programa de 3 niños para hacer un total de 9. Desafortunadamente, mi solicitud para un permiso de ocupación del hogar, HOP, para un cuidado infantil en el hogar fue negado. Estoy aquí el día de hoy para pedir su ayuda con, número 1, el desarrollo de regulaciones más inclusivas para el cuidado infantil en el hogar y, número 2, cumplimiento del DOB con la Ley de Acceso Lingüístico de DC de 2004. Un HOP para el cuidado infantil familiar ampliado solo se ofrece para viviendas unifamiliares y de unidades de 2 viviendas. Mi edificio residencial tiene 3 plantas. Mi residencia está en la planta baja con salidas apropiadas. Tengo una licencia de cuidado infantil válida, cumplo con las normas y políticas de aprendizaje temprano de OSI y mantengo las licencias en funcionamiento adecuadas. Mi programa de hogar de cuidado infantil familiar participa en el programa de subsidio de cuidado infantil y ha sido designado como programa de alta calidad por OSI. Yo, junto con mis maestras, estamos cursando el grado de asociado bilingüe en educación en la Universidad del Distrito de Columbia. Me graduaré en primavera, en mayo próximo. Tengo el consentimiento del propietario del edificio y, por supuesto, las familias trabajadoras de mi vecindario están agradecidas de poder elegir un programa de desarrollo infantil en su vecindario. Proporciono servicios durante 10 a 11 horas por día. Creo que después de la inspección, mi programa cumplirá con los estándares ocupacionales y de seguridad. Un programa de ambiente y un aprendizaje apropiado. Parece que la única razón por la que no puedo ampliar mi programa se debe a una regulación exclusiva. Tal vez se pueda hacer una excepción especial para que puedan expandir negocios como el mío. La realidad es que no puedo pagar una vivienda unifamiliar con los precios actuales del mercado inmobiliario de DC. Los diversos planes de desarrollo de la ciudad han convertido muchas viviendas unifamiliares en viviendas multifamiliares. ¿Cómo podemos ayudar a garantizar que este tipo de desarrollo de vivienda no elimine el servicio comunitario esencial que brinda el cuidado infantil familiar? Imagínense que con la aprobación de un programa ampliado podría aceptar 3 niños más para este cuidado infantil. Tengo una lista de espera para estudiantes. Los lugares se abren cuando los niños se inscriben en pre-K. Todos somos conscientes de que los niños con retraso en el acceso a un desarrollo adecuado del aprendizaje temprano pueden requerir intervenciones cognitivas, motrices o conductuales. Mi programa ofrece un ambiente de aprendizaje lingüístico y culturalmente apropiado para bebés y niños pequeños del vecindario. Mi segundo pedido es su ayuda para garantizar que el DOB proporcione las traducciones de los documentos vitales necesarios para solicitar la apertura o ampliación de un hogar de cuidado infantil familiar con un número cada vez mayor de permisos HOP para una vivienda de negocios profesionales u otras actividades económicas. DOB tiene el deber de garantizar que los documentos vitales se traduzcan y se ofrezcan interpretaciones de idiomas. Finalmente, quiero decir que durante más de 20 años he ayudado a los padres de DC ofreciéndoles una opción de cuidado infantil en el vecindario que brinda cuidado asequible y de alta calidad para niños pequeños. El plan de regreso del alcalde cuenta con programas sólidos para la primera infancia para las familias de DC. Con su ayuda, se pueden abrir más programas de cuidado infantil familiar y ayudar a abordar la escasez de espacios para la educación de la primera infancia. Gracias por la oportunidad de dar mi testimonio. Estoy dispuesta a preguntas. Gracias nuevamente.
Thank you very much. Thank you. Maria Paola Miranda.
I'm here.
Hello.
Buenas tardes, presidente Madlenson y miembros del Consejo. Soy María Miranda, residente del Distrito 1 y expropietaria de Washington Family Child Development Home. Soy miembro de la Asociación de Proveedores Multiculturales de Habla Hispana y formo parte de la comunidad Under Tree DC. Estoy aquí para pedir su ayuda para brindar una mayor protección a los hogares de desarrollo infantil, también conocidos como hogares de cuidado infantil familiar. Además, solicito el apoyo de este comité para la Burning Association from Burning Young Amendment, Act 2023, B250045. El otoño pasado, la Corte Superior de DC me ordenó cerrar mi negocio. De inmediato, la asociación de mi condominio presentó una demanda declarando que violé los estatutos de la asociación al operar un negocio comercial desde mi casa. Mis abogados y yo no pudimos persuadir a la Corte de la Asociación de Condominios que no tenía ningún derecho a interferir con la operación de un programa para la primera infancia basado en el hogar. Lamentablemente, el juez de la Corte falló a favor de la asociación y me ordenó cerrar y desistir de las operaciones de inmediato, así como pagar multas y sanciones. También me ordenó entregar mi licencia de cuidado infantil a OSI. No importa que tuviera un permiso de ocupación de vivienda emitido por DOB, anteriormente DCRE, y que tuviera una licencia de cuidado infantil válida de OSI. No perdí mi negocio porque no cumplí con las normas y políticas de aprendizaje temprano de OSI o porque no mantuve las licencias de funcionamiento adecuadas. Esto sucedió porque la ciudad no tiene medidas ni leyes de protección que protejan a los hogares de cuidado infantil familiar. Desde 2014, mi cuidado infantil familiar ha sido sirviendo a docenas de familias trabajadoras, muchas de las cuales mantengo un contacto cercano hasta hoy. El cierre abrupto de mi programa dejó a varias familias sin solución de cuidado infantil. Además de mi personal y yo, quedamos desempleados. Estoy devastada porque no puedo servir a mi comunidad. Cuando comenzó el proceso de reconstrucción de mi programa en una ubicación diferente, encuentro que el proceso de permiso de ocupación de vivienda, DOB, no es accesible como soy un hablante limitado inglés o necesito hacer solicitudes de permiso informado en español. Cuando voy a DOB para obtener respuestas, muchas veces me dirigen a un proceso en línea o necesito contactar a alguien por correo electrónico. Esta es una barrera de acceso que excluye a muchos habitantes de baja tecnología o habitantes delimitados en el idioma en inglés. Como agencia pública, DOB debe cumplir mejor con la Ley de Acceso Lingüístico DC del 2004. DOB también debe ser más claro en cuanto a definición de hogar de cuidado infantil familiar e incluir derechos adicionales con el permiso. La terminología también es importante. Creo que la adopción de Barney Association for Barney Younger Amendment 2023 D250045 ayudará a proteger a los programas de cuidado infantil familiar en el futuro. Una vez más, pido su ayuda para proteger los programas de cuidado infantil familiar. También solicito el apoyo del Comité Plenario con la aprobación de la Ley de Enmienda Prohibición de Asociación de Jóvenes 2023. Gracias por su disponible a cualquier pregunta que pueda tener. Gracias.
Thank you. Thank you, Ms. Miranda. The next witness is Julia Ruiz.
Yes, I'm here. I will read in Spanish my testimony because I'm part of the Association of Spanish Speaking Providers. Ok, buenas tardes, presidente Mendelssohn y miembros del Consejo del Comité Plenario. Soy Julia Ruiz, miembro fundador de la Junta de Asociación de Probadores Multiculturales de Habla Hispana, las siglas del MSSPA. También soy antigua propietaria de un programa de cuidado infantil en el hogar de Julia en Ward 1. He operado mi programa de cuidado infantil oficialmente desde el 2010, brindando educación temprana bilingüe a bebés y niños pequeños que viven en el vecindario de la U Street Cardozo y alrededores, en el Distrito de Columbia. Estoy aquí para pedir su ayuda para, uno, construir un sector más sostenible que incluya hogares de desarrollo infantil, también conocidos como hogares de cuidado infantil familiar, que puedan trabajar, operar en edificios de departamentos, porque es un servicio directamente a la comunidad, considerando que es el primer eslabón del bebé que sale del cuidado de la madre a un cuidado de hogar infantil. Número 2, asegurarse de que la agencia de DOB cumpla completamente con la Ley de Acceso Lingüístico de DC de 2004. A lo largo de los años, presté servicios a docenas de familias trabajadoras, brindándoles educación infantil de alta calidad. Mi programa brindó un servicio esencial para mi comunidad. Ayudó a fortalecer el sentido de comunidad. Justo antes de la pandemia, se vendió la casa que había estado alquilando y operando en mi cuidado infantil familiar. Por 18 años había vivido en esa casa, aunque me dieron el primer derecho de denegación, me fue imposible calificar para un préstamo por el precio de compra de 1.6 millones. Residí aquí durante 18 años, ya lo dije, y estaba devastada por perder mi residencia. Posteriormente tuve que cerrar mi negocio, perder mi fuente de ingresos y despedir a los empleados. Varias familias perdieron el cuidado infantil para sus hijos y en un área de opciones limitadas por el cuidado infantil. No tengo muchos home daycares en el área, casi ninguno. He estado buscando en el mercado inmobiliario actual una nueva casa para alquilar y restablecer mi programa de cuidado infantil familiar. Encontré un local al lado de mi casa anterior, una vivienda en la planta baja con fácil acceso desde la calle, o sea, street level, y con 3 salidas. Obtuve el permiso del arrendatario y de los vecinos para ejecutar un programa de cuidado infantil y luego solicité un permiso para la ocupación de vivienda del DOB o DCRI. Ahí conseguir el HOP. Ahí empieza el problema porque me mandan a hacer la aplicación en línea y el sistema no me permite proseguir con la aplicación. Porque es denegado. Mi solicitud es denegada porque el sistema no me permite. Y no encuentro mucha explicación por qué. Me dijeron que mi programa no sería permitido, no entendí totalmente y no recibí una respuesta por escrito. Ahora sé que DOB prohíbe el establecimiento de un programa de cuidado infantil en el hogar en casas con 3 o más unidades. Creo que con la ayuda del Consejo Municipal de DC se puede crear regulaciones más inclusivas para los servicios esenciales del vecindario como el cuidado infantil. A lo largo de mi interacción con el DCLI he experimentado barreras de idioma y tecnología. Muchos servicios de agencias ya no están disponibles en persona, sino en línea. El servicio al cliente también necesita mejorar y contestar a mis llamadas y correos electrónicos que no fueron respondidos apropiadamente. La solicitud, el proceso y la información relevante no están disponibles en español y no son accesibles para hablantes con limitado inglés. Me gustaría ofrecer una solución a las barreras anteriores. DOB necesita revisar su proceso de revisión de permisos, HOP, para programas del cuidado infantil familiar, para permitir que los programas operen en diversas propiedades y áreas residenciales. Por ejemplo, DOB puede considerar emitir un HOP para programas de cuidado infantil en el hogar que estén al nivel de la calle, con los requisitos de seguridad adecuados. Esta acción es importante para la estabilización del sector de la educación temprana y muy importante para las familias de DC que buscan opciones en los programas de aprendizaje temprano. Si el DOB no incluye más los programas de cuidado infantil familiar en DC, continuará perdiendo la oportunidad de expandir los espacios de cuidado infantil dentro de los vecindarios, que se han visto afectados por la gentrificación y los altos costos inmobiliarios. Para seguir atrayendo a más residentes, incluidas las familias, se necesitan más programas de aprendizaje. Mi programa bilingüe tenía una gran demanda y anticipo ansiosamente la posibilidad de volver a servir a mi comunidad, porque este trabajo es principalmente un servicio a la comunidad de padres, que también están dispuestos ellos a apoyar con sus propios testimonios. Les agradezco por la oportunidad de exponer mis inquietudes, mi preocupación, y estoy lista para cualquier pregunta que deseen hacer. Gracias.
Thank you very much, Ms. Ruiz. Vanessa Bertelli? Is she here? Ms. Bertelli?
Hi. Oh,
Good afternoon.
good afternoon. May I begin?
Yes, please.
Chairman Mendelson, committee members, DOB Director Shrapa and staff, thank you for this opportunity to testify. My name is Vanessa Bertelli, and I live in Ward 4 with my family, and I advise on electrification of buildings. I would like to thank DOB for spearheading the DC Net Zero Energy Program. My 100-year-old home was the second retrofit to participate in that program, and I had the pleasure of interacting with DOB employees committed to electrification. I have also used the new permit wizard and appreciate the technological innovation by the department. We need more of this. As you all know, greenhouse gas emissions from buildings account for 76% of all district emissions, which is why the DC Council and the Mayor have passed legislation which will eventually require most buildings to be electrified. Most of this work is going to fall on DOB and its employees. Director Trapa's decisions are going to make or break the district's ability to achieve carbon neutrality and phase out fossil fuel combustion by 2045. These are 5 opportunities I see. Staffing. I'm excited about the green energy training and the code training, and that almost all green building team positions have been filled. But ensuring DOB can deliver on the district's climate commitments will require nothing short of mandatory training for all staff on the critical role DOB plays in that, and hiring additional capacity with these expertise. So I hope Director Shrapa is asking for enough budget. Programs. DOB, together with DOE, must consider which programs can be funded through the Inflation Reduction Act and apply for those grants. Where programs necessary for the electrification of our buildings are not fully funded by federal money, Director Shrapa should ask for an adequate budget to deploy and sustain those programs. KPIs. KPIs that reflect the role of the DOB in meeting the district's climate commitments should be evaluated and added. 4th, technology. I'm excited about technological innovation being one of DOB's priorities, because to electrify our buildings in the fastest, most efficient, and equitable way, we need nothing short of a technological miracle. For each district building, we need to populate information on the state of appliances, electrical panels, wiring, renewable energy sources, energy consumption, fuels used, square footage, and do not have time to go into each of our hundreds of thousands of buildings and units. Leveraging tools across agencies, utilities, and the public is going to be necessary. Outreach, lastly. Director Shrapa has masterfully used the district's coordinated outreach potential to inform residents on DCRA split. An endeavor of similar magnitude is needed to inform residents about the need to electrify and the programs on offer to do so. I'm looking forward to seeing what DOB's communication and marketing strategy initiative for coordinated outreach can do to advance this work. Director Shrapa's task and his legacy will be how he wrangles our buildings to transform them from our most polluting asset into tools to combat climate change. I wish him luck and stand ready to help. Thank you.
Thank you, Ms. Bertelli. I don't have a copy of your statement. If you would send that, please.
I will gladly provide it. Thank you.
Thank you. Margaret Stevens.
Good afternoon. Thank you all for having me. I am Commissioner Margaret Stevens representing 1C05, and today I am testifying about the impact that 2920 blighted property 2920 Ontario Road Northwest has had on my neighborhood. And in the interest of time, I will just read my impact statement directly, and then I just want to freestyle a bit for a brief critique, DOB critique, and then a brief solution at the end. So first, 2920 Ontario Road Northwest has been vacant and blighted for more than a decade, with falling bricks, failing structure, slumping entrance, broken and open windows, providing access to the inside for possible squatters of unknown intent. Graffiti and illegal dumping, including everything from large pieces of furniture to appliances to food waste, has occurred off and on, which spills onto the sidewalk and out into the street. All of these things pose an obvious threat to our physical health and safety. They also pose a threat to our mental well-being and general morale as a community. And actually, let me add, in terms of the physical health and safety, there was a fairly recent weather event where unsecured, very heavy construction material and tools and debris blew from the roof, again, unsecured by the owner. The debris blew right into the adjacent building, and luckily no one was hurt, but someone could have been very seriously injured or even killed by that event. And I was actually hoping that someone from that building might be here to testify. They may. There are so many people, it's possible. So moving on. So as a commissioner, this property introduces the following unique challenges and burdens to my responsibility to improve my SMD. 2920 is an enormous waste of resources at a time when affordable housing and shared community spaces are desperately needed. My heart was breaking a little while people were talking about new builds for housing. And when I look at something like the one that's actually behind me, this is the building here, there's a visual. When I think about what something like that and all the blighted properties around DC, think about what they can be before a new build even happens. And of course, we do need new building, but again, I just look at that and say, what a shame. So then also 2920 is setting up a dangerous example and precedent to other building owners and developers in the neighborhood, that it is permissible to neglect and abandon your property in a hazardous state for years on end. I am being alerted to more and more of these cases in my SMD. So I think that definitely is a focus of mine, the number of years that a property is allowed to sit neglected and blighted. And I'll address that a little bit later in the critique and the solution. So, and then another point here, at a time when crime is on the rise, it is extremely concerning to have a property that is accessible for entry by criminals who need a hiding place. We had 2 fatal shootings, and the individuals, as far as I know, are still at large. My constituents were a little fearful that they might claim 2920 as their own, because again, there is a possibility to enter that building and occupy the building.
Commissioner, I think you said you had some suggestions and you've used up all your time. So could you get to the suggestions?
Oh, okay. Oh, I'm sorry. I thought as a commissioner, I had the 5-minute time. Okay. All right. So the critique is that I have heard, I'm a new commissioner, but I have heard that sometimes the enforcement of blighted property policy and laws is a bit spotty. So I would ask that the enforcement of it be consistent, and that I have heard also communication between the DOB and OTR, which is the agency that gives all of these blighted property classifications teeth. The communication is a little, at least something to be desired. So I want communication, but this is my focus right now. So I believe that the actual content of the existing laws and policy concerning blighted property is not strong enough, and I don't think it's quite well crafted enough to prevent owners from willfully neglecting their blighted properties for years and decades on end, and it just continues and continues. So in accordance with an ANC 1C resolution that is in place, myself and other commissioners are going to meet. We're going to come up with a few suggested modifications to the policies. We need to really think it through, and then we would like to present our suggested modifications to DOB, OTR, and the City Council. So we will be in touch and see what we can set up in terms of a Zoom and a presentation on that level. Because what I've run into for the building that's shown behind me is that it is classified, the highest blighted classification. It's a class 4, which means that the owner has been taxed the blighted property rate for quite some time, but it does not seem to be encouraging him to either improve or sell his property. So I think there is a problem with the wording, the content of the policy itself, and we would like to suggest something so that this problem of blighted properties in our neighborhood and all over DC can be solved, and these properties can be used and become a positive part of everyone's community.
You're still developing the suggestions and you'll be giving them, and I would be interested in seeing them. Let me just note that until a year ago, the property was classified as class 1, and the department reclassified it retroactively, so that it's now classified as class 4, which, as you noted, is the highest, the highest tax rate. It's $10 per $100 assessed value. Last summer, to avoid tax sale, the owner paid $174,000 in taxes. That was in addition to payment in 2020 of $100,000 and in 2021 of $79,000. So the tax has gone up significantly, and right now, as of today, the owner owes almost $380,000. This is economic pressure. What you noted was not exactly correct. Until a year ago, the property was classified as Class 1, and that's how it was able to be vacant for so many years, because it was classified at the lowest tax rate. And now that the department is finally taxing it as blighted, which it is, the economic pressure is there. They almost went to tax sale last year. I don't see how it's sustainable for them to hold on to a property that they keep vacant if they're going to owe $380,000 on a vacant building. And the owner of this building also owns a vacant property, multifamily apartment building on Hyatt Place, between it's Irving. No, it's not Irving. Doesn't matter. East of 16th Street, across from the Czech athletic field. Thank you for your testimony. I have your statement, and we look forward to getting your suggestions.
Wonderful. Thank you so much. Appreciate it.
The next witness is Doug Siglin.
Good afternoon, Chairman Mendelson and council members. I'm Doug Siglin. Perhaps you know me as somebody who's testified to the council a lot over the past 30 years, mostly on water and community issues. But today I'm here to talk about climate change on behalf of the Chesapeake Climate Action Network. You should have my written statement. I'm going to respect your time and be very brief in my remarks. The district has perhaps the most aggressive carbon emissions reduction goals in the nation. But the fact is that it's going to be very hard to meet those goals. And a threshold issue in meeting those goals is to quit digging our hole deeper. That is to quit allowing our new buildings to be built using fossil fuels for heat, hot water, and other uses. Last October, the DC Construction Codes Coordinating Board rejected a proposal from its own technical advisory group to require new buildings to be all electric in this next code cycle, despite a letter asking it to approve the proposal from 12 of the 13 members of the council. I don't want to call out anybody by name here, but I do want to say that two very senior district employees who were present and voting in October did not support the electrification proposal. Last week, the board was supposed to reconsider the vote, and nearly the entire council wrote once again asking the board to approve the proposal, but somehow the item failed to make the meeting agenda. Perhaps it will be reconsidered on a future agenda. We can only hope that the codes board sees fit to approve the proposal this time around. I'm going to conclude with only one comment and one ask based on October's vote and what happened last week. My comment is that meeting our climate goals may be too important to allow a virtually unaccountable volunteer codes board to allow at least 3 more years of fossil fuel combustion in new buildings. While I appreciate all the time and effort that the volunteers put in, maybe the times call for a different structure for our codes process. And my ask is this: if the codes board remains recalcitrant and rejects the recommendation once again, I hope that the council will be prepared to act at the end of the process to make sure the new buildings are electrified as soon as possible so we can chalk up some progress to our mutual climate goals. Thank you.
Thank you, Mr. Siglin. In your statement, you referred to there being 3 more years if the board does not take action. Why 3 more years?
Because, Chairman, the code cycle is 3 years, and the legislation that was passed in the summer requires something at the end of 2026, but that's more than 3 years away.
I didn't follow. The board voted or didn't vote or took action or considered it last summer unsuccessfully. And you're saying it's before the board again now. If they don't act successfully now, why couldn't they take it up in the fall or next year?
Because as I understand the process, Chairman, the board is working toward a new regulation that would update the building code. And that new regulation will go through process and eventually come before the council. And that's probably going to happen in the spring. Whatever happens during that code process will obtain until the next time they do it. And traditionally they do it every 3 years.
Okay, thank you. And I have your statement. Thank you very much.
Thank you.
Rebecca Miller.
Good afternoon, Chairman. So just want to kind of riff a little bit off of what I've heard so far. We submitted our testimony earlier for Office of Planning, which included a lot of information about enforcement, which remains a critical problem. With the Department of Buildings formerly being DCRA, it's only been a few months, but it does have the same leadership. And so it's hard to tell what things have changed. I see this long list of witnesses, and I suspect there's going to be a lot of people who are talking about losing their life savings in a house that they can't live in because of lack of enforcement and lack of review of properties when they're under construction. So that seems to be a major problem. With regards to the ANC Commissioner, Ms. Stevens's comments, I was just kind of looking at some stuff while she was talking because I was interested in this property. So this building was built in 1924. It's not currently designated, but it's in the Commission of Fine Arts review area. The current owner paid $2.2 million for that site. This would be like a prime site when you had asked me earlier in planning about historic preservation costs, more to do and whatnot, where they could utilize the federal historic tax credit and also utilize a low-income housing tax credit for this particular property. It's been done on several other projects across the city. All they have to do is spend $1 more than their acquisition cost back in 1998. And so this could obviously add more housing to it. I don't know how you pressure a private owner to do that, but I'm just offering it as a suggestion to Ms. Stevens and to the council as something to be, because I know that you're concerned about that property, Chairman. So with that, our previous testimony stands for itself. Obviously, enforcement is one of the biggest issues we face in historic districts. It continues to erode our historic districts going forward. And with that, I will just yield back my time. Thank you.
Thank you. I'm looking at your earlier statement. There's like one paragraph in it about enforcement. Am I reading that correctly?
That is correct.
Okay. Thank you.
Thank you.
David Maloff.
Mr. Chairman, good afternoon. Thank you for holding this hearing. I am David Maloff. I'm a 40-year resident of Ward 2, a 32-year resident on Q Street in a home that's been besieged with 3 neighbor notifications. And for anyone who's been through neighbor notification, it's not a friendly experience when you're interacting with the government and a developer who don't tell you anything about the dangerous construction that is about to take place, which is the reason why Section 3307 specifies for neighbor notification. I've got 33 years experience in human resource, finance, marketing, management consulting, and I'm an entrepreneur trained in Silicon Valley. I've got a good eye for hiring people, I've been told, and I have 2 recommendations for you today that are decidedly within your wheelhouse, sir. First, I'd like you to enact a resolution to have the Department of Buildings unwind the new neighbor notification that was surreptitiously installed in October. My wife and I got the 3 letters in August and September, and all of a sudden the world had changed. So I've seen the old DCRA and the new DOB, and the new rules are eviscerating in residents' rights to comment pre-permitting on the dangerous projects that are being proposed. What DOB's done is they've stripped the pre-permit comment, and you're invited in a magic 10-day window after a permit has been issued now to comment, and you have to do it by hiring engineers. And for us, we had 10 days running around before submitting as required the day before Christmas Eve on December 23rd. They've made a mockery of respecting DC residents who have their life savings invested in their homes. You've got, I'll play numbers if you'd like, sir. It's kind of fun with numbers, but you've got about 80,000 single-family homes in this city, by my estimation. When you take out the condos, you take out the apartments. That's a good number to play with. That's about that's about 10,000 per ward. That's about 2 voting residents per those 10,000 or 20 voters. And those people are focused on their properties. And taking away these rights is just absolutely unacceptable. It has been a trip from translucency to opacity. And my second request, oh, by the way, the mayor is aware of this. The mayor can also simply ask DOB to stand down and implement a rulemaking, a simple rulemaking to fix these rules, and or take it to the council and build it out as official code. Either way, these are settled rules that were upset last October. Finally, I do not support the advancing of the nomination of the current nominee, Mr. Chopra, nor any of his 4 top executives. They lack the sincerity to respect homeowners who have about $50 to $60 billion invested in homes in this town, by my estimation, and they don't have the training either. When I hire a chief of a fire department chief, I want someone experienced with using a hose and who has a healthy respect for combustion. These folks want to push paper faster. I respect Mr. Chopra for wanting to do permitting faster, but there's a limit here. And I think he'd make a marvelous IT director and green energy director at DOB, but not as the agency director. And spend a little coin and just like with Metro, get some fresh blood from the outside to break up some of this entrenched management that really doesn't care about residents here. I don't see any of the big developers here. I don't see any of the big apartment building owners here. God bless them. They go in the front door at DOB and they go in the front door at Wilson. And we're sitting here as the little people with 3 minutes. So that's the proportion here. 56 billion is not to be laughed at, even though I understand some of the commercial and the rest are even bigger numbers. But I don't care the DOB management went to the Nationals ballpark and drank and ate last month, which was on their newsletter. I care about them caring about the residents of this town who vote and whose lives are at stake when buildings crack and collapse. Do a rulemaking for neighbor notification, make it open in the sunlight, and advance another name.
Mr. Maloff,
thank you.
I'm a little bit confused. First of all, has the construction begun next to your house?
Oh, yeah.
And has there been damage?
Not yet. I sleep every night, and my wife and I wake up at 3 in the morning wondering what's going on 10 feet from our heads.
You've referred to a change in the neighborhood notice.
Yes,
What's
sir.
the change?
The previous forms were very officious, built out over years, and basically you either signed the form agreeing to some unspecified amount of protection and safeguards that are never clarified. At least they weren't for us. Or you don't do anything and you give up your rights to protection should damage occur, or you had 30 days to file technical objections, and they must be filed by an engineer. We hired 2 expensive engineers. I have the wherewithal to do that. I don't think other residents do.
You're saying
never heard a word back, sir.
You're saying that previous to last year,
yes,
a neighbor was notified and had 3 choices: to give up their rights, or to take 30 days, or to.
Yes, sir. If you take a cup of coffee and close your door, you're a very busy man. I'll send you the forms. They are scary as heck. And anyone I've ever met with said the old forms were terrifying, and actually they're full of triple talk. The name of the game is to
those are the old forms.
The old forms. The new forms have been very streamlined. You get a form in the mail and no one signs it this time. So you get by certified mail a new 1-page form, and you're notified that something dangerous has been proposed, and you're not invited to submit comments within 30 days. And no one signs it, not from the Department of Buildings and not from the developer. It's just sitting there.
And so what would you like to see?
I want the old forms back. And if DOB feels that something needs to be streamlined, we need to talk about it, because it doesn't involve, it shouldn't involve eviscerating the rights of the people who are abutting, sleeping next door, wondering who is digging under my property, how far are they into my property line that has been authorized by DOB, and what are their skill sets? Are they insured? When people don't answer basic questions that we filed duly under technical objections, my antenna go up, the red lights and the amber lights start flashing. This group wants to deal with the sexy projects, and all the people here today represent a group of, I'm sorry to say it, I'll say it again, we're the little people, okay? And that's not right. And we can't manage our new city state should we become one in this manner. And this team has a bias towards moving things quickly and concentrating on the commercial. And I am not mistaken.
Most homeowners, when they are doing some work that requires a permit, most homeowners, I would like to think, are complying with the law and the regulations and the code and are not going to damage their neighbor's property. That would be most. And most of them are not interested in a long delay and, frankly, an unclear process if a neighbor objects.
Agreed.
So I want to replace the windows in the front of my house, and I have to notify you, and you don't like me and you object.
No, you don't have to notify me, sir. These are section 3307, forgive me for interrupting, is for dangerous, basically dangerous projects. Digging under my property, not only theirs, putting something on top of like a penthouse on their roof, increasing the weight that turns my party wall into a flying buttress. If you're going to do that, then I want to know what the calculations are. That's why neighbor notification was promulgated. If it's a little too hard for DOB to manage now because they're so very busy, then let's do a rulemaking and don't pop out eviscerating rules in the dark of night. Yeah, no one wants that. It's in direct violation of the DC APA.
Well, I'm not getting that the old notice was particularly clear or helpful. And when you mentioned that one of the options is that you waive your rights if you're damaged, that sounds a little extreme.
Well, this form says if you don't sign and accept this, in our case, unspecified protection and safeguards that are never defined in the code and never defined by DOB, but they're used on the forms. If you don't sign, then you run the risk of not being protected. There's a lot of double talk, and it's all for DOB to say, we issued the permit, and what they say at the very bottom of one of their permits, if you read the fine print, is that this does not release the contractor from being responsible for damage caused during the project. So I'm not for it. I'm not for a quick permitting that just shifts the burden onto the Superior Court for the neighbors. Mommy Preston, I'm honored to be on this board with her. She's number 35 this afternoon. She'll tell you all about it. She's been at it for 5 years.
No, I'm
She's my neighbor
familiar
up on 13th Street. And my wife and I don't want the same thing to happen to us.
I understand. So your suggestion is to go back to the old forms.
For the time being, that's a very easy thing to do because you should have done.
How about your long-term suggestion? Do you have that written out?
Yeah, well, the long-term suggestion, you could put time limits on it.
Do you have it written out?
You could limit the scope. But one thing that is important is when people file 3 sets of technical objections by very expensive engineers, and you're promised in the form and in the fine print with the signatures that you will receive a consolidated, a detailed resolution report in one package. I'm waiting for my 2 resolution reports, and you could have an intern at DOB sit in a room, listen to the engineer, and document it and send it to the neighbor. I'll tell you one thing that works in this town, sir, with ABRA, when there's a bar owner or a restaurant owner and the neighbors, they put them in a room with some donuts and they lock the door and they make people talk it out. We are losing the magic here by not having neighbors affected talk to neighbors. And what they've done instead is move in the other direction.
Your long-term proposal, do you have that written out?
Well, let me think about that. I think largely what I experienced was very good if they'd simply respond. We've gone through 6 months now. My wife and I received.
Okay, well, I'm kind of at a handicap of being able to spend some time to look at a long-term solution if I don't have a suggested solution.
Well, sir, let me do this if I could. I recommend that you and I both go back to the beginnings, like the Monopoly game, okay? Let's just do a rulemaking that's open. What happens in a rulemaking is DOB states publicly what it would like to do and have the council members and the neighbors comment. And if they don't want to do it, they're a big, powerful agency. Don't do an administrative rulemaking. Let them submit it to the council. But what they should not do is do what they did.
All right, well,
I'm
they
telling you
don't
from my
submit their
heart.
rulemakings to the council, so that's not going to happen. But this just seems a little, you've spent a lot of time on this, and I think it's unfortunate that you've had to spend a lot of time on this. You spent a lot of time on this, so you have some ideas on what would be a good process. And all I'm asking is if you've set that down in writing so I could look at it.
Well, sir, I'm not a professional at it. And in all honesty, I wasn't in the business of receiving 3 certified letters. I like what was in place. I'm not the one proposing to eviscerate what was in place. DOB is. They need to state what's so bad about what was in place. But Mr. Chopra's newsletters, they say that the process has been streamlined. Oh yeah, it's been streamlined.
Okay, I didn't want you to go over that again. I just wanted, okay, so the bottom line for you is the previous process.
Previous process, and it won't take long to do an open rulemaking. Very, very straightforward, very transparent, very honest.
Thank you, Mr. Maloff.
Thank
and
you,
it's
sir.
good to see you.
Thank you, sir.
Give me just a second here. Councilmember Lewis George, do you have any questions?
Yes, thank you, Chairman. And we have a few witnesses. Abel, Amin, I'm not sure if you're still here.
Yes, I am.
Okay, want to get to your question regarding the ventilation from the kitchen range hoods. And I think you specifically referred to a code, a building code for revising it. So basically you just want us to sort of amend the building code because you believe that it should be a violation to have a kitchen range hood that doesn't basically go to the outside, that doesn't have adequate ventilation.
Absolutely, that is absolutely correct. You know, I've gone through 2 inspections, as your office knows, and both times I've been told that it's not a violation. They've looked at range hood, it functions as it's supposed to, according to its manual. So they've been unable to do anything about that. And the code clearly says, you know, it's permitted. So I'm just asking for that entire paragraph to be stricken. I can send a specific number as well.
And what is this sort of like, you believe this is like a health risk, an environmental issue?
Absolutely. I mean, you know, first of all, in combination with the fact that we have gas stoves, gas heating, that's, you know, that in itself is a reason we should have, you know, proper ventilation to the outside. On top of that, cooking anything sets off the fire alarm. Residents often will ignore it or unplug their smoke alarms. So all of that creates more dangerous living conditions.
Okay, thank you. I appreciate your testimony, and I will follow up with DOB regarding this later on today. Darlene Jackson, are you still here with me?
Yes, I am.
Okay. Darlene, you've been through, I think what you describe in your testimony is, and what you've described here, a long process sort of with DOB regarding the contractor, negligent contractor. What was your last communication with DOB regarding holding this contractor accountable?
My legal team had been in contact with them after the OAH hearing, where they were trying to see what the result was. And they just kept being told that they hadn't gotten any they hadn't gotten a ruling. And so when I was preparing to do this, I just happened to make a call to OAH. And the person who answered the phone was the one who told me that there had been a ruling back in October. And they had been telling, DOB had been telling my attorneys that they didn't know about anything. And so then I tried to get the actual document to say that, and I put a request in back in October, and I just received it last night. Yes, just received it last evening at 5:09, actually. Because I wanted to, put something in place to try to see if there could be some reconsideration, because I didn't understand why a civil case would have a bearing on a professional disciplinary hearing. And so probably back in maybe November, December, my attorneys had been, back and forth, just waiting for this ruling to come. And so I haven't had any other conversation with them personally in a while.
Okay. So, and who sent it to you? OAH sent you this yesterday at 5 p.m.?
Yes.
Okay. But DOB stated that they just didn't, they stated to your attorneys they hadn't had a ruling yet.
Correct.
Got it. Okay. All right. I'm going to follow up with them on this. Is there any other questions that you want me to specifically ask that isn't related to the litigation?
No, just like in my testimony, I would love to know why they don't have a problem with the ruling not being made. Okay. What does a civil situation have to do, which, like I said, it's been 3 years.
Yeah.
And it could possibly be another year or so. Who knows? Because this contractor is, of course, using all of his strategies to delay and delay and delay. And I just feel like he should be held accountable. He should be held accountable professionally for what he did to my house.
Yeah, absolutely. Okay. Thank you for that. I will be following up with the director on that. Cynthia Davis, I want to come to you. Thank you for all the work that you all do and the amazing success of the Kings and Queens Child Care Center, and the amazing work you all do. I know you've testified, and I know legislation is already sort of in the works for the Baby Act that has been introduced by Councilmember Nadeau, which I have also signed on to as well. But I just want to thank you for your testimony and let you know that this is something that we will be following up on to make it easier. To make it easier for you and for others in that respect. So I just wanted to let you know that we are moving the ball and we will try to get this done as soon as possible.
Thank you so much, Council Member. We appreciate you, most definitely.
Thank you. I think there was one more person I had. Give me a second. Vanessa Bertilli, that's who it was. Just with permitting and financing the renovation of net zero home, and in that piece, this is the area that I'm really excited about working on this year and working with DOB about particularly. I agree with you. And so I know they put together, they have a good team that I've already spoken with, and so I hope, I'm going to be pushing for that this year and working with DOB. So I just wanted to thank you for your testimony and let you know I 100% agree with you.
Thank you very much, Councilmember.
And I agree, the greener government buildings is a start, but we have to go even further. And so we will try our best to do that as well. So thank you. Thank you, Chairman. I appreciate the time.
Thank you, Councilmember. I want to thank each of the witnesses. I apologize that in my time, I didn't get a chance to ask others questions, but I do appreciate your testimony. We're going to move to the next set of witnesses. So you all are excused. And again, thank you.
Thank you, Council Member and the committee of the whole. Thank you. Have a great day.
You as well.
Thank you.
Shonda Valentine, who is listed as a construction consultant. Sharon Robinson Goods with an LLC, 3601 14th Street LLC. Matthew Bevins, Troy Prestwood, who is CEO of the Prestwood Group and president of the Ward 8 Democrats. Barbara Briggs, who's chair of the Friends Meeting of Washington Committee on Peace and Social Concerns. Sarah Bagay, B-A-G-G-E, Sarah Bagay, Anne Dubais, D-E-B-U-Y-S, Lauren Esrock, Lara Levison, Jean Stewart, who's a volunteer with the Sierra Club, Cynthia Price, Julia Novi with Interfaith Power and Light, Thyra Riley with multifamily, who is a multifamily property owner and president of Tara Enterprises, Inc. Mommy Preston, Angela Franco, who's president and CEO of the DC Chamber of Commerce, Kittlin Peter, who is vice president government affairs at AOBA, Eric Jones, who's vice president governmental affairs commercial at AOBA, Rhonda Hamilton, president of Healthy DC and Me Leadership Coalition, William Crane, who's board member of Foggy Bottom Association, Sandra Bray, who's with Healthy DC and Me Leadership Coalition, district tenant, Yvonne Hunter, same, Christopher Wilson, same, Coretta Hood, same, Emel Bayrak, and Amy Fisher, who's vice president of Realty Group, Inc. So if Shonda Valentine is here, you are next. Been a little loose with the time. Please be mindful if you're in gallery view, you can see the timer. I think it's in the front at the top row of your screen. Ms. Valentine. I see you. It looks like you're looking for your mute button.
Can you hear me?
I can hear you. It's a beautiful.
Okay. Good afternoon, Chairman Mendelson, committee members, and attendees. Because you have my written sworn testimony and, you know, time isn't on our side, I will keep it brief. I am one of the people that expressed that I was really excited at the creation of the Department of Buildings, but my excitement was short-lived. And what I have presented to you is in the form of questions, because I don't understand. I kind of don't understand the DOB leadership and why he was chosen, considering that the DOB director, his what I would call Beltway counterparts, all have backgrounds in engineering or architecture. Most of them do. All of them have at least 15 years of the required knowledge that is actually listed in the building code for a director. And they all have experience managing permitting and inspection shops prior to heading an agency. So looking at the level of demonstrated skill and competence of the Beltway and relevant accomplishments of the Beltway counterparts, I'm unsure how the current DOB director was selected. And also, I listened to Miss Darlene Jackson speak about what happened to her. And one of my suggestions to that was, what I noticed the former DCRA DOB, when it comes to general contracting companies, they're able to get a license as a company, and they're not required to have licenses as individuals. And what that means is that you would have a licensed contracting company, but it doesn't ensure that the person heading your project or that's on your site is licensed as an individual. And I would like to see that happen, where DOB is requiring individual general contracting license where their competency is verifiable through a state competency exam. Another thing that is really a point of contention are required safety inspections. And Towers Condo Association, that project, had 413 balconies that needed to be inspected. There were 3 different inspectors, and each inspector had a different process. Now, the purpose of final inspections and special inspections are safety and to validate that the end structure or the structure, the finished or completed structure, was built in conformance with the approved construction documents. And 2 of these inspectors really did not know how to read construction specifications. I have recordings of both of them. This is a huge risk because you could have 3 inspectors inspect the same unit and they're not looking at the same things and give them a pass or an approval inspection. When I sent the email to DOB, and I sent multiple emails to them asking, are your inspectors checking the construction documents, the shop drawings, the product, the materials, to ensure that they used the appropriate materials, that they inspected all the appropriate places and connections on the balcony? And I have yet to receive a response. And the investigator.
You're 2 minutes over your time. If you could wrap up.
Oh, I'm sorry. Okay.
Thank you. We have your written statement. And I'm going to look at it more closely. Thank you. Sharon Robertson Goods. Well, she's not here. Matthew Bevins. Well, he's not here. Troy Prestwood.
Yes, good afternoon, Chairman Mendelson. Can you hear me?
I can hear you.
All right, well, good afternoon to you, sir, and also to Councilmember Louis George and other at-large and ward council members. I'm Troy Dante Prestwood, a 4th-generation Washingtonian and a small business owner of the Prestwood Group. And I serve as the president of the Ward 8 Democrats and formerly as a commissioner and chairman of the Advisory Neighborhood Commission 8A. I'm here today, though, in my personal capacity to testify before this performance oversight hearing in support of the nomination of Acting Director Ernest Chopra to lead the newly formed district agency permanently. I first met Director Chopra when he led the Department of For-Hire Vehicles, a district agency that was based in ANC 8A. And as chairman of that commission at the time, I worked with the director and with his staff to address several resident concerns about taxi cabs and other vehicle operators taking up limited residential parking spaces in the surrounding neighborhood. I found the director to be very responsive to those concerns, and he committed himself and his staff to working toward a mutual solution for residents. Now, when Director Chopra went on to lead the now former DCRA, it was from this previous interaction that we had with him that our commission extended a warm invitation for him to come and speak with our constituents at a public meeting, where he shared his vision for this agency that he was about to take over, DCRA that was, and he listened to even more resident concerns about illegal construction, the need for increased inspections, and the business registration process. Now, I recall Director Chopper telling those gathered that he heard them loud and clear, and he asked for their help, our help, to shape the agency for the future. I go on to just tell you in my statement here, and I submitted this to you in advance, but I've seen the fruits of the director's vision, from enhancing the customer experience with innovative technology, to streamlining the licensing application and renewal process, to centralizing many business functions under one login. I can't tell you how much that was an improvement over the previous method, which sometimes required different accounts to log into multiple systems. So it's no surprise that the satisfaction rate for DCRA rose to 85% under Director Chopper's leadership. And again, that's due to him having a solid vision of what the agency could and should do. Now, finally, while DCRA wasn't a perfect agency by any measure, it's not every day that we see a large breakup of a complicated agency like DCRA. And when the council mandated this, I had some concerns. I wasn't sure how the breakup would impact some of the agency innovations I mentioned earlier. I recall attending several lists, appreciated the opportunity to speak and ask questions and offer input and suggestions in that process. This was during the pandemic, I should note. And ultimately, in the end, that one big agency was transformed into two smaller ones with different missions and mandates, as you now know. And now the work begins to make them work better for district residents. So it is that last point I wanted to emphasize before I leave. And I can't think of the last time that a director of an agency had to break that agency up into two separate agencies while continuing to run the agency at hand. Now, earlier, I mentioned that the complexity of DCRA, so to break up such an entity, not only do you have to consider the needs of customers, but also of your staff. And from most accounts, Director Chopper rose to that occasion. So I can't think of anyone more capable than the director to lead the new Department of Buildings, an agency he helped to create as mandated by the council.
Crestwood.
Yes.
You're almost a minute over your time.
During my professional interaction with the director, I found him to be intelligent, competent, and committed, a straight shooter focused on results and service for the district. I know as you exercise your due diligence over the new agency to make it work better for the customers it serves, I urge you and the committee of the whole to support the director's nomination to lead it. And I'm happy to answer any questions you have. And I apologize for going over.
Thank you, Mr. Presswood. And it's good to see
you.
Barbara Briggs, who is Chair, Friends Meeting of Washington.
Yes, hi, good afternoon. Thank you so much for this opportunity to testify. As you said, I'm the chair of Friends Meeting of Washington's Committee on Peace and Social Concerns. As you probably know, Quakers have historically concerned themselves with matters of equity, social, and economic justice. And as an extension of that commitment, our meeting is an active participant in efforts to advocate for decent, affordable housing for all DC residents. And we've become increasingly aware that for DC buildings to be decent and safe places to live and work, we must not rely on the combustion of fossil fuels. So I am here today to urge the Department of Buildings that the Department of Buildings work to assure the all electric commercial code under consideration by the CCCB is quickly passed and implemented, and anything that council can do in that direction would be extremely important. Time is urgent. Last year, Friends Meeting of Washington members, together with faith and climate concerned DC residents, conducted a citizen science investigation of gas leaks. We found nearly 400 leaks, including many of them that were over the lower explosive limit of 50,000 parts per million. In other words, a public health hazard, in addition to spewing greenhouse gas into the atmosphere. There's no question that these dangerous leaks have to be patched. But the fact that our gas delivery system is crumbling beneath our feet should also be a signal to us that we have to accelerate the transition that we know that we need to make to all electric and ultimately highly efficient net zero energy buildings to minimize wasteful spending on gas infrastructure. We know that in order for DC to do its part in avoiding catastrophic climate disruption, we have to stop burning gas. But we're becoming more and more aware that when we stop burning methane inside our homes, we and our families will also be much healthier. When gas is burned, it produces nitrogen dioxide and fine particulates, both of which are damaging to the lungs. Nitrogen dioxide is a pulmonary irritant. It contributes to asthma, COPD, hypertension, and a host of other health conditions. Children living in a home with even one gas appliance have a 42% greater incidence of asthma, and some studies are finding that early exposure to nitrogen dioxide may also affect children's neurological development. We're now collaborating in a new citizen science investigation of nitrogen dioxide emissions in DC area homes with gas stoves. We invite you to be a participant in that study. It's too early to report the results, but I can tell you that many homes, including mine, I rent, the nitrogen dioxide concentrations rise to potentially unsafe levels in just 15 to 30 minutes of gas use. So I urge that members of council weigh in and that the Department of Buildings do all it can to assure that the Construction Codes Coordinating Board passes the proposed all-electric commercial building code and then see that that code is enforced. DOB's role is important in keeping DC's residents safe, and this task is time urgent since every new building that is constructed using gas appliances is both an unnecessary risk to its inhabitants and one more obstacle to the critical transition that we are making to protect our climate and the health of our residents.
Thank you.
Thank you, and sorry for going over.
I want to remind witnesses there's a clock, and if you're in gallery view, it should be at the top of your screen. The next witness is Sarah Bagay or Bag.
Here? Thank you. Good afternoon, council members. My name is Sarah Bagay, and I'm a resident of Ward 4. I'd like to share my experience as a first-time homebuyer in the district and the way DCRA's failure to enforce building codes has harmed me and my neighbors. I'm very concerned that the decision to continue the new Department of Buildings with the same leadership will mean that there will be no relief for us and others like us, and that developers will continue to get away with flagrant code violations. I bought my condo in a 6-unit newly renovated building in Brightwood Park in September of 2019. I, along with several others in my building, were able to purchase with the help of district programs for first-time homebuyers like EHAP and HPAP. We soon began experiencing issues with our building that the developer refused to address. To understand the scope of the problem, we consulted a master code professional who found extensive code violations. At the request of this professional, DCRA came out to do their own oversight inspection in May of 2021. They found a total of 47 violations that include failure to complete dwelling unit separation walls, failure to provide fire partitions as required, and failure to properly seal penetrations. Translation of that is that the walls built between our units were not sufficient to stop a fire from spreading. These are not the kind of issues that a standard home inspection during purchase is supposed to find. Issues like these are supposed to be found and addressed in the building inspection process. So why weren't they? Why weren't these problems fixed and addressed before our units were sold? DCRA and now DOB's third-party inspection and plan review program allows developers to hire the third-party agencies approved and overseen by DCRA to review building plans and do code inspections during construction. This means that the people with a financial interest in the project get to choose who does their code enforcement. DCRA is supposed to provide oversight for these third-party agencies, but as our experience demonstrates, this oversight is completely inadequate. As DCRA own inspection notes, the third-party inspectors failed to find dozens of violations, including several life safety violations. DCRA issued us, the home buyers, with a notice to correct the violations within 90 days, and I'll be including this with my written testimony. An estimate of the cost of addressing these violations came in at several $100,000. Our only recourse is to take legal action against the developer who sold us our units. This has already taken hundreds of hours and thousands of dollars on top of the repairs that we'd already had to do to keep our building habitable. And we have no guarantee that the harm that we have experienced will be addressed. Given how difficult this experience has been for us, it's likely that developers in the district often cut corners, knowing that DCRA and now the Department of Buildings under the same leadership will not stop them, and that holding them accountable will be too exhausting and expensive for most home buyers. I'm concerned that nothing will change under the same leadership and would ask the council members here today how the harm that has already occurred will be addressed. Thank you.
Thank you, Ms. Bajay. And you said you'll be submitting your statement.
I will.
Thank you. Ann DeWise.
Yes, good afternoon, Chairman Mendelson, council members, and council staff members. My name is Ann DeWise, and I'm a resident of Ward 3. I appreciate the opportunity to testify today in support of electrification of buildings, and particularly net zero energy buildings in the district. I would like to begin by commending the Department of Buildings for its support of electrification for residential and commercial buildings, thereby carrying forward the mayor's agenda for clean energy in the district. I salute the DOB for doing the right thing for DC residents and for our climate future. A report out this month from the Building Decarbonization Coalition asserts that the entire landscape of building in the US has permanently changed. As we begin 2023, 1 in every 5 Americans lives in an area that has enacted a building decarbonization policy. Both the executive and the legislative branches, including the DOB, along with other government departments and agencies, will need to coordinate and collaborate to an unprecedented degree in order to timely and effectively achieve the transition from fossil fuel-powered boilers and furnaces to electric heat pumps for building heat and hot water. We already know that in order to meet DC's mandated climate targets, a transformation is needed because buildings account for approximately 3/4 of the district's greenhouse gas emissions. Pathways that are working in the US depend largely on regulations in building codes that restrict the use of fossil gas. An immediate concern, as in, I hope, at the next meeting, is the Construction Codes Coordinating Board's all-electric commercial building code revote. This vote has had a dramatic history, to say the least, but now that PEPCO has acknowledged that the power grid can accommodate electrification for the district, we need to remain on schedule with regard to the code cycle. Progress is being made toward using 100% Tier 1 renewable energy sources by 2032, and now is not the time to stall. The technical advisory group's proposed all-electric commercial building code amendments are the logical next step. The climate crisis feels personal to me. I moved here because my children live here, and I spend a fair amount of time wondering what here will be like when they are my age, how the weather will be in 30 years when my 17-month-old granddaughter will be an adult, if we don't live up to our climate commitments. I despair to imagine my granddaughter enduring broiling temperatures, a permanent haze in the air, and a landscape where most of the trees are dying. Perhaps moving to electrification looks expensive to us now compared to remaining with the status quo, but I assure you that the long-term cost of our inaction will be much, much higher. So in closing, I urge all 3 Department of Buildings representatives who serve on the CCCB to vote yes on the all-electric commercial building code. Thank you for your time and attention. Please refer to my more lengthy testimony submitted yesterday. I'm happy to answer any questions.
Thank you, Ms. DeWeese. Lauren Esrock.
Yes, hi. Thank you, Chairman Mendelson, and the members of the Committee of the Whole for this opportunity to testify today. My name is Lauren, and I'm a president of a 2-unit condominium association. I, along with the other unit owner, was a first-time home buyer when we purchased our units almost 5 years ago for a combined $2 million. Fast forward to today, the HOA is now looking at $1.4 million in construction-related defects stemming from building and zoning code violations perpetuated by the developer of the condo, but enabled by the Department of Buildings' predecessor organization, DCRA. To date, we are aware of more than 40 known code violations. I'll highlight the most egregious one now.
The entire facade of the condo is not waterproof, flashed, or structurally sound. When it rains, water leaks in through our windows. We know for a fact we have mold growing inside the building envelope. And based on a structural engineer's review of the approved DCRA plans, as well as photos from the time the house was framed, we know the structure is compromised. Not only did DCRA approve plans without the necessary detail or specifications to prevent these framing defects, they failed to catch them via multiple inspections. Our home is the last one on the block. To repair these violations, every wall except the party wall needs to be exposed and addressed. The work is so extensive, we've been advised we should consider tearing down our home and starting again. Investing $1.4 million on top of the $2 million we've already spent purchasing these new yet defective units. I'm sure the Department of Building and Acting Director Chopra will tell you they've since reformed and have put in place measures that ensure no future homeowner will face the same situation. However, I attended the DOB open house last week, and I can tell you I'm not reassured. I had an extensive conversation with the Deputy Chief Building Official who oversees the day-to-day operations of inspection and compliance administration. The official tried to tell me what I'm experiencing happens to just 4 to 5 homeowners each year. Based on the number of people I've met through this situation, I challenge that number, which begs the question, does the agency even know how many homeowners in the district are in my situation? Do they track the number of warranty bond claims made through DHCD? Every time a homeowner needs to claim that bond reflects a failure of the Department of Building to ensure compliance with building code. The deputy chief smiled knowingly when I divulged my home was inspected by a third party with a no unquestionable track record. I asked point blank, if you know they are a bad actor, why are they still 5 years later inspecting homes? The answer given was a cop-out and shifted accountability to another agency. If DOB truly wants to reform, we need leadership that understands the extent of the damage they are inflicting on district residents and has a mandate to challenge the status quo for the better. Thank you for this opportunity. I'd be happy to answer questions.
Thank you for your testimony. I'm sorry that you are having this experience, and that goes as well for the other witnesses who've testified regarding their problems. Unfortunately, we hear this at these hearings, and it's a challenge to try to get the department to be more responsive. Again, thank you for your testimony. Lara Levison.
Yes, thank you. And also very sorry, Lauren. That's really awful. Thank you, Mr. Chairman. My name is Lara Levison. I've lived on Capitol Hill in Ward 6 for about 40 years total. I'm testifying today in strong support of the proposed all-electric building code for commercial buildings. The district's building code is developed, as you know, by the Construction Codes Coordinating Board with the support of the Department of Buildings and enforced by DOB. If anyone is wondering why we need building codes, well, look at Lauren's experience, but also look at the massive earthquake deaths in Turkey, where building codes were poorly implemented and enforced and many buildings collapsed. My concern today is a slow-moving tragedy that is already claiming lives around the world, the crisis of climate change. To reduce the impact, we in DC must do our part by eliminating combustion of fossil fuels in our homes and buildings and moving to electric appliances as quickly as possible, including heat pumps and induction stoves. Eliminating fossil fuels for heating and cooking has local and personal benefits as well as climate benefits. We will reduce air pollution, both indoors and outdoors. Gas appliances in our buildings, as I think others have said today, emit many of the same pollutants as car exhaust. Also, electric heat pumps are significantly more efficient than gas boilers and water heaters and will save us money. At the same time, the electricity powering these highly efficient electric appliances is becoming increasingly cleaner, since DC law requires that all of our electricity come from renewable sources by 2032, thanks to the renewable portfolio standard that you champion, Chairman Mendelson. The Construction Codes Coordinating Board is soon going to vote on an update to the building code that will require all new commercial construction to be all electric. Commercial construction includes large multifamily apartment buildings over 4 stories high. The CCCB already approved all electric requirements for smaller scale residential construction. I strongly support the all electric commercial building code and urge the Department of Buildings representatives to vote in favor and encourage the other CCCB members to vote in favor as well. I want to close by speaking to those of you who are attached to cooking on gas. I know you love gas because of that blue flame and because it's faster to adjust than an electric resistance burner. You also love cooking on gas because of decades of intense advertising and indoctrination by the gas industry. I've cooked on standard electric resistance stoves and on gas stoves. Now we have an electric induction cooktop in our kitchen. It is faster, cleaner, safer, and more responsive than any other type of cooking I've tried, and I've never looked back. So give it a try. I love my stove as much as you love your electric vehicle, Mr. Chairman, and thanks for the opportunity to testify.
Thank you, and I do love my electric vehicle. Thank you, Ms. Levison. Jean Stewart.
Good afternoon, Mr. Chairman, council members and staff. My name is Jean Stewart. I should have identified myself as a public witness, and I apologize for any confusion. And I'm actively engaged as a volunteer in getting buildings in DC to transition from fracked gas to electricity from renewable sources. I've been involved in these efforts because of the looming climate crisis, knowing that the effects of climate change are already a clear and present danger for us here in DC in the form of flooding, increased heat waves, and increased air pollution. I'm also actively involved in ensuring environmental justice for our lower income communities as they suffer the most from the impacts of climate change. You've already heard from many of my environmental colleagues and friends about the degree to which buildings contribute to air pollution and our carbon footprint here in DC. Most of that, of course, comes from burning fracked gas and burning methane, which is the principal ingredient in fracked gas, produces, as you've heard, numerous pollutants, especially nitrogen dioxide, which in interior air has been shown to exacerbate asthma and cardiovascular disease and other health consequences. Fracked gas is also leaky, and I was a participant in the leak survey that Ms. Briggs talked about, and in my neighborhood of Adams Morgan, and we found our biggest leaks in front of the Harris Teeter and St. Augustine's Catholic Church, which is pretty frightening. But all these leaks significantly also add to DC's carbon footprint. And methane is 84 to 87 times more potent than carbon dioxide as a greenhouse gas. And like previous witnesses, DOB is a key player, and I urge DOB to support getting DC buildings to transition from gas to electricity to achieve DC's climate commitments as soon as possible. And since DOB provides 3 members of the CCCB that sets the building codes, I urge those 3 members to vote for the new construction codes. And I certainly urge the other members of the CCCB to vote for that. And I understand that this all-electric commercial code proposal will be voted on again at the March meeting of the CCCB, not, in years, as a previous witness said. And I urge the council also to remind the board that approving this code proposal is a meaningful step toward achieving the mayor's commitment to carbon neutrality and to executing decarbonization laws enacted by the council. Thank you.
Thank you, Ms. Stewart. Cynthia Price. Cynthia Price. I'm told that she might be in the waiting room, but she hasn't accepted, so we'll keep moving. Julia Nove.
Yes, Novi.
Please proceed, and good afternoon.
Good afternoon, Chairman Mendelson, council members and staff. My name is Julia Novi and I live in Tenleytown. I am here speaking on behalf of Interfaith Power and Light, an organization through which congregations of many traditions are working together to respond to climate change. I also speak as someone in my 20s who has lived in DC most of my life and hopes to continue to live here, breathing healthy air and enjoying a livable climate. Maybe older people take our world's habitability for granted, but for those of us born above 350 parts per million, we understand that being able to live here is a sacred gift that is by no means guaranteed to us. I'm here to support the all-electric commercial code currently before the Construction Codes Coordinating Board. If we as a city want to do our part to fight climate change, have clean and healthy air to breathe, and live up to our moral and practical obligation to be good stewards to our common home, we cannot keep constructing even more new buildings that burn gas. When methane gas leaks, it acts as a powerful heat trapping gas, dozens of times more potent than CO2. And gas leaks a lot. As Barbara already mentioned, last year, over a dozen congregations walked their neighborhoods with a methane detector, finding 389 leaks across all 8 wards, 14 of which were at or over the methane concentration at which an explosion is possible. Leaking methane also oxidizes to form smog in our air, which makes our neighbors sick with asthma and chronic obstructive pulmonary disease, or COPD. Even when they are not in use, gas appliances in buildings leak known carcinogens like benzene into the air we breathe. When gas burning appliances are in use, they release toxins and respiratory irritants like nitrogen oxides, fine particulate matter, carbon monoxide, and formaldehyde. When a gas stove is used to cook dinner, more children tend to use their inhalers that night. Principally, though, burning gas releases carbon dioxide into our atmosphere where it lasts 300 to 1,000 years, which makes transitioning off gas and other fossil fuels as quickly, efficiently, and equitably as possible all the more urgent. We know that our actions today, the CO2 we release today, will stick around, affecting the lives of beings a millennium in the future. To me, the fact that our planet evolved to support human life is such a miracle, one that took millennia to unfold. I can only describe it as a sacrilege to continue lighting on fire the miraculous and limited resources that support human life. To the Council and to the Department of Buildings representatives that serve on the Constructive Codes Coordinating Board, for yourselves as humans living on this planet, for the children getting asthma now and who will inherit our climate calamity when they grow up, for all the future generations at the mercy of our actions today, I sincerely entreat you. The Construction Codes Coordinating Board must vote in favor of the all-electric commercial code at their upcoming meeting. Thank you.
Thank you, Ms. Nove. Thyra Riley.
Yes, sir. Just a moment, please.
Please
okay,
proceed.
Very good. Thank you. Good afternoon, Chairperson Mendelson, Chairperson Lewis George, and members of the Committee of the Whole and Committee on Facilities and Family Services. My name is Thyra Riley, and I'm a proud resident of Ward 4. I'm also the owner of 60 affordable rental units in several apartment buildings that I own, located in Upper Northwest DC and on Capitol Hill. The purpose of my testimony is twofold. First, I wish to provide strong praise for the excellent work that the Department of Buildings does to set and fairly enforce, at least in my case, clear and transparent housing maintenance and safety standards to govern the quality of housing and facilities infrastructure across the city. Over the years, I and my property management team have been sincerely committed to providing a safe, secure, healthy, and a well-maintained living environment for all of my tenants and their families, and I have had very few legitimate violations reported. Nevertheless, I would like to summarize two very unusual circumstances that gave me contact with DOB that truly earned my respect. In the first case, a well-known professional tenant began to ongoingly report false emergency violations to DOB with the very explicit fraudulent intention to extort $11,000 from myself as the landlord. The other tenant has mental illness and a boyfriend who used her to intentionally cause and report to DOB severe blockages in her unit's plumbing that flooded several units on the lower floors in his effort to also extort me for money. In both these cases, DOB inspectors, legal advisors, settlement officers, and support staff were extraordinarily responsive and professional to receive from me picture and video evidence proving abatement of the reported violations and the evidence of the false reports before they very fairly settled or completely dismissed the notices of infraction and the associated fines. In short, I learned through my direct experience with several of DOB's staff that they do truly outstanding and very competent work, all while being respectful, courteous, and extremely fair to both landlords and tenants. The second purpose of my testimony is to appreciate the critically important role that DOB continues to play to protect the beauty and character of Washington's several historic districts, including the Rock Creek Park Historic District where my home is located. Recently, the required permit review and approval role by DOB and the U.S. Commission of Fine Arts under the Shipstead Loose Act of Congress protected my home and my property from what would have been unjustified and irreparable damage by one of the public utilities. DOB's protective permitting role will be crucial in the days ahead as the public utilities carry out accelerated infrastructure replacement projects. In conclusion, I want to thank you and your staff for providing me with the opportunity to talk about the extremely positive experience that I have had with the Department of Buildings and to share with you my thoughts about what a tremendous asset I feel the DOB is to the city in its efforts to maintain the high quality and safety of the city's housing and other infrastructure. Thank you very much.
Thank you, Ms. Riley. I believe Cynthia Price has come on. You're here.
Hi.
Please proceed.
Hi. Let me adjust my video here for a second. I guess this is as good as it's gonna get over here. So, sorry. Move this way. Okay. Good afternoon. Thank you for having me here, Chairman Mendelson, Council Committee members. I'm here today to relate my story regarding an illegal construction project on the house next door at 230 12th Street Southeast that has potentially adversely affected my property at 228 12th Street Southeast, along with my attempts to try to ensure that this does not become a situation that goes from bad to worse. You may have already seen my story about my damaged wall, which is behind me. And if there's time, I'll try to show you with the camera. It was on WJLA TV on February 10th and then on the internet. But let me sum it up for you. This is the wall that has been adversely affected. And I don't know if you can see, but it's got some pretty big cracks in here. You can stick your finger in here. And it has mortar that has crumbled out. Here are a couple pieces of the mortar right here. So in summary, the next door neighbors embarked on an illegal construction progress on December 21st. No permits were posted. I received zero warning and no efforts were made to structurally protect my property. This work continued throughout the holidays. Then on January 3rd, workers began chipping away bricks along the neighbor's interior party wall on the other side at which point my exposed brick party wall developed deep cracks and the mortar crumbled. I became frantic and I called 2 neighbors. The first spoke fluent Spanish, said there were no permits posted, and told the workers they had to stop. They continued on. The second neighbor gave me the direct numbers for her contacts at DOB. Luckily, I immediately got through to a DOB rep who got in touch with HPO, and HPO came out and put a stop work order on their front door because there were no permits. I also received an email that DOB would be coming by the next day, January 4th, for an internal inspection of both houses, but they didn't show up. So after that, I waited for 5 weeks. Finally, on February 7th, upon learning that from the tenant next door that the owners were almost finished getting their proper permits, I again became concerned because DOB had not been out to inspect the wall situation, and I really worried that my wall might collapse if the interior brick chipping on the other side resumed. I also filed an emergency request online for an immediate inspection.
Ms. Price, I hate to cut you off, but you're like halfway through page 1 of your 5-page testimony and your time is up. So perhaps you could summarize?
Okay. My concern now is that I'm working with I'm trying to find a structural engineer. I'm trying to work it out with the owners next door. I'm in contact with DOB, but my concern is that didn't it used to be that this was just mandated that the offending party would, have to get structural engineers involved and pay for the repairs, and now they push you into a civil lawsuit? And so that's what I want questions answered on. I mean, for me to be dealing directly with his contractor, isn't that kind of like, letting the fox in the hen house? And how am I going to be guaranteed that this work is going to be done correctly and not just a cosmetic fix? So those are my questions. And I'd like to know how I can proceed and not have to spend that possibly tens of thousands of dollars in a civil lawsuit.
What has the Department of Buildings said to you?
What have they sent to me?
Said to you?
Oh, that the 2 homeowners have to work it out on their own, and the stop orders, there's 2 of them, will be lifted when we come up with a plan. And again, right now I'm trying to get a structural engineer in so that they can look at the wall and advise what needs to be done to fix it, and then come back and make sure it was fixed correctly. And I've been in constant contact with DOB, and the stop work orders are holding. But again, I don't see why I should have to pay for all this when I just woke up one morning and there were workers standing on scaffolding in front of my bedroom window. I mean, no warning whatsoever. So that's what I want questions answered about.
Okay, thank you. I'm not sure I can answer them, but in fact I can't, but I'll ask the director about it. Thank you.
Okay.
Mommy Preston? Is Miss Preston here? We think you're in the waiting room. You haven't clicked to accept to come in to testify. I'll come back to you if you join us. Is Angela Franco here? I believe she's not. Caitlin Peter from AOBA, are you here?
Yep, I'm here.
Please proceed.
Thank you. Good afternoon. My name is Caitlin Peter. I am the Vice President of Government Affairs for the Apartment and Office Building Association of Metropolitan Washington, otherwise known as AOBA. We represent members managing nearly 100,000 multifamily properties throughout the district. My counterpart, Eric Jones, Vice President of Government Affairs for AOBA, will be testifying today on behalf of our members managing commercial and office properties. Together, we will share questions, insights, and recommendations on our collective work with the newly created Department of Buildings. Our goal is to address issues we believe we can work together on most productively. First, AOBA respectfully asks the committee to hold off on any new measures related to proactive inspections and shift its focus on improving the efficiency of the current program. Foremost, AOBA believes diligence is needed to assess the current proactive inspections program to determine whether how it's being applied in practice is practical for both DOB and those on the consumer end, housing providers and tenants. AOBA continues to recommend we do prioritize inspection efforts for habitual code violators who fail to abate conditions and respond promptly to tenant complaint-based reported violations. We may also want to consider focusing proactive inspections on during this time, DOB can inform residents that it will conduct in-unit inspections upon request.
Ms. Peter, for some reason, you're becoming harder and harder to hear, or softer and softer.
My sound is on. Can you hear me now?
Softly.
Softly? I don't know. How about now? I'll go closer to the screen.
Or speak up.
I saw Councilmember LaGeorge put her finger. Okay, cool.
She has better ears than I do.
May I start with the paragraph prioritizing? Okay. AOBA continues to recommend we do prioritize inspection efforts for habitual housing code violators who have failed to not only abate conditions and respond promptly to tenant complaint-based violations. We may also want to consider focusing proactive inspections on common areas. During this time, DOB could also inform residents that it will conduct in-unit inspections upon request. Supposing DOB reintegrates notices of violation back into the overall process, which I'll discuss after, such reforms could make for a more straightforward, cleaner process for responsible landlords while being extensive enough to capture bad actors. The next issue is that we do believe DOB has become much more aggressive in the issuance of notice of infraction. Another problematic issue for AOBA members is the assessment of notices of infraction versus the notices of violation. This is an issue we've discussed before. AOBA does believe DOB should provide property managers a reasonable time for abatement through NOVs first instead of immediately issuing an NOI. It's our understanding once an NOI is issued, it still must be officially dismissed at the Office of Administrative Hearings. I think there is some sort of confusion on exactly how this works in practice, how it's supposed to work, and how it's being applied, which is why the first recommendation was to ensure that parties on all ends, tenants, landlords, and DOB are all on the same page. Overall, the current process, or at least the way our members tell us that it's being applied, it ends up being much more expensive in the long run because if they had an NOV issued and they were able to abate it very quickly, they wouldn't have to go through any additional costs for dismissing an NOI when that time and money could be more readily spent on making the repairs. I go into my written testimony on what we'd be looking for, whether it's an NOV, whether it's through NOV or perhaps a light NOI process. We think that there are multiple ways which you can get to this. And finally, AOBA urges the council to convene a working group of DOB stakeholders. And we've made this recommendation before, and we wholly recommend the committee convene its own group of stakeholders, including housing providers, DOB staff, and tenant advocates to make recommendations for systematic improvements to the current programs. AOBA is now working with DOB on an education session. So there's currently still a great deal of confusion in the industry.
Thank you, Ms. Peter. And next is Eric Jones, also from AOBA.
Good afternoon, Chairman Mendelson, Councilwoman Lewis George, and members of the Committee of the Whole. My name is Eric Jones. I'm the Vice President of Government Affairs for the Apartment and Office Building Association in Metropolitan Washington. I represent the commercial portfolio, which now encompasses over 70 million square feet within the district and makes up roughly about 10% of the district's overall commercial tax revenue on an annual basis, according to the CFO's estimates for FY 2022. In a matter of time, I will not read my full written testimony. I will, however, cover two issues. As background, I'm also a fourth generation Washingtonian, raised in Ward 5 and currently a Ward 4 resident. For those who are having issues with home issues, I also empathize as someone who spent his birthday last Friday, dealing with an issue that's cost my wife and I nearly $107,000 to deal with a faulty basement that has been leaking for the entire 6 years we've owned our home because of faulty inspections. So I do understand and empathize, but I will address two issues. First off, we've talked a lot about inspections. One of the things that I've testified before this body on over the last 8 years is the lack of qualified inspectors. We've heard a lot about inspections and failure to deal with inspections, but the city has done little to nothing to actually increase the number of licensed and qualified inspectors. There's been no pre-apprenticeship program, no license training program, or no real investment within the school system, within the CCDC, UDC structure, or working within the private sector to actually increase the number of maintenance and management folks who also qualify as licensed inspectors. This has led to a dearth, not only within the district, but throughout the region, and has created issues as the district is still unable to attract and qualify licensed and certified inspectors to increase the number of folks who are able to properly inspect properties and do the work that is in question to deal with a lot of the issues that we see today. In addition to that, I also want to talk quickly about the CCCB because there's been a lot of conversation about the vote on full electrification. We've heard a lot of folks talk today about equality, equity, and inclusion, yet when we look at the CCCB structure, there's one minority who's on the CCCB, and he was the last to be appointed. We talked about full electrification, and the tag in question has no native Washingtonians, no minorities, and they have no one from the construction industry outside of one person whose firm personally stands to benefit from pushing forward a full electrification tag. The reason that the proposal was voted down in October is because of false information, shoddy reports, and the inability for anyone to prove that the actual required amount of electricity can be approved. Likewise, we talk about affordability, but this same council at the end of last year approved a solar for all proposal that was shown to cost an additional $1 billion to district taxpayers, have a negative racial economic impact, and I only had one council member who was willing to stand up against it to this proposal that was written by a former council staffer who now represents the industry. I feel like we're being hypocritical when we talk about affordability, affordable housing, and truly dealing with the issues before us. If we're going to talk about the CCCB, they follow council guidelines, which never actually reintroduces this proposal that has been voted down during that session. Yet we're asking the CCCB to do so because faulty information cause folks to vote against it. Mr. Chairman, I ask you to hold the CCCB to the same standards that you would hold the council that you're in charge. Thank you.
Thank you, Mr. Jones. You had in your statement also something about certificates of occupancy.
That is correct. I left that off just in a matter of time. So certificates of occupancy have had a large issue because of clean hands and other items that has carryover with OTR and other issues. And we've been working integrally with DOB, myself and my colleague Catalin. We've seen some progress, but the issue has been the interaction between OTR and DOB, and has required us to work a lot harder to get certificates of occupancy issued in a timely manner.
If I'm allowed to, Chairman, permission to make one note on that.
Quickly.
When certain websites automatically will direct us to another agency, and then when we go to put in our information there, we get these, basically, you can't move further without going through this other. We can specify, I can work with your staff on exactly where the clashes are coming. It seems like one system is not speaking to the other, and we'd like to be able to close that so we can move some of these things forward, and not even just move them forward, but so they're not stuck.
Thank you. Dr. Rhonda Hamilton.
Yes, greetings, Chair, members of the whole, and staff. We are so thankful for the opportunity to testify today. I am President and CEO of the Healthy DCME Leadership Coalition, which is spearheaded by the Mental Health Casework for My Mother's Keeper, our founding organization. We are mental health, trauma-informed housing rights, and social justice advocates. I'm here today in order that our testimony can be in support of the positive attributes of the Department of Buildings, formerly DCRA. I would like to understand and acknowledge that there's much testimony here today that we also support, because there is room for. I would like you to understand that a little bit over 3 years ago, we received intake from community members on the Ward 8 level in a community village as a result of the egregiousness of exposed housing conditions. We have formed the Woodbury Project, which is on our healthydcandme.org website for those who need more. Sir, I want to acknowledge the exemplary work, first and foremost, of an employee of the district, because too often they're receiving the brunt of what happens when we have systemic failures and not proper oversights and accountability. Inspector Gamboa stepped in the midst of what we found to be an atrocious level of what we'd like to recognize as slumlord reality over in the capital realty ownership community of Woodbury Village. I want the council member and the council to consider the following. As we've heard much testimony today, we have not heard the understanding or representations from tenants themselves that have expressed concerns with their mental wellness challenges as a result of their housing injustices. I would like for the council to consider that over 100,000 citizens in the district were documented to have reported feelings of depression. I also want the council to recall the fact that at least 1 in 5 Americans are going to experience mental illness in any given year and in their lifetime. DC citizens who face challenges and instability in their housing are also reporting, sir, instability in other areas of their daily living and mental wellness. I want you to understand that housing injustices are causing stress, hospital visits to the emergency room, depression, compromised health challenges, trauma induced from hallways that are filled with gun brandishing, loitering, gun shootings, and folks that are sleeping in their buildings because the buildings are not secured. Much of these realities has kept many of our constituents from the voting polls and from participating in hearings such as today. I would like you to acknowledge and recognize that there are 3 of our 4 tenant representations that represent housing rentals in the areas of Ward 7 and Ward 8. I would like to represent that because these are lengthy processes and many of our citizens that want to participate are seniors. I would like you to refer to our testimony and acknowledge that Ms. Cornelia Hill, the president of the Woodbury Village Tenant Association, is going to step in for Ms. Claretta.
Thank you, Ms. Hamilton. Let me go to the next witness, William Crane from Foggy Bottom. Well, he's not here. Sandra Bray. Yvonne Hunter.
These are 10 representations.
Good afternoon, Ray. I couldn't unmute myself.
Okay, Miss Bray, you're next. Please be mindful of the clock.
Okay, am I on now?
You must be. I'm talking to you.
Okay, great. I just wanted to say, all right, well, great. Well, my name is Sandra Bray, and I'm the president. I'm a resident at Marbury Plaza, Southeast DC, Ward 8. And I am vice president of the Marbury Plaza Tenants Association. So thank you for hearing me. Living at Marbury Plaza moves me to implore changes be made to strengthen the real and intended power of the Department of Buildings and the ability to enforce the safety regulations that slumlords notoriously get to avoid. I moved here in 2018. Mold showed through my unit by 2019. By 2020, it covered my entire dining room wall, several closets, and my second bedroom. Despite efforts to gain response from management, I was completely ignored until late 2021 when I was moved into another unit. 2 months into that unit, it showed that there was water leakage, that there was disturbed asbestos, and what appeared to be more mold. Now, Marbury Plaza has never inspected any of my units for mold. I paid for an independent inspection in my first unit that advised me to move out immediately and to dispose of everything that I had in that unit. Despite many requests, no inspection has been provided for my current unit. DOB and OEE have not been able to provide inspection assistance. In spite of living a lifelong holistic lifestyle, my health has declined rapidly and continues to worsen. I have been healthy with no flus or colds since the 80s until I moved here. And now I'm awaking every night with pain in my body. I'm also congested in my head and in my chest. And now it's an everyday concern. In addition, I live in the stress of unsanitary conditions on the common grounds. Garbage is overflowing, and there's extreme structural damage, water leaks, mold, asbestos, exposed wiring. Tenants here live among vagrants in the hallways, the stairwells, the laundry rooms, and violence, including shootings on a continual basis with inadequate security and easy access. The elevators don't work. They're not dependable. Maybe 2 out of 4 might work at any given time. Sometimes none of them work. Large rats are seen throughout the complex and in the garage, where the stench of open garbage is deplorable and sickening, considering the airborne disease is just horrific, and the garage is sinking. I moved here in 2018, and conditions have continued to worsen. When I signed a lease with Marbury Plaza, they made me certain promises, the most fundamental promise for my safety. Among others, this has been breached, and yet I'm expected to continue to pay rent and to absorb rent increases, while the courts and the owners give the owners more time to make changes to a history of neglect. We wait, living in danger and sickness and the threat of even death due to toxic exposure and unsecured premises in the midst of violence. We pay for the slumlord's financial convenience of time awarded with our own lives. We're sick, we're depressed, we're anxious with the ineffective regulations that don't prohibit these slumlords' practices of demolition by neglect. Again, I must implore that DOB be strengthened to deal with the severity of these issues, because human lives are depending on it. And what are we about if not humanity first? With that, I thank you for my time. And that's it.
Thank you, Ms. Bray. I and my office have been out to Marbury Plaza several times to look at the situation you described. And my understanding is that the Attorney General has litigation against the landlord. Thank you for your testimony. The next witness is
and it's been stayed.
Ms. Hunter here?
Yes. Can you hear me?
I can hear you. You're next. And you're okay. Turn on your camera.
Now that I don't know how to do. I'll start the video.
Well, it might be at the bottom of your screen. You click
I have it. I think I have it. I have it. Can you see me?
I can see you. There's a big light in the background.
Yeah, it is a big light. Oh, now you really can't see.
Now it's in darkness.
Okay. Maybe I'll turn this way.
Oh.
Good afternoon.
Beautiful.
My name is Yvonne Trent Hunter. I'm a 4th generation Washingtonian of DC also. I now reside in Ward 7 on Nash Place Southeast. In 2020, I live in a 22 unit building. There's 22 buildings with 4 units in each building. It was sold from under us and we didn't know anything about it. In August of last year, one of the buildings caught a fire, because we do have electrical problems. The tenants were misplaced. They weren't given anywhere to stay, and they're still misplaced. They're now renovating the buildings and telling us, and a lot of us are seniors that live here, that they're making them into a two unit building. And we have one bedroom now. They're making it into a 2-bedroom unit. And they're gonna charge us $1,000. As you know, most seniors don't have that type of money to pay for rent, and we're going to be misplaced. So what they're doing is they're renovating each building one at a time and moving us from building to building. Once the renovation finishes, that means we have to leave. I indicated about the electrical wiring. Some of the buildings still have fuses, and that's what I think caused the fire in August of 2022. My building doesn't. We do have a fuse box, but it cannot accommodate the new electronics that's out today. Because if we're using one thing, we have to turn off another, or it'll turn off all the lights. Not only that, some of the buildings are dark and people can't even see how to get into their building, and you don't know if someone's lurking in the dark. Because they're doing renovations, we have a rodent problem now. Rodents are running from one building to the other. As I indicated before, the safety of the property is bad. Rodent infestation is terrible. And number one, the price that they're trying to charge us, they're pricing us out of here. And we have been living, most of the people who lived here have been living here decades. We haven't just moved in. I've been here almost 10, 15 years. One resident who's 80 years old has been here 40 years. These buildings are 124 years old. So we need some help. We need someone to help us because we don't know where we're going to live. So I'm asking the council and the Department of Buildings for help with holding your landlords and the district accountable to each of the tenants living in our apartment complex to help us to find out what we're going to do. We're just being placed from place to place, and that's not fair to us. Thank you so much.
Thank you, Ms. Hunter, and I do have a copy of your statement. Christopher Wilson? I believe Christopher Wilson is not here. That would bring us to Coloretta Hood. Is the person that somebody else is going to testify for? Or is Claretta Hood here?
Yes, Miss Hill. How you doing?
Okay, your name again is?
Cornelia Hill.
Cornelia Hill.
Yes, I spoke with you, Mr. Middleton, and you've been to my house, 2244 Savannah Terrace. I'm in Woodbury Apartments. You've been here when the Capital Realty took over our property, which was 4 years ago, 2020, whatever, however. They took over our apartment in 22, I believe, 2020. And you've been over, we have mold, we have mildew, we have rodents, security, they put key fobs on our door, and each door is open. From day one, them giving us the key fob, they have never worked. I have a tenant, which the tenant who was supposed to talk for us, her health couldn't take it, so she had to leave. In her home alone this week, she has caught 10 mice. Not only that, I had another tenant who said that they also caught 10 mice in a weekend. That is very inhabitable. We have ceilings falling down. One of my elders here, ceiling that fell down 3 times. She sits in a bathroom with the umbrella up because they came by, supposed to have been fixing the ceiling, and they have not fixed it yet. We have crime. We have security on the premises. We have a 16-year-old young man who was in the news who got killed in the apartment building, and the tenant and the property manager said it didn't happen on a unit. We have pictures showing the medical examiner out front. It's ridiculous. Gun violence, not every night, but quite a bit. We have a store up the street. It's not the part of us, but still, because of the trafficking and the tenants up at the store, allowing them to bathe in their stores, it's really ridiculous. Again, I say the property manager, we can't even get in contact with them because why? They do not answer the telephone. It's just one thing after another. It is ridiculous. Our owners, which is Moshe, I don't know Moshe's first name, but when he came on, he promised this, he promised that. We have had 3 sets of new property people in that building. One called me last week asking me to come and meet with them. I am the president of Tenant Association. I'm not coming to meet with them. They have not yet complied to the very first thing they said they was going to do. Nothing. They moved us in when they took over. They took all garbage disposal. Now rats come with trash being thrown anywhere. They took out garbage disposal. You know what the owner told us? Because they don't want to fix all single garbage disposals. Who do that? It's ridiculous. It really is. And we have people sleeping in our buildings also. I'm one of the tenants who moved up to Marlboro Plaza in this transition. And guess what? What the young lady said about Marlboro Plaza is so true. They was turned asbestos from in front of my door while I lived there. I see my time ran out. See, this doesn't even cover all that we have to talk about. This is so sad. And again, I say, Phil Milton, you have been in my home. You have been to our tenants' homes. And we still have no help after 4 years. This is ridiculous. I'm in therapy. I hate to even raise my voice, but this is so mental that I hate even talking about this property. Because literally, I'm in therapy because of this foolishness. Raising rent without even, we are on rent control. How do you raise someone rent without letting them know? Before it's time for research time. How do you raise rent? But again, we're here and nobody's doing anything. I've contacted Trayvon White. You have been to my house, Robert White, the mayor's office, attorney general, who dropping the ball. These people don't have heat, no air. It's cold. And it's ridiculous. So I thank you for hearing what I had to say. You even called me also, Phil Milton. You called me.
If you want me to come back out and walk around, I'm happy to do that.
Something.
You come around and do what? What you gonna do?
Well,
you gonna get rid of them? Are you getting rid of Capital Realty? Because they're doing nothing.
There's a limit to what I can do. I can't get rid of the landlord, and I can't make Department of Buildings do what they're supposed to do, but I can join you in putting pressure on them. So I still remember when I visited a couple of years ago, it was before the pandemic, and
no, you came after the pandemic. You came after the pandemic.
But I remember
they moved us in the pandemic.
I remember the heat wasn't, there were several buildings without heat. And I remember that the then DCRA was much too slow with regard to coming back to re-inspect to see if the heat was back on. But I'm happy to come out if you want, work with my office and we'll schedule it. And if you don't want, that's okay too. And all I can do is try to help you. Thank you for your testimony.
All right.
Thank you. Emil Bayrak. I believe that person is not here. Amy Fisher.
Hi. Let me get video. There we go. Hi.
Good afternoon.
Good afternoon. Thank you for having me. Our property is currently under siege on two sides. We're the center house in a row of five in what was once a row of five. Hats off, by the way, to Mr. Meloff. I'm also here to discuss the neighbor notice. Originally, a single developer held the other four properties and provided us the old notice for development of the two properties to our north, and then sold those properties to a second developer. The notice was received under the old regime, gave us 30 days to become experts in the housing code and provide technical objections. We spent approximately $18,000 on legal and architectural review and provided several pages of technical objections. The new developer got their plans approved last October without addressing any of our objections, and we now have a 12-foot hole next to our property with footings poured. Last week, 5 months after the work began, we received a single-page neighbor notice indicating they'd made a few insignificant changes to the original plans that we'd objected to. At no point were our technical or other objections addressed. It appears we fell entirely through the cracks in the transition from DCRA to DOB. On the south side, we received the new version of the neighbor notice. Gone is the clear time frame in which to respond, as well as any mention of anyone at DOB to receive and ostensibly review a copy and any objections we might have, leaving us entirely to our own devices to deal with the developer. The notice again comes without without so much as a pamphlet to explain the process or let us know what our rights are. That developer is currently demolishing the remaining 2 properties to our south side without water to keep down the dust, blanketing the neighborhood in filth. In order to get sufficient window light into his new structure, his plan includes turning our former row house into a semi-detached property with a 7-foot walkway between us. These houses were built with heating primarily on the exterior walls, front and rear. We now have a 30-foot section of exterior wall exposed without a single radiator on the inside. The developer plans propose finishing the exposed wall with a product that would have been a measly R10. Our architect correctly pointed out that the plans showed no areaway drain and inappropriate drainage under the foundation did not meet code. The developer delivered an alleged revised set of plans on Tuesday. Our architect just advised us that the details don't confirm his assertions. There's no topping slab, blah, blah, blah. There's a series of things in my testimony. Council members, the developer's assertion that the DOB has approved these plans is terrifying and unacceptable. The revised plans were delivered with a snarky remark saying the developer had already spent an additional $30,000 to build the wall to our specifications, and he's not going to make another change. We're now out of pocket another $5,000 and counting, and that's just to get him to build the code. My testimony last year was to protest the old neighborhood notice, which putatively had someone at DOB looking after our objections. My testimony today is to protest the new neighborhood notice, in which the DOB appears to have entirely absented itself when it comes to protecting existing property owners. Please explain why we are the ones paying to provide architectural advice just to get developers to build the code. Please explain why there's no evident protections at the DOB for existing property owners, and please explain why are developers permitted to demolish properties before plans for new developments are fully vetted. Thank you.
Thank you, Ms. Fisher. Do you want to tell me, are you okay telling me what street we're talking about?
Sure. I'm at 427 13th. The development in question is at 423 and 429.
It's northwest.
Northeast, sorry.
Capitol Hill.
Cap Hill.
That would be in the historic district.
No, we're 1 block off.
Okay.
But we're commercially zoned, so what they can build is twice as big and twice as impactful as the usual residential redevelopment.
Thank you.
Thank you.
I do not have any other questions for you or the other, because I've been asking questions all along. Let me see if Councilmember Lewis George is here, if you have any questions. Councilmember Lewis George here. Here, she's not here. Here's that she is. We're going to move on. I want to thank each of you for your testimony. Some of this has been a little bit painful to hear, painful in the sense that you should not be experiencing what you're experiencing. And I'm going to, I will be asking some questions of the director based on this testimony and probably following up with him on other questions in writing. I do see Councilmember Lewis George. Did you have any questions for the witnesses before we move to the director?
Just 2. I just wanted to ask Sarah a question and Laura Esrock, I believe. Hey, Sarah, can you, if you could, walk me through what what happened in your situation?
Yeah, so once we moved in, we hired a master code inspector to come in and check things out because some things weren't working and the developer was refusing to fix things. They wrote an extensive report that I'm happy to include with my testimony of code violations, and some of what they found like required them to then report the building to DCRA. DCRA came out and documented 47 code violations and issued us with a notice to correct. So saying that we, as the people who had bought these units, are now on the hook to fix all of the issues. And it was third-party inspectors who signed off on sort of everything in the building.
Okay, and because this has come up, this is reoccurring. It's happened in our ward. I know, Lauren, you're not in my ward, but this is reoccurring.
My developer is building in your ward, though. I was going to send you an email offline.
Oh.
On
Okay,
the same block that has had a building collapse due to DOB failed oversight.
Okay, please do send me that. I have been working also with the Attorney General's office. I don't know if you all have reached out to the Attorney General's office already. If you have not, I'm going to say please do. Other residents in our ward who are dealing with the same issue have reached out to the Attorney General's office. So I do want to flag that. So please do reach out to OAG. If you need the information of who to email, I will give that to you. I just wanted to clarify. And so, Lauren, is your situation the same or different from Sarah's?
It's similar. However, again, we're only 2 units. We have not had DCRA or now DOB out to our property. So we have not been inspected and thus cited with these notices. In my allusion to the conversation I had at their open house, they made it very clear that that was the next step before I could involve the Attorney General's office. Our concern is obviously, we're looking at $1.4 million, and I recognize that I appear privileged relative to some of the other issues that are on hand here, but I don't have $1.4 million to put into my home. And so we're very concerned that working within DOB and potentially the Attorney General's office is actually going to result in us as the homeowners being penalized and not DOB holding the developers accountable. And, they're building in the district. What is DOB doing to both rectify my situation, for which they've made it very clear they have zero responsibility, and that the third-party inspectors, they provide no oversight or accountability for, which I think is absolutely bananas. And genuinely, we're fighting this in the courts. I'm sure, you've heard from a few people. Yeah. That's really expensive.
Expensive, right. Okay. And Sarah, I know people have brought up is the warranty and
yes.
Could you just speak to that for a second?
I'd be happy to. So our DHCD does no enforcement of the amount that the developers put up for those claims. So they claimed that to add a unit to our building and completely do a gut renovation cost them $96,000. And any architect or developer that we've talked to has just laughed at that number. So they're only required to post 10% of that. So that's $10,000 in our case. We did file that claim. DHCD essentially did not read the documents in our claim and denied it. So we have spent another year trying to trace that money down through the appeals process and are currently waiting for OAH to decide on our appeal. To Lauren's point, each part of this involves us paying lawyers, and we don't have the money to sort of keep up with all of the legal stuff that we're having to do.
And I would say with regards to the warranty bond, we've had the same issue. So we know now through the lawsuit, most likely that they, fraudulently reported their building costs. We were successful in our warranty bond claim, but we're talking about less than 100K in my instance. And it's a rounding error. Candidly, at this point, that's, covering the first year or two of legal fees.
Okay. All right. Thank you.
And I would also add, the point about is DOB even held accountable to the number of people who need to claim a warranty bond feels really important. I looked at the dashboard they published in their newsletter this week. I don't see any interagency communication.
Okay. All right. Thank you both. And I'll follow up also offline. Thank you. Thank you, Chairman.
Thank you, Councilmember. Ms. Badger, before you go, I didn't get your written statement, so I don't remember your address. If you don't want to give me the address, if you'd give me the block.
Yeah, we're on the 5100 block of 2nd Street Northwest.
That was 2nd Street Northwest?
Correct.
Thank you. Again, sorry for this. I want to thank all the witnesses again. You all are excused, and we are going to hear now from the director, Ernest Trapp. Give us just a moment, Director. Director, why don't you begin? You have your statement.
Sure. Good afternoon, Chairman Mendelson, Chairperson Louis George, council members and staff. I am Ernest Trapper, Acting Director of the Department of Buildings, DOB, previously known as the Department of Consumer Regulatory Affairs, DCRA. Before I begin my testimony, I'd like to take a moment to thank Mayor Bowser and my team at DOB for their exemplary service to the District of Columbia. Providing top service to DC residents in the built environment requires unparalleled teamwork, and I'm grateful for the dedicated work of agency and executive principals and staff. Prior to the commencement of each fiscal year, an agency performance plan is established to transparently set the foundation for how the agency will operate, how stated goals will be achieved, how performance will be evaluated at the end of each year with metrics, and new initiatives to improve the efficiency and effectiveness of services provided or delivered. DOB and its predecessor agency, DCRA, have performance plans, and DOB, as one of the city's newest agencies, will continue to be guided through this structural framework. DOB's mission is to protect the safety of residents, businesses, and visitors to the District of Columbia and advance the development of the built environment through permitting, inspections, and code enforcement. The agency is responsible for regulating construction activity through plan review, issuing building permits, conducting inspections, and improving rental housing safety through code enforcement, and drive an abatement of housing code violations by district landlords and property owners. Mayor Bowser has set an ambitious agenda for a more responsive and accountable district government, particularly with regards to housing, and I'm proud to be leading our new agency, one that strives to live up to that aspiration. I would like to take this opportunity to share the progress we've made and thank the residents, community leaders, business owners, and staff who have provided valuable input for our agency transformation. Today, I'll provide testimony on the performance and accomplishments of DCRA in fiscal year 22, leading into the transition to and creation of two new agencies, DOB and the Department of Licensing and Consumer Protection, DLCP. I will also discuss DOB's strategic initiatives and ongoing activities in fiscal year 23 to date, as well as how we are tackling new challenges. This hearing also outlines the agency's functions and responsibilities, including how we are delivering under the unique challenges of the global labor market, as well as the structural and operational changes that we have made since the establishment of DOB in fiscal year 23. At this time, I would like to speak of DCRA's 10 strategic initiatives of fiscal year 22. I am pleased to report that our predecessor agency completed 90% of them. These include the establishment of a fast-track licensing, permitting, and inspections team, which, among other functions, provides speedy housing inspections for 1 and 2 family rentals. DCRA also developed interactive programming for small businesses coping with the pandemic, including a zoning and permitting workshop held last August that walked district residents through the process of applying for a certificate of occupancy, COO, or home occupancy permit. In addition, we completed a strategic initiative to streamline construction inspections by operationalizing a scheduling system that automatically schedules inspections based on inspector availability and inspection types. In fiscal year 22, DCRA also established a regulatory mechanism for licensing and enforcement of short-term rentals. While the benefits of short-term rentals have been enjoyed and utilized worldwide since the establishment of various provider platforms, for too many years, district homeowners were opening their dwellings to short-term renters without government oversight. DCRA was able to stand up an entirely new licensing, enrollment, and tracking application so that residents and visitors may enjoy safe and legal licensed rentals in the district. While this program is now administered by DLCP, I'm proud of the work my team did to get this regulatory mechanism up and running. In addition, DCRA completed its fiscal year 22 strategic initiative to support affordable housing through code enforcement and abatement tracking. To advance Mayor Bowser's goal of establishing 36,000 new homes by 2025, including 12,000 affordable housing units, DCRA emphasized the preservation of existing housing stock through targeted enforcement against landlords with a high volume of unaddressed housing code violations. Specifically, we stepped up re-inspections utilizing a targeted enforcement strategy. As of January 2023, this effort has yielded approximately 3,803 abatements. In fiscal year 22, the agency also made 34 referrals to the Office of Attorney General for those entities that failed to show any progress in curing outstanding violations. To provide further context, since 2020, DCRA and DOB have collaborated with OAG on 53 cases in total and has been a productive working relationship. In fiscal year 22, DCRA successfully integrated a new case management system into its consumer protection unit's operations to allow for better tracking and monitoring of investigations and customer resolution. The agency also made significant progress towards its strategic initiative to advance climate change mitigation and adaptation through participation in the development of the DC Energy Conservation Code. For example, in the fourth quarter of fiscal year 22, the Construction Code Coordinating Board approved 5 commercial energy code changes to advance Mayor Bowser's Clean Energy DC plan. Completion of this initiative in fiscal year 22 was delayed, however, due to heightened interest from outside stakeholders and the resulting need for more ongoing work of the Construction Code Board technical advisory groups. Additionally, in fiscal year 22, DCRA reduced fees for certain categories of licenses and established a new 6-month business license. This initiative was aimed at helping district small businesses and improving racial equity in small business support. The agency also completed a strategic initiative to empower staff members through technology training and regular opportunities for dialogue and feedback. To provide some context on this last point, it was obvious to DCRA leadership that the agency split at the beginning of fiscal year 23 was going to cause significant anxiety for our employees as the agency transitioned into DOB and DLCP. To address this issue, we hosted quarterly town halls to allow employees to voice their concerns and receive regular updates on the transition status. As agency staff also participated in team building activities and focus groups, as well as mandatory training sessions on digital communication, data analysis, and change management. These training sessions and other activities put DOB on a strong foundation to ensure maximum performance after the split became official on October 1st, 2022. Before moving on to our fiscal year 22 key performance indicators, I want to take a few minutes to talk about our broadest, most complex fiscal year 22 strategic initiative, and that was the implementation of the Department of Buildings Establishment Act of 2020. As previously mentioned, effective October 1, 2022, DCRA ceased operations and two new agencies were stood up, DOB and DLCP. During this transition, customers were able to conduct business activities without service interruptions. DOB and DLCP continue to issue permits and licenses, continue to conduct inspections and investigations, and continue to regulate construction activities and business, professional, and vending activities. Both agencies successfully launched new websites and performance dashboards and rebranded over 20 internal applications and 400 customer-facing forms and guides. By way of analogy, this transition could be looked at as an aerial refueling process. In our specific case, DCRA was the tanker aircraft providing the fuel, and DOB was the D2 bomber receiving the fuel mid-flight so it can continue its critical and crucial mission for the district. All of the necessary resources from our predecessor agency were seamlessly transmitted, allowing DOB to provide a full range of services to customers and oversight of the district's built environment. One of the most significant accomplishments my team at DCRA made over the past several fiscal years was the establishment of unparalleled digital tools for customers to learn about services from the agency, interact with its professional staff, and request and receive services. I'm happy to report that our predecessor agency's applications, including Tertius, the Permit Wizard, Scout, and the Contractor Rating System, among others, were successfully transitioned to the new DOB website. Before the DOB website was launched on October 1st, DCRA also established a transition website to educate district residents about a pending transition, how to access our resources. This ensured that there was no ambiguity about the provision of services throughout the DOB Establishment Act implementation process. Turning now to DCRA's metrics for success in fiscal year 22. I'm pleased to report that for the third year in a row, our predecessor agency exceeded the targets for all 19 of its key performance indicators. For example, the agency met its target percentages of solar permits that are reviewed within 10 calendar days, construction inspections completed on the scheduled date, standard building plat requests completed within 3 business days, and notices of infractions related to customer inquiries that are resolved in one agency interaction. Other KPIs which were met include the percentages of property maintenance inspections completed within 15 business days, vacant building unit inspections scheduled within 30 business days, and property maintenance notices of infraction that are initiated within 2 business days following the discovery of violations during an inspection. In addition to KPIs, DCRA used workload measures to assess the quantity of service provided to DC residents. For example, in fiscal year 22, 13,450 housing inspections were conducted, dwarfing the levels from fiscal year 20 and 21 at 5,745 and 7,606 respectively. I'm also proud of the fact that DCRA completed over 11,000 proactive inspections and surveyed nearly 8,000 vacant buildings in fiscal year 22, both significant increases from fiscal year 20 and fiscal year 21 levels. The accomplishments of DCRA set the foundation for DOB and served as a springboard for the development of its fiscal year 23 initiatives. Looking forward to the remainder of the fiscal year 23, district residents and council members can anticipate the completion of at least 7 new DOB strategic initiatives aimed at improving customer service. These initiatives build on our crucial fiscal year 22 successes and help our new agency continue to accomplish its mandate to efficiently and effectively oversee the district's built environment. One of the fiscal year 23 strategic initiatives that I want to highlight is DOB's Training Academy. Our agency recently announced the Training Academy, which was launched as a pilot late last year, will now be available agency-wide. The Academy's new digital platform will grant all DOB staff access to a training curriculum designed to enhance employee knowledge and performance on subject matters such as green energy code, civil infractions, vacant buildings, abatement and permitting processes, among other topics. DOB also recently unveiled a new career pathways program, which is designed to provide architecture and engineering college seniors, graduates, and postgraduate level students with construction administration experience through interdisciplinary programming. Participants will rotate between different departments to attain a wide array of exposure to DOB's work, and successful participants may even attain full-time career prospects with DOB at the end of the 8-week program. DOB also continues to invest substantial resources in public outreach to promote awareness of the new agency structure and services. Specifically for fiscal year 23, we have established a communication and marketing strategic initiative for coordinated outreach. As part of this initiative, DOB has placed advertising on metro buses and at bus shelters across all 8 wards, released radio ads, and hosted public webinars and town halls. These efforts will ensure that all district residents know how to access the services they need from DOB and are aware of the agency processes and procedures. In addition, earlier this month, DOB launched the DOB Public Dashboard, formerly the Agency Performance Dashboard. The new dashboard includes an updated design and improved navigation, making it easier for our customers to use and provides greater functionality, which allows for more robust review and analysis. Many of the changes were in fact requested by existing customers and include additional and enhanced features concerning permit operations, inspections, violations, and abatement, vacant properties, and economic insights. For example, customers can now filter permit information by fiscal year, quarter, month, and permit type, and view the average timeline to receive construction permits. Another crucial fiscal year 23 strategic initiative will address vacant property enforcement and information sharing. In fiscal year 22, DCRA began piloting a modern record-keeping system to manage the district's vacant and blighted building stock. When DOB launches the system this summer, it will facilitate automatic notifications to the Office of Tax Revenue, OTR, and the property owners about tax billing and exemption status. This new tool will significantly improve our ability to monitor abatement efforts. Additionally, DOB will increase compliance and enforcement resources with additional FTEs, full-time equivalent inspectors, and enhanced usage of contract inspectors. Additionally, in fiscal year 23, DOB will upgrade its elevator and boiler certification process by replacing a paper-based system with a digital one. This new platform will make data searchable and allow for automatic notifications, as well as equipment recalls and similar alerts. Another fiscal year 23 strategic initiative that I'm pleased to share with the Council is our ongoing work to streamline the certificate of occupancy process. Specifically, the agency is establishing a pre-application checklist to ensure the submission of a complete package. The checklist will automate notifications to provide greater efficiency, tracking, and monitoring. I am confident that these important changes would ensure a higher quality of COO reviews. Finally, in fiscal year 23, DOB will expand quality control and quality assurance processes to improve business operations for all inspections through a pilot program. DOB will engage with an external partner on this effort, which is intended to identify and resolve potential issues throughout the business process, leading up to better customer satisfaction. Turning now to DOB's metrics for success in fiscal year 23. I'm pleased to report that As of the end of the first quarter, DOB exceeded all but one of its KPIs. For example, while we set a target number of vacant properties returned to productive use at 150, we have in fact achieved a milestone of 372 properties. Similarly, while DOB has a goal of 4,500 housing code violations abated by property owners or DOB, we oversaw 4,881 abatements. Our KPI reporting also indicates that 98.4% of customers' cases were resolved within 3 business days from the date of receipt by DOB, more than the 95% target. I am confident that DOB will exceed all 15 of its KPI in fiscal year 23, and proud of the work my team has done to ensure that we are meeting our targets and delivering the best possible service for district homeowners and residents. I would now like to turn to DOB's enforcement role as established under district law. When housing code violations are discovered during a proactive or complaint-based inspection, the agency issues NOIs against the offender for failing to correct the violation after advance notice of inspection was provided. For example, in fiscal year 22, DCRA issued 9,133 NOIs, a 53% increase from fiscal year 21 levels. DOB also remains committed to our continual work with other agencies who share an enforcement role to hold property owners accountable by using a wide range of tools to enforce housing and building code standards. To that end, our agency recently shared an infographic with the members of the public outlining where DOB fits into this larger regulatory framework that includes the Office of Administrative Hearings, the Office of Attorney General, the Real Property Tax Appeals Commission. Specifically, the infographic breaks down enforcement tools and potential outcomes into different categories such as illegal construction, rental housing, and property maintenance, and vacant and blighted property. It is important for the public to be aware of the various stages of the enforcement process and the role of other agencies and entities. DOB is confident that this new infographic tool provides transparency and will help set reasonable expectations for customers to understand the steps along the enforcement and abatement timeline. While ultimately, abatement is the landlord's responsibility, DOB and our sister agencies will use every tool at our disposal to ensure compliance with code standards. Next, I would like to discuss DOB staff recruitment. This past fiscal year, we were still coping with the COVID labor market, which has caused massive staffing shortages worldwide. When you couple that with the fact that we were setting up a new agency structure requiring dozens of additional FTEs, we faced a very difficult recruiting environment. Additionally, while we would receive numerous applications for new positions, in many cases, only around 1 in 10 applicants were actually qualified for the position. Keep in mind that a lot of the work of DOB professionals, including inspectors and plan reviewers, is highly technical. In addition, our entire hiring process, which includes job posting, approvals, advertising, evaluating resumes, interviewing, hiring decisions, offer transmittal, and offer acceptance, takes between 90 to 120 days. However, even in this challenging environment, DOB was successful in recruiting new staff, including several key positions such as the Strategic Enforcement Administrator, the Public Health Analyst, and many more. We have also steadily recruited new housing code inspectors in conformance with fiscal year 23 Local Budget Act, account managers, program support specialists, and other DOB professionals. Lastly, in the month leading up to the agency transition, DCRA hosted hiring fairs for both DOB and DLCP. Excuse me. To provide some specific figures, as of February 1, the Office of Zoning Administration had only 1 FTE vacancy, and the customer service team was fully staffed with 9 FTEs. The Surveyor's Office has filled 7 of its 8 FTEs, and the Green Buildings Office has 6 of 7 positions filled. Recruitment efforts to fill remaining vacancies are ongoing, and DOB continues to fulfill its roles and responsibilities, including through the completion of strategic initiatives despite these vacancies. Throughout my testimony today, I have outlined various statistics and benchmarks to highlight DOB's and its predecessor agencies' accomplishments on strategic initiatives. Although numbers matter, they only tell part of the story. The impact we have made in the lives of our residents and customers, as exemplified by the positive feedback we have received, provides the rest of the story. For example, an attorney who frequently represents clients in housing cases reached out to DCRA multiple times in fiscal year 22 with positive comments about our work. Specifically, he complimented the work of our team in helping his clients confirm abatement and resolve NOIs without having to proceed to a hearing. On another occasion, a property owner who had their case settled upon proof of abatement contacted the agency and expressed their appreciation for, quote, a process that was fair and timely. An additional customer reached out in fiscal year 22 to express their appreciation for our staff in helping them obtain a permit, get an inspection, and a certificate of occupancy during a very critical time. In fact, even when we haven't been able to help customers who approach us, DOB has still received compliments on our professionalism and responsiveness. For example, in January 2022, a lawyer seeking assistance with a commercial tenant dispute. When he was advised that our agency could not assist him, he still provided a 5 out of 5-star rating and expressed gratitude for receiving a timely and informative call from our legal department. I mention these examples because it is important to put a human face on our interactions with district residents. I strongly believe this reflects the professionalism, dedication, and diligence of our agency staff who have worked so hard on behalf of district residents, both as part of DCRA and now DOB. Chairman Mendelson, Chairperson Louise George, members of the council, thank you for the opportunity to testify. With that, I will now play a video from our customers, and then I will provide insight into how we are meeting the needs of today and the demands of our changing world. And then I'll address any questions you may have. Can I have the sharing control enabled?
I don't think I was expecting you to play a video. I think staff is trying to figure out if you can do it.
Yeah, I think they got it. Thank you.
If there's a soundtrack, we're not hearing it.
Innovation, technology, and investment in our people. Since this agency was established on October 1st, we have been investing in a robust outreach and awareness effort with our many stakeholders. This has included holding several virtual public forums to introduce the new agency, hosting a stakeholder forum to collaborate and inform development of our strategic enforcement plan, trainings with advisory neighborhood commissioners, holding 20 targeted community meetings and an in-person open house, providing informational and educational support to ensure residents and businesses are aware of our services and how they can access them. We want our customers to know what we do, and we are grateful for the opportunity to better understand what our customers need and expect us to do. In short, at DOB, we are doubling down on our commitment to serve. Even in the earliest days of our agency's launch, we were providing great customer service. Here is what a few of our customers had to say in our first 2 weeks. James Kane from Ward 5 was pleased with the agency's online presence and functionality right from its launch. Tim Schatz from Ward 1 brought us this concern regarding scheduling multiple inspectors. Sam Foreman from Ward 2 brought us this appreciation of the chat function. Sibo Wang from Ward 7 called to schedule an inspection. She was so pleased, she left 3 messages. Riza Shargel from Ward 7 appreciated the quick resolution of her concern. Ann Bowers Evangelista from Ward 4 was eager to schedule an inspection of a vacant property. Teresa Graham from Ward 2 needed assistance navigating the website and portal. Because our staff understands that every person in the agency has a role in customer service, we are investing in our people. From permitting and zoning to inspections and enforcement, our staff manage nearly 6,000 inquiries each week. We're expanding our knowledge, improving our responsiveness, and increasing our preparedness to ensure that customers have their questions answered, their concerns addressed, and their problems solved. We're improving our permitting process, and we are working to further streamline it. We're heavily focused on providing timely, precise, and accurate information to our customers through innovation and by deploying new technologies. We are building the workforce of the future here in the district through our new Career Pathways program.
DOB has unveiled a paid Career Pathways pilot program to provide architecture, engineering, and construction management seniors, recent graduates, and postgraduates with valuable practical building code and construction administration experience in a supervised environment, and a potential to full-time career prospects with the DOB at the conclusion of the program.
Through our innovation, better use of technology and service delivery, and greater investment in our people, our already strong commitment to the residents and businesses of the district is growing, positioning us to meet the demands of today and those of the future.
Does that conclude the video?
Thank you, Mr. Chairman. It does.
I can not hear you very well. Can you check your audio?
All right. Hello?
Very soft.
All right, let's try it. Hello, is this better?
Minimally. It's just soft.
All right, let's try this again.
Is it better?
Yes. All right, if we could be on 10-minute rounds. I believe Councilmember Louis George is here. Are there any other council members present? I can't say, Director, that I'm feeling very good at the moment. There's been 46 witnesses and an awful lot of testimony of complaints about body construction, which I consider to be illegal construction if it doesn't comply with code. That I think there's been too many complaints about that. This hearing feels to me almost like we've gone back in time to hearings a couple of years ago when there were so many complaints with regard to the responsiveness or the effectiveness of the inspection process. I don't really appreciate it when there's a tenant from Woodbury Village who's mad at me when I went out and looked at the property and contacted then DCRA and said you need to follow up, and apparently the problems are still manifest. And it doesn't surprise me that Woodbury Village is still a problem. It was pretty clear from a few years ago when you may remember, Director, that I went out and there was no heat. I was like the beginning of February, and I was pretty angry that the department said, well, we'll send out an inspector. They've sent out an inspector, found that there was no heat, and then the follow-up inspection was going to be like a month later. And I said, I hope you remember this. That's waiting too long. There's no heat. This is February. It's cold. Well, not today, but 3-4 years ago. And the follow-up inspection should be right away. We knew then that the owner of Woodbury Village was not a good actor. And so that today I listened to the tenant who's angry, just angry that the problems continue. Department buildings should be all over the place for that apartment complex. There was testimony regarding Marbury Plaza. I know that that's in litigation, so I don't know what Department of Buildings could do, although I suspect Department of Buildings could keep going out there and inspecting and keep citing. And with its NOIs fining. There was building after building, and then those homeowners who bought and I mean, that's just wrong that somebody's buying their new unit. And it turns out that I can't remember if it was a couple $100,000 in repairs needed or the $1.4 million in repairs. And that's just wrong. In fact, maybe that's where I'll start. Sarah Baget, 5100 block of 2nd Street. Department of Buildings cited 47 code violations against the current condo owners, the purchasers. And according to Ms. Baget, there was a third-party inspector who had okayed the construction. The warranty bond was grossly inadequate. I think she said $10,000 because the construction was grossly underestimated at like $100,000 for a gut job and a complete renovation. So let me ask this, Director. I guess 3 questions. 1, what is the Department of Buildings going to do to help the property owners? 2, please explain what's going to happen with the third-party inspector, assuming that the allegation is correct, that the third-party inspector okayed the building, which DCR or Department of Buildings subsequently said had 47 code violations, significant violations. And third, what is the Department of Building? How is it that the warranty could be the warranty bond could be so grossly understated? And what's the Department of Buildings going to do about that? 3 questions.
I'll first of all start by sharing your frustration and anger. I also get angered when I hear about residents living in terrible housing conditions. I also get annoyed and angry when I hear about construction defects. So the feelings you have, I have the same feelings. At the same time, I also look at the totality of the system to see what improvements can be done so that we don't sort of throw the baby out with the bathwater, so to speak, because there are so many more residents who are living in better rental housing conditions and also in safer homes that have been built according to code. So I try to balance my frustration with the positive. That is not to say the issues should be swept under the rug. Far from that. In fact, we will pursue every avenue possible to bring accountability. You asked 3 questions, one around what is the department doing to help our tenants. We follow the law and the codes and the authority that we are given. When there is a housing or property maintenance issue, as you know, our first response is to do an inspection after we've given the property owner notice of the inspection. And if violations are found, we utilize one of the enforcement tools available to us, that is to issue fines and litigate those fines at OH for the benefit of tenants. And we'll continue doing so. For Woodbury and Marbury Plaza, a look on our public dashboard shows the hundreds and thousands of fines that have been levied. We also work closely with the Office of the Attorney General to pursue other enforcement strategies. I mentioned in my testimony that we've worked with them on about 54 cases, and that is the process that we are working within. So if there are any new issues at Woodbury or Marbury Plaza, I'll have my staff look into it so we can respond appropriately, be it fines, re-inspections, reviewing proof of abatement, making referrals to other entities who are part of the enforcement process. I think it's also important for people who are listening to understand that DOB by itself is not positioned or empowered to solve all these issues just within the agency. That is just not the reality. You also asked about the third-party inspector. Have my team look into the case to see what other measures we can take, because we've been on record for asking for inspecting agencies to be their license to be revoked or their privilege to work in the district to be taken away. We've indicated those issues in court, and we'll continue to do so when there's sufficient basis for that. And then you asked about the warranty bond. Unfortunately, the warranty bond is not managed by DOB, nor do we aspire to manage that process. We'll continue working with DHCD. In fact, I know my team has already initiated conversations with DHCD on areas where we can collaborate, whether it's just on the warranty bond process, or it's on ADUs, accessory dwelling units, or even on inclusionary zoning, or housing, or buildings that are being converted into apartments. So there is an opportunity to strengthen the partnership. So while I don't have a magic solution that I can offer right this moment, the agreement for me and my agency and my staff is that we will follow the law that is established and processes to bring justice, accountability, and to help people where we can.
Well, I guess I want you to follow up with a written report after this hearing on the situation that Ms. Baget spoke of. And it is extremely unfair to the purchasers, the condominium purchasers, that they buy a building. And this is not the only instance. And I'm looking at Councilmember Lewis George. It seems to have happened a few other times in Ward 4. It's not just Ward 4, by the way. So if you could address my three questions more thoroughly in a report following up this hearing. And you'll be able to give better information with regard to the third-party inspector, assuming that that allegation is correct, that it was third party. And even if it wasn't, there's an inspection that's done by your agency before a certificate of occupancy can be issued on a multi-unit building. So your folks had to have okayed the construction. And then after the purchasers complain, your inspectors go out and cite 47 code violations that were significant. And I'd also like more detail on how the warranty bond situation will get fixed. It's not good enough to me that it's the DHCD, not Department of Buildings. Department of Buildings can go sit on the director of DHCD and say, you're going to fix this. I'd also like a report on Cynthia Price's situation. She's 228 12th Street Southeast. That was the one where it's not clear to me whether there was a permit for the work or the work was done without a permit. The structural damage to the brick wall, which I believe is a party wall for her house. And I'd like to know how Department of Buildings is going to make Ms. Price whole. And I'd like to know how the violator, the neighbor at 230 12th Street, is going to pay for the damage that they caused. So that's two reports I'm requesting, one for 228 12th Street and one for Southeast, and one for Ms. Baget's property at the 5100 block of 2nd Street. And I'll have more questions. Councilmember Lewis George.
Thank you, Chairman. And thank you, Director Chopra. I want to, I'll first follow up on the chairman's point, but I want to say I think it's clear from today's public testimony there, I guess, two different perspectives. From the perspective of some of the residents, department is ignoring the needs of residents who have reported illegal construction, or residents who have been, sort of swindled by fraudulent developers and shoddy third-party inspections, and tenants who somehow live in uninhabitable conditions that neither landlords nor the department will necessarily fix. And then in a different world, the department is sort of letting the market do its thing, according to witnesses who I think primarily represent or engage in business as real estate companies, and the department is streamlining the process to get permits. And I think I'm interested in exploring these two different perspectives, because I think they say a lot about the agency and the metrics it uses to evaluate its performance. And the perspectives are not necessarily in conflict with one another. In regards to, what we hear from for residents who are suffering, and this is the word from their experience, what we talked about earlier already was suffering from living in new condo buildings that were built under third-party inspecting programs. And I know the chairman has asked for a report, but I just wanted to, and I appreciate you saying you also get angry about terrible housing conditions and substandard construction. I wonder if do you all ever sort of refer any of these cases for criminal prosecution for fraud?
Thank you, Councilmember Dennis Louis George. To answer your question, as far as we make criminal prosecution, we make referrals to the Office of the Attorney General, because we can go sue people. I don't have the number of referrals that we've done.
Okay.
Work with them on a routine basis. It is par for the course. If we find some evidence of fraudulent activity, or we find some evidence of nefarious activity beyond what our authority is, we make those referrals. And we've also been successful in getting companies to leave the district, suspending certain professionals, and that is all part of the enforcement process. It is nothing new, in the sense that we have a framework of what we need to follow, whether it's somebody who's cheating a little bit or a lot on their taxes, and we make a referral to our OAG, or whether it's the chairman bringing an issue to our attention, or you making a referral. Our process is still the same. Evaluate the facts at hand, and then follow the prescribed process for holding people accountable.
Okay. And it sounds like some of these third-party inspectors are really bad actors. And so I'm curious sort of what quality control and quality assurance activities does DOB have when third-party inspectors allow substandard structures to pass instruction?
All right, I'll answer the question about what controls we have in place. But I also want to touch on an issue that may appear to be a faulty premise for the benefit of the public. Shoddy construction, or like construction defects, that is in a different realm when it comes to the means and method of doing a certain type of work. Our role is to see if the work is code compliant. Our role also is to perform oversight on third-party inspection work. We do hundreds of oversight inspections on third-party inspection companies and their inspectors. And we also have disciplinary measures in place to protect homeowners, property owners, and hold inspectors accountable. In certain situations, inspectors just cannot do the work anymore. So the example that you provided earlier, or that the lady talked about, is something that we are still looking into to see what facts can be established and what will be the appropriate enforcement step to take. But I don't want any property owner listening to think it's the department's responsibility, or the department is solely responsible for construction. It takes a team, an architect who is required to design by code, an engineer who is required to design by code, a licensed contractor who is required to follow safeguards, plan review team to ensure that plans are code compliant, inspections team that do direct inspections and sometimes do oversight inspections. So that's sort of like the broad system in place.
Right. Yeah, no, I understand it's not just you all. I just want to know sort of what you all have to within your responsibility with these third-party inspectors. Because it sounds like, you know, if they're continuing to do it, at what point are they sort of not allowed to be sort of provide inspections or for and be submitted to DOB?
Yeah, when we have a sufficient case, they get suspended or they get removed from the program completely. And one of the things we are able to do now, which we were not able to do several years ago, is really prevent work from getting to them. As you may recall, we now have a single platform for all construction inspections, whether it's by DOB full-time employees or third-party agencies, and they are inspected. So we have the ability to monitor in near real time construction inspection activity. And if somebody's removed from the program, guess what? Their profile will no longer be an option online for somebody to schedule an inspection with them. So that's just one of the safeguards in place in response to the need to ensure that the built environment is strong, is safe, and addresses contemporary challenges that we come across.
Okay. And do you know if we've suspended any inspectors over this last fiscal year?
Oh, from memory, I know we suspended a couple of them. The exact names and the cases, I have to do further research, but you know, I know that happens. It is not out of the ordinary for us to substantiate a case, litigate it, and then suspend the inspector or the third-party company. It happens. We do it.
Okay. And that leads me to, I know in page 49 of your testimony, you talk about DOB piloting an artificial intelligence powered building permit approval using building information modeling files for construction, permitting construction projects that require plan reviews. It will sort of, what is this technology? And you know, I just don't want it to end up it creating more issues and problems than it's solving.
Good question. Artificial intelligence really has reached a tipping point, in my view, where it is accessible to consumers, businesses, and the government. It is no longer the province of wealthy or rich companies. What we are doing is exploring how this innovation can improve building safety, improve productivity, and also prepare our workforce for the future. I look back to 50 years ago, if you would ask somebody if they run spell check on their emails or Word documents, they'll probably say no. But now it is common practice. It is foreseeable that artificial intelligence will permeate our lives to greater extent than what we are even aware of. So as the Department of Buildings, we are not sitting on the sidelines. We are assessing, exploring, working with other jurisdictions, working with companies to really understand the potential. And over the last few months, we've been able to scope out a certain level of work that can be done by humans and also can be accomplished by artificial intelligence. And we are preparing for a stage where we will see what is superior, what is consistent. And we've also targeted permit approvals because we know there are certain rules that are basically routine. Building height is building height from the building code perspective. From the zoning regulation, depending on the zone, there's a building height that you have to comply with. So rather than have a human being sit behind their desk, spend hours doing routine tasks, we can automate these tasks with artificial intelligence so that our staff can focus on higher value activities, whether it's quality assurance or doing complex reviews. The lessons we learn throughout this process will inform how we scale it. So I don't want to create an impression that we are ready to go prime time. No, we are still in the piloting process so that we can understand these tools, understand some of the bias that it may create, mitigate that, and prepare our workforce for the future, and ultimately make the built environment safer and improve the efficiency and productivity of our work here in the department.
Okay, so right now, artificial intelligence won't be used sort of to replace any current sort of work being done by actual human beings.
Once we complete the pilot and we settle down on the tasks that are better performed by artificial intelligence, we'll consider how to scale it. But under no circumstance do we see artificial intelligence replacing human labor for all tasks. No, that's not our vision. Our vision is for it to augment our work, particularly in an environment where there's just rather staffing shortages. Even if you have all the resources that you want, there are certain labor categories and skill types that you just cannot hire because there are simply not enough people. So coming back to your question, how to use the tool, it will evolve based off what we learn and also what our community expresses to us.
Okay, this is my time for this round, so I will.
And there'll be another round. Director, how many vacancies does the department have right now?
We have about 100, and give me a second, I'll give you the number. I think it's 108. Give me a second.
And while you're looking, I assume there's some folks from your office who are listening. Maybe they can set up a laptop and a separate connection so that the next round your audio is better. We think the audio is bad at your end. It's sort of muffled and soft. And when you turned it up earlier and asked if it was better, it had a sort of a hollow tone to it. It's sort of gotten soft again.
All right, let me try.
Muffled. And I'm not suggesting you fix it this round. That's my time. Your staff can maybe set up take a second laptop and set it up, and we'll let you enter that way, and then you can just switch to laptop with the next hearing. So how many vacancies do you have?
All right, give me a second.
Oh, you're using up my time here.
$108.
And do you know how many of those are inspectors?
Well, as far as inspectors, I can give you the breakdown for inspectors. For housing inspections, as an example, of the 41 positions, additional positions that council gave us, 6 were for vacant building inspections, 29 housing inspectors, 3 building code, and 3 combination code. For housing inspectors, we filled 7.
Okay, this is too confusing to me. Can you just tell me how many vacancies there are in the inspector positions?
I'll have to tabulate that to answer that question. Of the 108 vacancies, the exact number that are inspector positions, I'll have to tabulate and get that to you.
Can your staff, I mean, this is your performance oversight hearing. These numbers should be available. This is not an unusual number to request.
I agree, it's not. It's just how the information is packaged based on the Schedule A.
There's nobody there who can, like, while I'm asking the next question, can figure out how many inspector positions are vacant?
All right, I'll telegraph that so that somebody can look at it so that you don't have to spend a lot of time on the chatting.
The union rep for AFSCME testified about separations In 2019, the agency had 6 separations. In 2020, the agency had 31 separations. In 2021, the agency had 68 separations. And last year, the agency had 70 separations. Why is that number going up? I mean, that's going up from 6 to 70. Each year, it's more.
I question the numbers, so I don't want to respond to a faulty premise.
So you'll get back to me with that.
Yes.
When will the confirmation resolutions for the director, chief building official, strategic enforcement administrator, and zoning administrator be submitted to the council?
It is going through executive approvals. So that's something that we can follow up with you on.
I'm sorry, you said going through executive approvals.
Yeah, executive
What did you
office of the
say?
mayor. It is going through approvals within the executive office of the mayor.
So my question, when will the confirmation resolutions come to us? The answer is,
I'll have to check. The confirmations don't come directly from the agency. We work with our EOM. So that is something I can follow up so that EOM responds to you, or I can provide additional information.
is it correct that there was an inspector position that was reprogrammed to be an HR position?
Yes, that's absolutely correct. Given the number of inspectors and other non-inspector positions that we had to hire, it was just simply impossible to expect 2 people in HR to recruit, manage the retention for over 100 positions. So we reclassified one of the inspector positions to an HR position so that the staffer can develop expertise in recruiting inspectors, which is a very difficult undertaking. And sometimes you also have to understand the certification process and educate prospective applicants about our certification requirements. As you know, Chairman, we don't hire inspectors that are not certified or not qualified to do the job. So that is a constraint that we are working to overcome.
Well, I wish we had realized when we were putting the positions in the budget that there would be another HR position needed, because the idea was to hire inspectors, not to hire an HR person. What is the ratio of supervisors to inspectors?
We've tried to achieve a balance of 8 or maximum 10 line staff or inspectors to a manager. So that was one of the driving reasons.
Say that again, 8 or 10?
8 to 10 line level staff or inspectors to 1 manager. So a 1 manager to 10 people ratio.
Okay. Do you have the answer yet on the vacancies and inspectors?
1 second.
Yes.
It's being looked at, Chairman.
I'm sorry, say that again?
It is being looked at. From the 109 vacancies, how many are purely inspectors?
Okay, the audio is better.
Okay.
How many of your inspectors are cross-trained?
Help me understand what you mean by cross-training, like,
Well, you
cross-
have a vacant and blighted building inspector, you have a housing code inspector, you've got an illegal construction inspector. How many are cross-trained across those different lines?
All right, good question. Cross-training is not actually the standard we look for, certification. So somebody who is certified in property maintenance or housing can end up doing vacant building inspections after they get certified. But you cannot be a vacant building inspector and do property maintenance or housing inspections because of like the skill gap or the certification required. Similarly, for construction inspections, you cannot end up doing vacant building inspections. So the answer to your question about whether people are cross-trained, we provide general information about disciplines, but you actually have to obtain certification to
Okay, but that
perform.
doesn't answer my question. My clock is, I've managed to ask like 3 questions in 10 minutes. Okay, so an inspector can't inspect across disciplines unless they have a certification. My question was cross-trained, cross-certified, whatever. How many can do more than one discipline?
All right. The 38, for example, the 38 housing inspectors can be prepared to do vacant building inspections. That is about one area. Another area will be construction inspectors can do illegal construction. So if you want to use that as sort of like a way for cross-training.
No, that doesn't work for me. You know, we had a hearing a couple of years ago on mold. Now, I didn't mention mold, but an inspector can do a building code inspection. Can an inspector also do mold? How about or a housing inspector can do housing code. Can they also do mold? How about if you get back to me on this? So get back to me with an answer.
Can you clarify?
How many inspectors are cross-trained? However you want to answer, you understand what I mean by that?
No, I don't, Chairman.
Can inspect on more than one discipline.
We will report back on the number of inspectors that can do more than one discipline.
How many of your inspectors are able to inspect mold?
Our inspectors don't make mold determination. That's the Department of Energy and Environment.
All right, so the answer to that question is 0. Councilmember Lewis George.
Thank you, Chairman. Director, I want to go to some vacant and or blighted properties. And I also want to try to get to some of the loopholes that must exist that they continue to persist. 3700 14th Street Northwest. My most recent email and letter sent to you all was on December 6th of 2022. In addition to the Deputy Mayor Lucinda Babers, and it was directed to you as well. 3700 14th Street Northwest is a blighted property and has been such. We also included Deputy Mayor of Public Safety because this is a property that also has high drug use, and many times we've had to engage DPW who've had to come out on several occasions to remove graffiti from the wall, whether it be gang tag graffiti. Most recently was anti-Semitic graffiti. Just a couple of weeks ago, there are needles that are found on the ground in that particular area. I sent a letter on my letterhead email on December 6th to your office, as well as the Deputy Mayors of Public Safety and of Demois. And the issue here is that, and this is a location where we've had numerous of instances of gun violence. I have previously asked for your office to the enforcement team to place, and at least in the meantime, which you've done in other areas in our ward. I know for a fact on Kennedy Street there is a gate that is put up around 3 properties that were known for that as well. And I just want to get a status of when 3700 14th Street Northwest will be addressed by the enforcement team.
Thank you for the question, Councilman Louis George. As you noted in the letter, you asked us to consider putting up a fence on that property. So far, what we've done is make communication to the owner, the private owner, to address those issues. The cost involved in fencing that single property is not something that we can bear right now, given our abatement resources. That has to be spread across thousands of properties. So we'll continue exploring ways.
I don't understand that, because this is the issue, because everybody else is paying the price as a result of it, right? Because DPW has to continue to come out. Their team has to come out for cleaning of drug paraphernalia, of graffiti removal. I mean, this is happening every single week. And, you know, it's not like I'm making this request alone. MPD, 4th District is also, and ANC commissioners all with me on this. I don't understand how much it costs to just erect a fence there, especially when you've done it on 6th and Kennedy, where we had 3 properties that were the same, and it didn't take, you know, it wasn't sort of a financial hurdle in that regard.
I don't recall the exact date where 6th and Kennedy was fenced, whether that was done by DOB or that was done by the property owner. So I don't want to speak to that. At the end of the day,
It was the enforcement team. It was the former DCRA, now DOB, as it functions.
I get that, but I cannot sit here and commit to fencing one particular property when there are thousands of properties requiring our attention, and we have to, allocate our resources effectively. I just cannot make that determination while we're having this conversation. I know we've done abatements at that particular location. We've also taken steps to inform the property owner. There are outstanding tax debt on that property. So,
it is. Yeah. So, I mean, the property owner has not done anything. Our Uptown Main Street has also engaged about this because it's hurting the Main Street in addition to. So I guess, how is this property owner allowed to sort of continue? This is me asking sort of what the loophole is there. It's been in this blighted condition for at least 3 years now. And so how are they allowed to continue to sort of, when do we get to a space where we can have this property?
That's the District of Columbia laws. It has private property rights. It has enforcement processes that we have to follow. I don't make those laws.
Oh, I know. I'm asking you what the loophole is so that I can address it in the laws.
Oh, I don't know if I'll call it a loophole. I don't know if there's a loophole. What I know is that even properties go through a tax sale and then it falls apart for various reasons. But a tax sale option is still a viable option. A property can be put through tax sale multiple times. The existing property owner has, I believe, a couple of months to reclaim a property that has gone to the tax sale. So perhaps one idea is to consider eliminating that option. But now that should be weighed in terms of the cost and benefit, because it would have unintended consequences. If there's somebody who has inherited property from multiple generations and they're falling on hard times and they can't keep their property up, they just need some extension of time. If you force a tax sale and they don't have the option to reclaim the property, you've created a financial gap or a wealth gap in that family. So while I would suggest evaluating the tax sale process, I would also suggest maybe we have a broader conversation with property owners who are in distress, community members, to figure out what else can be done. And maybe we can workshop this together and partner on a solution. I know we've also had conversations about having properties participate in the vacant to blighted, the vacant to visual initiative. Mm-hmm. And there are situations where the property owner just doesn't want to cooperate. They just don't want to be part of it, even though this helps them and helps the community. So there's a long way to go. But I think what I can comfortably say is that we need to workshop this a little bit more to look at really troublesome properties the underlying issue why the owner is not responsive, the limits of government intervention, and how to help our communities cope through properties that are in transition.
Okay. And then the other, and maybe it's the same thing. So we've talked about this before, 1400 Hamilton Street Northwest, your office is engaged with us there. It has been sitting there for over 10 years at this point. It is also at a point where the roof is completely open. The roof has been completely open for 2 years. Neighbors are fearful of collapse happening. The green tag process has really done nothing to solve the problem that the property presents. It's been more than 10 years, but I know for record, it's 10 years that it's allowed to sit there. Is this just another issue where you're saying for all these years, it's just been gone through this tax sale, resale process over and over again?
I don't remember the latest activity at the Hamilton property. So pardon me for that. But if it sounds like what you are describing, I think the thread here or the highlight here is the limits of the existing laws we have. Correct. To get things done.
That's right.
So, whether we've gone through tax sales, we've increased the property taxes through blighted classification, we've issued correction orders, we've placed liens for any abatement that we've done. Those are all enforcement tools.
That's all enforcement. Okay.
But when it hits the ceiling, we have to figure out what else we can do, because I get it. Residents can be frustrated, and nobody wants to live next to an ugly or blighted building or abandoned building. Like nobody, it's just not a good thing. Right. But we are a nation of laws that reflects our values, and we have to take another look at the laws on the book. So again, you have my commitment that we would partner with you to workshop this and figure out what can be done for our community.
Great. I appreciate that, because that is where I want to go and look towards in the future, because it just seems like something is happening there when we have several of those properties. And I don't know how much it's even costing you all to continue. We have a property on 3rd Street. I mean, you all have to come out every time and sort of make it a safe for the surrounding neighbors. And I don't know, do you all recoup any funds from these individuals who've been holding on to properties that you all sort of have to come out and then abate and upkeep?
Unfortunately, most of the investments that we do in securing properties, or even the liens that we place, are not something that we recoup in 1, 2, 3, 4 years. No, it is tied to the property being sold. So I like to share with residents that, look at this context. We don't have an infinite supply of resources to abate. And the limited abatement dollars we have when we invest in nuisance properties, we don't recoup them the next day or the next year. So it is basically operating in a deficit for a long time. But it helps the community. It keeps the community safer. But we just have to figure out how to do more with less, and also how to shift the burden a little bit. I was at a community meeting, and one lady came up to me and she said she sees blight in her neighborhood. She also wants to be a developer. How can we help her understand the real estate development process so that she can concentrate on her neighborhood? So that to me shows that there are non-traditional tools that others are interested in deploying to return properties to productive use. And we really have to have those conversations about how we can be helpful, whether it's through education or dissemination of information about properties and beautifying their properties, maybe even temporarily, to attract developers who will build according to what the community wants, and not just flip and move on to other properties.
Okay.
Councilmember.
Thank you.
And there'll be another round. The property you mentioned was 1400 Hamilton?
Yeah, 1400 Hamilton Street Northwest.
And how long has it been vacant?
Over 10 years. It's blighted. It's marked as blighted in the system. With
Director, 1400, Director?
Yes,
1400 Hamilton Street was classified as residential and taxed as residential. That means occupied until 2020. Councilmember says that it's been vacant for 10 years.
Sure.
Can you explain that?
I don't have the details in front of me to explain it. Properties can go in and out of vacancy status for a number of factors. So
Well,
this
if the roof is
something,
caving in, my guess is that it hasn't been going in and out of. I get that you have a harder time retroactively classifying blighted property, but vacant. So I noticed there was testimony earlier about 2920 Ontario Road, and the department finally went in and reclassified it as vacant, going back at least 4 or 5 years. Why don't you do that for Hamilton Street?
that presupposes that it was reported to us as vacant 10 years ago. If a property is vacant and we don't know about it, we can't.
Well, your folks could reach out to the council member. She might have some evidence there. You know how this works. Okay, so I have the same
Sure.
question regarding 1724 New Jersey Avenue. I sent you a letter about that yesterday.
Sorry, I've not seen the letter. I was not around yesterday, but I know we have talked about that property at a retreat. So I'll look at the letter and I'll respond promptly.
Okay, well, here's the deal. And when I talked with you about it several weeks ago, I actually had the wrong address. It was the same block next, the lot next door. The building was built in 2016, finished in 2017. I believe the developer was unable to actually complete the building. So I said, yes, finished, but not completely finished. And so, and the developer, I believe, defaulted on their mortgage, and the bank filed for bankruptcy, or the developer filed for bankruptcy. All of which is to say that there's plenty of evidence that the building has been vacant since 2016, 2017. But the department classified it, I believe, in 2020 as vacant, and otherwise every year it's been occupied. I mean, it's just ridiculous. And if you go out there and look at the building, it's vacant. And so the letter I sent you yesterday was, how does this happen? How does it happen that the building is under construction and the construction stops? Your department knows that. And nothing's done for 2 years, 3 years to classify it as vacant. And then how does it happen that your department classifies it as vacant, and then it becomes unvacant the following year? How does that happen? And there was a related question which now has skipped my mind. Those were in my letter to you. So I get it that you won't be able to answer specifically with regard to that building today, but I suspect that what your folks did was they sent to OTR language that OTR read as for 2020, only 2020 classified as vacant. And then your folks didn't pay any more attention to it. It's listed, by the way, in Scout as vacant today, but that's not how it's taxed. These are the same problems that I complained about 2 years ago. And so I'm not seeing improvement here.
I'm not so sure I would agree with that, Chairman, respectfully. Improvements to vacant building management or even housing is clear on the books. If you look at even the number of properties that have been returned to productive use, knowing very well.
What does that mean, productive use?
Yes, that means something that was vacant is no longer vacant. Somebody is living there, or the space is being used for a business. And we can determine that because we do something called occupancy determinations. We set a goal for about 150. Currently, we have a little over 350. So there's evidence that we are driving the return of vacant properties to productive use. Knowing very well that DOB is not a developer.
With all due respect, Director, I think that's not a very helpful KPI.
You asked for that, Chairman.
Well, that is actually one of the questions I have, but I don't think that's a productive KPI. I think the productive KPI is how many vacant buildings are out there that are actually being taxed as vacant. To me, that's a meaningful number. That might be a hard one to come up with, but that's what we care about. Is
All right.
if the building is vacant, is it being taxed as vacant? And another KPI would be how long is it on the vacant list?
All right.
But
For those two
that
things-
one, you know, you may not have control over that one either, but I think that's a valuable metric because, you know, the public doesn't, what the public gets really upset about is the building down the street at 1400 Hamilton that's been vacant for 10 years. That's what they get upset about. And and they get upset that it's 1000 C Street Northeast. That it's gone for, by the neighbors, 30 years as being vacant. It wasn't even taxed as vacant for 30 years. I'll just say at this, for the record, that at this point, I believe the Attorney General has sued the property owner for fraud. I think those are the more meaningful KPIs than productive use. But your answer is that productive use means that it is actually being occupied.
And you're right, it is not fully within our control, but I do believe there are ways we can help, which we are working towards. So for example, this summer, we will be releasing a system that we've been working on for vacant building management that will do automatic reconciliation between what we've classified as vacant and what OTR is taxing at the vacant rate or the blighted rate. This has not happened in the history of the District of Columbia for over 40 years. We are this close to bringing that functionality to bear. So I, through this job, have understood things that are within our control and things that are not within our control. But I also think by working with you to solve these intractable problems, we can move the needle forward by providing transparency and leveraging some innovation to make problems that are seen as like intractable more manageable. An example is vacant buildings. We've had great success providing information to the public, and we think the next logical step is to have automatic system reconciliation that would eliminate human errors and also ensure that the community has access to information that is meaningful and helps understand the built environment that we are operating under.
So vacant property being put back into productive use was not what we proposed. What we proposed in our committee report last year was percent of vacant and blighted buildings that have been registered as vacant and blighted for more than 3 years, percent of appealed vacant and blighted building classifications that were upheld by the Real Property Tax Appeals Commission, percent of vacant and blighted property inspections where a violation was found, percent of re-inspections where violations found during the initial inspection were abated by the property owner, and percent of appealed NOIs upheld by the Office of Administrative Hearings. So I did have a question. In our committee report last year, which is what I was just reading from, the committee listed 13 potential KPIs covering housing code, illegal construction, and vacant buildings. Which KPIs, if any, is the department considering adopting?
In our proposed response, we listed the KPIs that we have adopted and the ones that are no longer relevant. I'll have to go to the specific section to.
Well, if you
speak
want,
about.
maybe you can get back to me on this one.
Okay.
So the question is, the committee of the whole's budget report last year listed 13 potential KPIs. Which, if any, is the department considering adopting? And if you're not considering adopting them, why? Regarding the new housing code violation KPI that you've adopted, will this measure the number of violations abated in the same year that an NOI was issued?
Yes, Chairman. In our responses, we listed violations that are abated in the same fiscal year and violations that are abated in the subsequent fiscal year. So for example, with housing code violations, in fiscal year 21, the number was 13,293 in terms of number of violations. The number of violations that were abated in that same year was 1,889, and the number of violations that were abated the subsequent fiscal year was 1,751. This is on page 53, question 28 for a number of abatements. So the short answer is yes, we are monitoring and tracking the number of violations cited and the number of abatements in the same fiscal year. What I'd like to point out with these abatement numbers is that we generally see a higher abatement rate on proactive inspections than complaint-based inspections. So that's an insight from the data analysis.
I'm going to have to do another round. Councilmember Lewis George.
Thank you. Director, I want to talk about the Adjacent and Adjoining Property Protection Act and what you all are doing to implement this and enhance protections. I know you all were supposed to be creating regulations to implement this. Where are you all on creating these regulations? As you heard, a number of witnesses have testified about this, and this is something that's come up a number of times with adjoining properties. And so I just want to get a sense of where you all are on making this happen.
We're making great progress, but first I want to thank the council for voting unanimously to adopt the bill that the mayor proposed. It came about because we did studies to see, okay, people have been complaining about construction damage for decades. And we got to figure out a creative solution to this problem rather than people coming to DOB and say, oh, my home has been damaged, it's DOB's fault. We know it's complicated than that.
Right.
So with the passage of the law, my team has been doing research so that we can publish the regulations and also get to a point where we would actually implement it. So we have two parallel tracks, and I'm optimistic that by the summer, it should be in full effect, not just from a regulatory standpoint. Of course, I don't control the rulemaking process, but from a timeline standpoint, we are targeting that by this summer, the regulations will be in place and the operational infrastructure is also in place. So for example, if somebody goes to apply for a permit and they don't provide proof of the special insurance, guess what? The permit is just not going to get approved for work that requires a special insurance. We are also going to expand the insurance education center that we built just for this. We are also going to expand outreach to neighbors and our community so that they understand that this is not going to solve all their issues, but this is just one additional tool that the city is making available to protect our homeowners from construction damage.
Okay. And sort of what can you explain in what way this is going to help protect homeowners from adjoining property damage?
And I have to be careful because I'm not an insurance adjuster and I don't want to get too technical. But let's say you live in the typical row house situation. You have your homeowner's insurance, the contractor and the developer have their commercial liability insurance. This new insurance will be on top of what the contractor and owner/developer is required to have. So if you start seeing cracks in your wall, that is clearly.
We saw a lady today who had cracks literally in the wall.
Yeah, but I don't know her situation, but it looks like this would help. And the result of the damage is from the construction next door. You can just call up the insurance company and say, hey, this construction work started. I didn't have this issue. Now I have damage. I want to make a claim. And we also know that some insurance companies like to be evaluated on their claims payouts or how quick they provide claims. So their market would adjust. And another unique aspect of this program is that it provides tail coverage after the construction work is done, because we know there are instances where you don't see those signs of cracks until the building is done, people have moved on.
Okay.
So this would provide that type of relief. But to put it simply, it's like getting into an accident and being able to call for help. This insurance product will provide just that kind of help based on the limits of the insurance that we will set in rulemaking.
Okay. So I appreciate, I think you said summer, you're looking at a summer 2023 rollout for this. If an education rollout as well. This is an issue that has impacted a lot of Ward 4 neighbors, specifically with row houses. So just looking forward to seeing that roll out as quickly as possible and hoping that will be a priority in this year. I want to also ask you about our inspections, rental inspections, and the work you all are doing within the rental housing inspections, but also I want to just see if you can clarify something for me, which is it right that you all, when in far as inspecting DCHA housing, that you all don't do DCHA?
DC Housing Authority has their own inspector workforce.
So you all don't have any sort of and so it's right that you all don't have any sort of legal authority to inspect DCHA.
We can do inspections to support their work, but the short answer is that DC Housing Authority has their own inspectors, and they follow hard requirements, and we are limited when it comes to enforcement on DC Housing Authority issues.
Okay, so what role do you all play right now, or if any?
I'll speak to sort of something that we did last year. Last year, the mayor asked us to go and do inspections behind DC Housing Authority and prepare a report. And we've been collaborating with them so that they are also utilizing the abatement portal that we created to help track violations and the ones that have been remediated. So that's the nature of the relationship. If today somebody complains about a DC Housing Authority issue, we'll tell them, okay, just like we require of landlords, you have to inform DC Housing Authority for them to address the issue. But we are not in a position where we will issue fines, because even if we issue fines, OAH cannot sort of force a lien to be placed on DC Housing Authority for failure to pay those fines.
Okay, so your role has been collecting some nature of data in regards to and following up on some of DCHA's after DCHA has already done an inspection, sort of doing after another inspection and for the purposes of data collection.
For the purpose of data collection, and also to provide residents with another outlet, really, because at the end of the day, knowing the conditions of the city's housing stock is important for us. And we want to be able to provide help directly or indirectly to any property owner or landlord who is dealing with those sort of violation issues.
Okay. Does DOB, do you all do rental housing inspection on voucher funded units?
We do rental housing inspections on a number of our units. The voucher status really doesn't play any role in our inspection determination. It is, yeah.
Great, so it's not sort of a hindrance, meaning you all will do a rental housing inspection even if it's a voucher funded unit.
That's correct, because they still have to get a license to be the landlord. And before you can rent, you have to pass inspection. That is one of the reforms that we put in place a couple of years ago. So for one family, two family, multi-family, you got to get a license. And part of that requires you to pass like an inspection to ensure that there's carbon monoxide detectors, there's like clear path to egress, the plumbing fixtures work.
So how, let me ask you, how many rental housing inspectors do we have?
Yes, I'll give you that number in a second. For housing, we have 53 positions.
Okay.
And then we have 17 contractors. And then we have 8 supervisors.
Okay. So right now within the rental housing inspector, we have 53 positions total and 29 of those are vacant at the moment.
That's correct.
Okay. And I know the Post issued an investigation last week about conditions in voucher buildings. So I just wanted to get a sense of sort of what's happening there, since I know, since you all do inspections, you know, is it the number of vacancies there, or what are we seeing? Why are we seeing these sort of conditions in buildings where we have a number of voucher holders if you all are responsible for those inspections?
Very good question. The number of inspectors has no role or no correlation to the conditions that people live in, not by any stretch of the imagination.
Right.
What we do know is that for voucher units, they also have to pass, I believe, there's another agency, the agency that administers the vouchers. They have their own criteria as well. So they are sort of like layers of approval. When it comes to housing conditions in general, empirically, what we've noticed is that a small subset or a relatively small subset of landlords or properties contribute disproportionately to the violations. So roughly the city has about 168,000 units under management. And I think last year there was about 20,000, or so violations. They were concentrated. We know the top 15 worst landlords simply based off volume of violations. But people who live in housing conditions, I mean, that's something that we are concerned about, whether it's a voucher or non-voucher unit. And we want to continue to offer any support we can and any help, whether it's through the inspections, recognizing that ultimately we are not responsible for abatement. We devote some of our abatement dollars for repairs or fixing life safety issues. So if we do an inspection and a smoke detector is missing, and it's going to take the landlord a couple of days to get it, we are not going to tolerate it. We just buy one and put it in there. So that's been our approach to prioritize life safety abatements. And then when it comes to routine property maintenance, we offer incentives for landlords to come into compliance. Really, one of the incentives we have in place is called the Alternative Resolution Team, where basically if we cite a landlord today on a routine issue, we give them 60 days to come into compliance. If they come into compliance, we reduce their fines and we do re-inspection to confirm abatement, and we move on. For life safety issues, we give them 24 hours, if I'm correct, because of the severity of the issue and also to minimize any adverse impact for our residents. So that's been the framework that we've been operating under for a couple of years now.
Councilmember, I'm going to go another round, and that means I think you get another round if you want. You don't have to. Director, I don't recall your answer to the issue of that the union representative made about separations, the increase in separations.
I question those numbers, so I don't want to answer on a faulty premise.
So how am I going to get the answer?
We'll research and get back to you. You have my
So
commitment.
you'll follow up on Mr. Trump, we asked you in the pre-hearing questions, the Section 108 of the Department of Buildings Establishment Act required the city administrator to submit a business process and analysis and re-engineering assessment. Your answer was that it's been prepared and it's undergoing executive review. We also noted, this is question 36, Section 201 of the Department of Buildings Establishment Act requires the department to submit a strategic enforcement plan. And the answer was it's been prepared and it's undergoing executive review. So both of these are undergoing executive review. According to your written answer, they've been prepared. When did you give these to the executive?
I'll have to think of the date. I don't have it like handy.
Okay, well,
Chairman.
give me a rough time. And I don't want you to get back to me on this one. I want to know when you gave them to the executive.
Chairman, I don't remember.
Well, was it like last week, last month, or maybe last fall? When were they due? One year after the effective date of the law. So were you on time preparing them?
I have to check. What I can remember is that at least even for the, well, not at least, specifically for the strategic enforcement plan, we had a robust stakeholder engagement
Okay, but I'm not
to the
interested
fall.
in that.
No, this is why it's important, Chairman. You asked about timeline. So that's what I remember us doing last fall. So the exact time about when we submitted it to the executive, any sort of like edits, I'll have to look into it. I don't want to give you misleading or false information. You know that, Chairman. I have too much respect for you.
As I understand it, these plans were required 1 year after the effective date of the law. The law was applicable as of October 1st, but the law became effective sooner than that. Is it your testimony that the department, you blew off the deadline and you didn't prepare them on time?
We never blow off deadlines.
Okay, so then you prepared them on time. And then you gave them to the executive then. I'm kind of assuming you don't want to answer the question because it's going to make the executive look bad. That's my assumption. And you're welcome to correct me on that assumption. But I'm kind of assuming that the plans were prepared timely by you, and they've been sitting for months in the executive office of the mayor.
Chairman.
And this is, let's just be clear, one is a business process analysis and re-engineering assessment, which will give guidance both to your agency, but you prepared the plan, so you have the guidance, as well as guidance or inform the public and the committee. So let's just be clear here. I'm assuming that they were prepared on time by you, and they have been sitting for months in the executive office of the mayor, possibly on the desk of the mayor's chief of staff, who's also the deputy mayor for planning and economic development. Let's just be clear. I'm assuming they've been sitting there for months. That's not doing anybody how do I want to put this? It's not helpful or constructive.
Chairman, give me a
Plus,
second.
it's a violation
It's dark
of the
in
law.
here. I have to get the lights on.
Plus, it's a violation of the law. So do you have any sense of when the mayor's folks are going to release these plans?
I'll be following up to check on the status. I also don't want to create an impression that we've been sitting on plans or not submitting plans. So I respectfully ask for you to give me the opportunity to look into this again so that I can follow up with you, Chairman.
Well, I've just made a note. You'll get back to us on you'll get back to us on that. We just lost your video. Your answer to question 5, which was provide the name of each employee who was or is on administrative leave. You declined to give the names, but I won't press on that. You identified 2 employees who are currently on paid administrative leave. One is on paid administrative leave for misconduct. If there's an allegation of misconduct, why hasn't the employee been terminated?
Whenever there is an issue, step 1 for us is to investigate, and the outcome of the investigation informs the decision that we take.
Okay, how long does it take to investigate? Because the taxpayers have paid for 6 weeks of salary for no work while this is being investigated.
It depends on the case. Some investigations can get wrapped
Okay, but
up.
you know this case. So how
Chairman,
long does it take
I don't
to
know the
invest-
details of the case. Frankly, I don't. I don't even think from memory, I know who the name of the employee is. What I can assure you is the steps we take, investigate, follow the district personnel manual. But while we're doing the investigation, we put an employee on administrative leave. So
With
that's
pay.
yes.
What about the other position? Position title, administrator, brief description of why they are on administrative leave, paid administrative leave, performance and program assessment, date December 19th. So we're talking about over 2 months. How long is that going to continue?
It may take a few weeks. I don't have the specifics on when the investigation is going to be completed.
Well, this investigation, this is a performance and program assessment. It's not an investigation.
Oh, okay. Chairman, what question are you looking at?
Question 5.
Okay, thank you. Give me a second. You're talking about employee A?
Correct.
How long is it going to take?
You're doing some assessment here. I don't know what the assessment is. Kind of would like to know, but you're doing some assessment here. Does the employee even know what you're doing?
The assessment that we are doing should be complete before the end of March. That much I know.
Okay, so taxpayers are paying it takes December, January, February, March. It takes 3.5 months to figure this out.
These are protections in place.
Protections.
For
This
due
is not
process.
misconduct. This is not misconduct. This is you're assessing the program.
Yes.
That's your answer here. I'm assuming that you were truthful in that answer. So there's no due process here. I mean, there's no due process issue here. There's no misconduct issue. There's no, there's nothing more than just a program assessment. And that takes 3.5 months at the taxpayer's expense.
Yes,
The
Chairman,
employee
because
not working because you're, for some reason, you don't want him or her to be working while you're assessing what to do with that program.
yes, Chairman. And at the end
I
of
have
the
a
day,
problem. I have a problem with this. It just sounds
Okay.
like you could have assessed the program before you put the person on leave. And I don't understand why it takes 3.5 months to assess a program.
and things involving personnel, I'm duty bound, just like many employees, about what I can discuss publicly and what I cannot.
You're assessing a program. That's what you wrote here.
Yes, Chairman, but as program assessment, it's not just walking into a program with like a clipboard and saying, is this present, yes or no? We have to do program assessment, collect data, analyze data, talk to employees, in certain instances, bring in new employees. There's a lot that goes into it. So I'll respectfully.
I'm having a hard time here. I really am. You know, if I want to do some reorganization in my office, I actually kind of figure it out before I put the employee on administrative leave. And actually, probably if I'm doing some reorganization, I'm not going to put the employee on administrative leave. And in any event, it's kind of unfair to the employee, isn't it? Because he or she's just sitting at home waiting to find out what's going to happen. I'll move on. But I hope that I hope I'm making some sense here to you.
Yes, I get your broader point, Chairman.
Question 11, we asked you about memoranda of understanding MOUs. I did not see an MOU with the Office of the Attorney General for vacant property enforcement. Why?
Are you talking about the idea we discussed when Carl Racine was the Attorney General?
Correct.
We've been working with them in this fiscal year without necessarily an MOU, so or MOA, which would be more appropriate. So, I mean, there's a new Attorney General, and we would like to codify our working relationships and service level through an MOA. That work will continue. In the meantime, it doesn't stop us from cooperating.
Well, my recollection was that an MOA was discussed because it would enable the Attorney General to get better access to information or more reliable information. You were in the meeting. You didn't balk at the idea of an agreement between the two agencies with the Attorney General picking up enforcement, like going to court against some of these vacant property owners, and yet it hasn't happened.
Yeah, it's a two-way street. We also have expectations. We also have what we'd like to see from the Office of Attorney General. So if we make a referral, we want a date certain where we'll get an answer so that we don't end up with situations where residents are saying, take more enforcement actions. And we are saying, no, we have to depend on the Attorney General for that. So those things have to be sorted out. There is a completely new leadership at the Office of Attorney General. We are still working with them. We have to understand what they would also like to see in any type of agreement. We also have to communicate what we want to see, regardless of conversations we have with the previous Attorney General. So if you're asking, are we going to enter into a memorandum of agreement with the Attorney General office, we are very interested in pursuing something that is fair, supports the agency, and also reflects the direction that both agencies are headed in.
Let me just, so that it's clear in the record, this was a discussion with you and me and the Attorney General, like maybe a year ago, long before there was turnover in the Attorney General's office. So I can appreciate that talking about it today as if it happened today. Yeah, new Attorney General got to figure things out, but this was actually like a year ago. But I'm over my time. Councilmember Lewis George.
Thank you. Director, I want to follow up with some of the witnesses who came to testify today from Ward 4. Abel and me spoke about sort of the kitchen range hoods violate and no ventilation, and sort of something about sort of revising the code there. Do you have a sort of understanding of that issue? And is that something that you all think should be considered?
There are lots of ideas that we think is worthy of consideration. And that goes to the Construction Codes Board, not DOB. DOB provides administrative support. So I would encourage the resident to channel their energies that way. And that's sort of like the process in place so that when it gets to public comment, people can also express their views on a particular thing. What I would note is that we follow or we take model codes and adopt them or tinker with them locally. The benefit of following local codes is that it makes it a little bit more easier to recruit people who are certified or understand certain codes. It also helps in managing risk of the built environment because it's based off like best practices. So ideas that we think are DC specific or ideas that don't go through that rigor can leave much to be desired. But on the surface, based on what I heard from the witness and what I also understand about codes in general, I think the best path forward is to go to the construction codes boards while we study the issue and see how it will make sense for the DC environment.
Okay, thank you for that. Darlene Jackson testified at Ward 4 resident about DOB failing to hold a negligent contractor to standards. And she also had some concerning information regarding the fact that she had reached out to DOB and they said that, who was it? That there hadn't been an order issued as of yet. And then an order was issued back in October of 2022. Can you speak to why she was informed that an order hadn't been issued, but then it was actually issued back in October of 2022, and sort of what is being done to hold the contractor accountable from DOB's end?
Darlene Jackson, I remember her because I think I've actually met her before when we were doing a lot of stuff in person. What I thought I heard her towards the end was that she received a final order from OAH, I think yesterday. So
Correct.
DOB doesn't issue final orders.
Oh, no, I know that one piece. She's saying that she was told by you all that there had been no order yet. And that's why you all hadn't done anything, except she found out that there was an order that had been issued in October of 2022.
Yeah, I don't know what order she's talking about and how different that is from the order she got yesterday. So that's something that I can look into. In this forum, usually is what somebody said, there's what somebody else has said, and I don't have the opportunity to research the facts. But ultimately, the contractor issue is in the jurisdiction of our sister agency, Department of Licensing and Consumer Protection, not Department of Buildings. So I'll have my staff follow up to see.
I'm having follow up with Darlene.
Yes.
And let us know. Okay, thank you. Cynthia Davis testified, executive director from, she's one of the owners of Kings and Queens Child Center in Ward 4, about homeowner association bylaws and restrictive building codes that unfairly limit home-based childcare centers. And sort of apparently DOB determines during the business licensing process whether a home-based childcare center is allowed under HOA bylaws or other real estate covenants. I know the council is working on legislation around this. Do you have any sort of input on sort of changing those restrictions?
I don't have a personal opinion on this matter. What I do think is that through the process of hearing people who are advocating for a change and people who are opposed to the change, we can find out what is actually maybe necessary. So if anything at all, I can say that promoting child development and child education, that's something that just makes sense.
Okay.
How to go about it based on building codes, zoning regulations, proposing changes, I'll rather rest on the process so that it can lead to desired outcomes.
Okay. I appreciate that. I know your legislative team will look into it and maybe have suggestions as that legislation moves along.
Yes.
There's a number of people testified sort of about greener government buildings and sort of Vanessa Bertelli and Doug Singlin and others have testified. And as you know, this is an area that I'm advocating around as well for greener government buildings. Sort of what is your office doing to ensure that we are making all necessary steps as it relates to the green government buildings and our ability to move faster in the future.
There are a few things that my office does, and there are a few things that the Construction Codes Board also does. We provide administrative support for code adoption and changes, and that would continue. On the implementation side, whether it's through the permitting process or the inspection process, we ensure that there is compliance, and when there's not compliance, we provide a pathway or a ramp for compliance. We also monitor changes that are happening nationwide with respect to green energy and climate change, so that we can think of like operational processes that will support moving the district closer to a greener future. We also provide training to the industry. We also provide training materials on the website to increase education and awareness of our greening practices. And I know this is an area where you have an interest. So we are certainly eager and open to ideas about how we can collaborate and ensure that the district's future remains green and bright.
Okay. I appreciate that. Who's the lead in your office on that?
We have multiple people who play a role in sort of like, the green initiatives. We have, for example, our account managers who go to ANC meetings and talk about things. We have our plan reviewers. We also have our inspectors. And then we have some employees who serve on the Construction Code Board on a volunteer basis. So there's not like one person who's the green. We've made green part of our culture. That's why everybody plays a role.
Okay. Well, we will reach out to the various individuals in that regard. And then the last part is Office of Strategic Code and Enforcement, which is, I guess, a newer part of your organizational chart. How is the Office of Strategic Code and Enforcement sort of implementing new strategies to deal with our issues in the district?
There are a few that I can speak to, starting with one, hiring somebody to lead that office, the strategic code enforcement, and we are proud to have been able to fill that role. The public health analyst is also another vacancy that we filled. Another vacancy that we've filled, but it's not officially reflected on the books yet, because that person will move into that position later this month, is the Chief Residential Inspection Official. But globally, when it comes to strategic enforcement, we are already implementing some of the steps that our community members have asked us for, and the ideas we received from the stakeholder engagement. So, for example, we have a list of actors that are subject to enhanced scrutiny, whether they are getting a permit or license. We also have a list of housing providers that are subject to more frequent inspections and tracking of abatement. We are also working on a broader approach to enforcement, in that we'll be looking at, for example, repeat offenders, and making referrals to like the OAG, and also making referrals within the agency, so that if somebody is on the targeted list and they try to conduct a transaction with us from a vacant building perspective, we'll make the appropriate linkages that, hey, you know what? This person has racked up this record. Now they want to get an exemption. Let's have a conversation with them about money they owe and steps they are taking to bring properties to compliance. So it is much more coordinated. And then once
I know my time, yeah, sorry, my time is ending, and I have to go to the DHS hearing right now. But I just want to a few things. We'll be following up regarding a number of issues that we've already talked about, flagging that 6109 3rd Street Northeast and 1400 Hamilton Street Northwest. If you can get back to the chairman's office and his staff regarding the diagnosis for those properties and why they've been allowed to be vacant and blighted for so long. And then I'm going to ask you to revisit 3700 14th Street Northwest, which I've already flagged to the Deputy Mayor of Public Safety and the Mayor, as well as properties where I would like to see abatement happen immediately because of the urgent public safety issues. And my Ward 1 colleague, Brianna Doe, joins me in that request along with both adjoining ANC commissioners. So hopefully you can make that happen. Thank you for your time. Thank you, Chairman.
Thank you.
Thank you, Councilmember. Director, the nuisance abatement fund. I believe fines are a funding source.
Maybe in a roundabout way, because fines go to the city, and then the city decides how much to allocate. Did I lose you?
No, I'm here.
All right. Liens go into the nuisance abatement fund as well.
Does all the money that should go into it, or does some of it end up going to the general fund because it ends up going through Office of Administrative Hearings or some other appeals process?
Yeah, that I'm not 100% sure about. I'll have to have my AFO advise.
All right, so you'll get back to me on that.
Yeah.
The Department of Buildings recently changed the process for issuing a certificate of occupancy for new apartment buildings that may require additional inspections after the base building core and shell certificate of completion has been issued. Previously, housing providers were able to secure certificates of occupancy within days of issuance of the certificate of completion. These new double inspections adds an uncertain additional time period for delivering new housing units for occupancy, which in turn adds uncertainty and typically at least 30 days to the time it used to take, adding at least 30 days to the time it used to take to receive a certificate of occupancy. This makes it much harder to secure tenants because the developers cannot tell the tenants when they can move in. It also adds carrying costs to the developer while they're sitting there, just sitting on the building, waiting for the certificate of occupancy. What's going on that the department has added significant time and uncertainty to the development process of housing with this new C of O process?
I actually challenge that premise that there are double inspections. What I do know is that the certificate of occupancy process has been streamlined because of advancements we've made in technology, systems, and process. Today.
Yeah, but I don't consider it streamlined if you've added 30 to, in fact, I met with some developers who are involved with providing affordable housing, and they said even as much as 90 days.
That assumes they are correct. And without seeing the facts, I cannot go along with that assumption.
Well, you have the ability to go and look in your own little C of O department and find out how long between application and issuance of a C of O, right? One has to apply for a C of O. So
actually, I know, and that's what I was going to share. There are two types of CFO applications, and each has a service level guarantee. If it's just a change of ownership, nothing else.
No, we're not talking about that. We're talking about
that's 1 day.
We're talking about new
everything else, new construction,
of multifamily apartment buildings.
7 days, Chairman. 7 business days is what we guarantee, provided we get a complete and thorough application. One of the things
Do you want me to take that answer to these developers? Because I think they'll throw me out of the room. They're not
No,
lying to me.
I'll go with you so that we look on a fact by fact basis, and areas where we drop the ball, I'll own up to it. But way too often, I hear these sort of like allegations. And then when I invest time into looking into it, they did something wrong.
Okay, well, this is what they're telling me. Previously, housing providers were able to secure certificates of occupancy within days of issuance of the certificate of completion. The new double inspections have added an uncertain additional time period for delivering new housing units for occupancy. That's what they're telling me. So I assume you'll look into it.
Certainly, and I'll reach out to you so that I can get some addresses so that we can unpack really what is happening there. And if there's an opportunity for improvement, certainly we'll be all over it. And if there's an opportunity to educate people, we'll do so.
You'll follow up with me to get addresses. There was testimony. Our members are also reporting problems communicating with agency staff, securing interpretation services, and not receiving responses to calls and emails. Although these challenges have been around since before the restructuring of DCRA, as a public agency, Department of Buildings must ensure compliance with the DC Language Access Act of 2004 and should be able to provide in-person support to those who need assistance with their online application process. And I seem to recall that in the past, the DCRA was cited as one of the poorer performers with regard to compliance with the Language Access Act. What is your response?
When somebody needs language access, there are mechanisms in place for us to figure out the appropriate language translation interpretation service that is needed. We've worked really hard to make our content and our website available in multiple languages. We've partnered with the Office of a Chief Technology Officer. We've done some work in improving language line access. So I would welcome an opportunity to understand those specifics and see what we can do better, assuming there's something that
well, this was testimony from, I would say, a half dozen witnesses today.
Yeah, Chairman, that's what they said. I have to verify and validate and come up with measures if in fact there is a problem. I don't know. But when people testify, it's valuable input for us. So we will take advantage of that opportunity to see what we can do better.
Isn't there an agency, is it Office of Human Rights that looks at compliance with the Language Access Act? Do you know?
Yes. HR.
So they would have done a report that would rank your agency with other agencies in terms of compliance.
Yes, they do.
Okay, so you'll get back to me with that information?
As far as how we rank compared to other agencies?
Yeah, what the Office of Human Rights is saying about you.
Sure.
Unless you were just given the answer.
No. That's not it.
There were two witnesses who testified rather critically of the new neighbor notification letter. And I got to say that going from 3 pages to 1 seems like a good deal, but when I looked at the old notification form, it really seemed more understandable and complete. Are you willing to take another look at that?
I know my staff had dealt extensively with some of the people who testified. So am I going to take a look at neighbor notification? Absolutely. But what I'm sure I wouldn't do is unwind progress. And what I'm sure I wouldn't do is create unintended consequences. There's a benefit with simplifying forms. And I recall one of the changes that we made, and it was for good reason. Now, to see the construction plans that are part of the neighbor notification process homeowners don't have to rely exclusively on the developer. They can come to our website, go to e-records, and have access to the plans. So if people have suggestions on how to improve the neighbor notification, I'm all ears. We want to hear and see how we can improve, because that's part of our value. Continuous.
Sure, and I wouldn't disagree with you on that. In fact, I agree with you on that. It's the last sentence of the new form. You can monitor the status of this permit submission. Copies of the proposed plans are available, and there are links to both. And I'm not sure that that's the same on the old form, but the old form has an explanation of what this is about, which is missing from the new form. It has
maybe, Chairman, this would help. On our website, we explain in detail and in layman language what neighbor notification is about, when it is required, because people used to think it's a tool that they can use to slow down development. And we say, no, that's not the purpose. It's to ensure that you are sufficiently aware and can raise technical objections that we would evaluate. It also lays out the process, required posting, required reading notice, access to adjoining properties, and if you fail to provide access, what that means. So a lot of work has gone into making the neighbor notification process simpler, more streamlined.
Yeah, no, I understand that, but I'm not sure that that was as successful as you were suggesting. For instance, the old form had on it, requested access to my property is granted with conditions, or denied. That doesn't exist on the new form. So you don't have anything in writing that indicates that the neighbor is agreeing to access. I think that's kind of useful to have.
Yeah, I actually have a form in front of me that I can share my screen that says request for access form if required, because there are certain scenarios where access is required and there are certain scenarios where access is not required. So maybe people are conflating the two and expecting things that is not required in all instances. But I get your broader point.
Yeah, I see that here on the new form. So that makes it like a two-step process. Instead of one notification letter, now there's this notification letter, and then you have to go to another document, find another document if access is an issue. I can't say that I think this one-page letter is an improvement. And there was quite a bit of criticism of it. You heard the two witnesses. They're ones who are actually affected. So they care about this more than a hypothetical discussion. And they were quite clear they thought the old letter was better.
I hear you. And you have my commitment. I'll look into it. I'll be remiss if I don't mention that we handle thousands of neighbor notifications over years. And most people are appreciative of the simplified form. However, we will look and see what else we can do better. I don't want to sit there and say we have everything figured out. No. The commitment is we'll look into it and see what we can do. And
I know you do thousands of these neighborhood notification, because this is exactly what I fell into before. What we're talking about here is notification where there is, I'm trying to remember what the phrase is. Substantial. I wrote it down. I don't see where I wrote it down. Where there's a substantial construction that could damage the property. It's sort of in a class by itself. I'll move on. The last question I have concerns the Construction Codes Coordinating Board. So there are 3 government members of this 5-member board?
A little bit more than 3. You have representatives from DOE, fire department as well. So of the 13 member board, they are DC government employees from other agencies as well.
Okay. And 3 of them are from your agency?
That's correct.
Okay. Presumably, they consult, maybe even consult with you, maybe even consult with the EOM, Executive Office of the Mayor, before they go into a meeting and decide how to vote on.
No. They decide how they vote. They are independent of the agency.
Well, you heard the testimony that the city has a policy of moving to net zero carbon emissions. Electrification is what we have to do. And the Construction Codes Coordinating Board was unable to make a decision on that last fall.
Yes, and that was because at that time, PEPCO had not confirmed whether the grid can support the electrification needs. So that was what the hoopla was all about, is whether PEPCO can confirm that, yes, the grid can handle all of this load. And later on, PEPCO provided that confirmation. But it was after the vote. And I think one of the
when the issue comes up again, which I think is going to be in the next month, within the next month, there should not be an issue.
As far as doubt about the ability for the grid to handle the load, I think that issue is being resolved. But anything else that will be up in the air. I'm not fully aware of any outstanding issues beyond the ability of the grid. Yeah, what I do know is that there's been robust stakeholder engagement and concerns about what this means for multifamily property owners. AOBA has spoken on this issue. I've gotten letters, even though I don't vote on the Construction Codes Board. I know my staff have gotten a bunch of letters. And we also know that electrification is something that is happening. We also know that we have to move towards net zero. But I don't want to sit here and speak about certain things that I'm not aware of. I'm not aware of a lot of issues at this point.
Well, is it true that if the board doesn't adopt this new standard electrification standard, that it will be 3 years before there's another chance?
Not entirely. I understand where that sentiment is coming from, because we move on 3-year code adoption cycles. But there's still time on the clock for the board to adopt the electrification proposal if they deem it as the direction they want to go, recognizing that failure to act by the end of 2026 means the legislation and the framework in the legislation, and I believe Appendix M or Z is what will go into effect.
Well, the council, I believe every member of the council signed on to a letter. Could be wrong, but I think it was every member of the council signed on to a letter urging this change in the construction codes. I'll leave it there. Thank you, Mr. Chapa, for your testimony. And I'm going to just remind folks that the Committee of the Whole will have its next performance oversight hearing on Monday with the Office of Budget and Planning, other post-employment benefits program, University of the District of Columbia, and Commission on the Arts. And then we have hearings on March 1st and March 3rd on education agencies, public witnesses on March 1st. I want to thank all the witnesses who testified today. And the time is 6:58 PM and this hearing is adjourned.
Thank you, Chairman, for your leadership.
Thank you.